Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Bills brought from the House of Representatives on the supplemental order paper. The Miscellaneous Provisions Judicial and Legal Service Bill 2024 in the name of the Attorney General. The Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2024 in the name of the Attorney General. The National Musical
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend in accordance with Standing Order 62-1B, I beg to move the next stage of the Miscellaneous Provisions Judicial and Legal Service Bill 2024 and the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2024 be taken later in the proceedings. Thank you.
Honourable Senators, the question is that the next stage of the Miscellaneous Provisions Judicial and Legal Service Bill 2024 and the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2024 be taken later in the proceedings. Those in favour say aye. Those against say no. I think the ayes have it. The next stage of the Miscellaneous Provisions Judicial and Legal Service Bill 2024 and the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2024 will be taken later in the proceedings.
On the supplemental order paper, the National Musical Instrument Bill 2024 in the name of the Minister of Tourism, Culture and the Arts.
Minister of Tourism, Culture and the Arts.
Mr. President, in accordance with Standing Order 62-1B, I beg to move that the next stage of the bill be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the National Musical Instrument Bill 2024 be taken later in the proceedings. Those in favour say aye. Those against say no. I think the ayes have it. The next stage of the National Musical Instrument Bill 2024 will be taken later in the proceedings. Honourable Senators, permit me to advise you that the Edinburgh Government Primary School are in the public gallery today to observe today's proceedings. Please join me in welcoming them.
Urgent questions.
Senator Dr. Paul Richards.
Thank you, Mr. President. Good afternoon, colleagues. To the Minister of National Security, given the Prime Minister's statement on the audit of the Strategic Services Agency, SSA's operation, can the Minister indicate what additional oversight mechanisms have been initiated to prevent the recurrence of this type of breach in the national security apparatus?
Minister of National Security.
Thank you very warmly, Mr. President. Mr. President, when the Prime Minister of a nation, this nation in particular, issues a statement as he did only yesterday, and as comprehensively and illuminatingly as he did, there is precious more useful that his minister can add on the matter raised by my friend Senator Richards. Suffice it to say that since the 3rd of March 2024, the director of the SSA reports bi-monthly to the chair of the National Security Council, attends meetings as often as requested so to do by the National Security Council, and meets monthly with the Minister of National Security in accordance with Section 4.5 of the Strategic Services Act of Trinidad and Tobago. Altogether, Mr. President, oversight remains with the National Security Council. Thank you.
Senator Dr. Paul Richards.
Thank you, Mr. President. Through you, can the Minister indicate how, despite these meetings and despite the Minister's indications of these oversight mechanisms, how the types of breaches that the Prime Minister outlined could actually have occurred, compromising the country's top intelligence agency?
Minister.
Mr. President, in the way of the world, things happen. As one writer previously wrote, there is no art to find the mind's construction in the face. What I can say is that once these matters came to the attention of the National Security Council, when they did, we acted promptly in the national interest, and the records will show what we had done.
Senator.
Thank you, Mr. President. Can the Minister indicate how promptly the information came to the National Security Council, since given the document that was released yesterday, I presume the one I received was accurate, there had been an exponential increase in the purchase of ammunition from 2020 through 21, almost doubling in 2022, seemingly without the knowledge of the National Security Council by the SSA.
Minister.
I don't want to chance a date, but it was a few months ago when information came to the National Security Council. The Prime Minister addressed this country on that some time ago and did so even more comprehensively yesterday. And as soon as that information came to hand, and of course the government and through the National Security Council cannot act precipitously or whimsically, the government acted responsibly and promptly in the widest and deepest national interest. Thank you very much.
Senator Dr. Paul Richards.
Thank you. Finally, on this question, Mr. President, can the Minister indicate if the government, given the chronology that we have seen in the document of seeming...
the order people.
Oh, sorry. Question number 2 to the Minister of National Security. Given the Prime Minister's recent statements on the Strategic Services Agency, SSA's operation, can the Minister indicate what urgent measures the government intends to pursue to prevent any potential compromise of national security agencies that routinely interface with the SSA?
Minister.
As the Prime Minister indicated yesterday, a full and thorough audit of all aspects of the operations of the SSA has been put in place. It is ongoing. And the Prime Minister's statement yesterday was punctuated by the assurance and on the facts that while this audit is taking place, or these audits, the business, the core business of the SSA continued apace. And I am in a position as Minister of National Security to say so. In addition to that, a draft National Security Interagency Concept of Operations has been drafted, and it is now for revision by the National Interagency Committee for review and assessment, and then hence a subsequent submission to the National Security Council for its consideration. Thank you.
Can the Minister indicate if the government, given part of the SSA's remit and responsibility is supplying analysis data to other security agencies and the National Security Council, and they have also supplied documents to the Parliament's Joint Select Committee on National Security, if the government has examined previous reports from the SSA to identify if those reports are compromised and or misleading?
Minister.
As I indicated, and the Prime Minister previously did, there are audits taking place into every aspect of the operations and the work of the SSA, and I have no doubt matters such as that would be contemplated in those audits. Thank you, Mr. President.
Senator.
Next question. Thank you, Mr. President. Through you, to the Minister of National Security. Can the Minister indicate what strategies have been implemented to mitigate the potential carnage that can result from the 70,000 rounds of missing ammunition that was purchased by the SSA, potentially ending up in the hands of criminals?
Sir.
Every single round of ammunition that finds itself in unlawful hands with the prospects for misuse, abuse, poses a very serious threat. So obviously, given the Prime Minister's observations that 70,000 rounds of ammunition are yet unrecorded and unaccounted for, this obviously poses a grave and a very serious threat to the citizens and visitors of Trinidad and Tobago, and of course, to national security. And that's the reason why accountability in the business of firearms and ammunition, their movement, their use, is so critical. So, Mr. President, the police, as the Prime Minister indicated, is pursuing this particular matter meticulously and hopefully to a very successful finding or end. Thank you very much.
Senator.
One more. Can the Minister indicate if, because of what has been identified in this report presented by the Honourable Prime Minister in the other place, if there has been an examination of the possible infiltration of similar rogue elements in other national security agencies?
Minister.
For the moment, I confine myself to the statement of the Prime Minister yesterday, upon which the question is premised, and audits are underway, very thorough audits into every aspect of their operations, and certainly this matter and relevant matters will be pursued and will be taken into account.
Mr. President, I just wanted to ask the Honourable Minister. Yeah. To the Honourable Minister of National Security, in light of the alarming revelations that 70,000 rounds of ammunition purchased by the SSA are now unrecorded and unaccounted for, can the Minister indicate whether the government has sought the assistance from our foreign counterparts to aid their retrieval?
Minister.
Thank you very much, Mr. President. We have not done so as yet, purely because at this juncture, it has not been deemed to be necessary, since the sources of this failure in the controlled equipment and supplies inventory management at the SSA does not exceed the investigative and corrective expertise and capacity in Trinidad and Tobago, particularly as it resides in the Trinidad and Tobago Police Service. But for completion, in answer to my friend Senator Mark, we cooperate with our foreign partners, every one of them, and this cooperation transpires on an ongoing basis. I thank you, Mr. President.
Honourable Senators, the time for urgent questions has ended.
Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Mr. President, in accordance with Standing Order 77.3, I beg to move that the following bills be restored to the order people. In the fifth session, 2024-2025 of the 12th Parliament. 1. The Private Security Industry Bill 2022. 2. The Supplemental Police Amendment Bill 2022. And 3. The Sexual Offences Amendment Bill 2024.
Honourable Senators, the question is that in accordance with the Standing Order 77.3, the following bills be restored to the order paper in the fifth session 2024-2025 of the 12th Parliament. The Private Security Industry Bill 2022, the Supplemental Police Amendment Bill 2022, and the Sexual Offences Amendment Bill 2024. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, bills second reading.
Attorney General.
Thank you very much, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 4, Number 60, be now read a second time. Before I get into my substantive comments on the clauses of the bill, Mr. President, permit me to make a few prefatory remarks as I introduce this bill. Firstly, the decision of the Privy Council in the case of the Attorney General and Achille Charles, 2022 UKPC, page 31, was delivered on the 28th of July, 2022, and significantly followed shortly after the reasoning of the decision of this board, the same Privy Council, in Suraj and the Attorney General, 2022 UKPC, page 26. And Achille Charles proceeded to apply the reasoning of the Suraj decision with respect to the issue that this bill addresses today, that is to say, the entitlement of citizens of this country to bail. Secondly, Mr. President, and of course, I will discuss the Achille Charles decision in some detail, but I consider it important to state from the outset two significant points which emerge from that decision. On the first principal issue which was before the board, whether the bail provision in the Act then being challenged, the 1994 Bail Act, was an existing law under Section 6 of our Constitution. In holding that it was not an existing law, the board of the Privy Council underscored a very important common law position dating back to 1898, and the decision of the Queen and Spilsbury. And I quote from the Privy Council decision in Achille Charles in that regard. This court has, independently of statute, by the common law, jurisdiction to admit to bail. The court or any judge on vacation, not being restrained or affected by statute, in the plenitude of that power which they enjoy at common law, may, in their discretion, admit persons to bail in all cases whatsoever. The point emerging here, which has been emphasized by Achille Charles, and which we salute and pay respect to, Mr. President, is the proper respect which must be had to the judicial discretion which this bill respects, and by the provisions of this bill is asking this House to legislate to provide guidelines for. And the decision in Achille Charles, Mr. President, endorsed and accepted the Court of Appeal reasoning of this jurisdiction. At paragraph 37 of the judgment, the Privy Council stated, "The Board therefore agrees with the Court of Appeal that at common law, there was no existing law prohibiting the grant of bail in murder cases, either pre or post-committal." And I emphasize the point because there are some of us in this society who continue to think that the only judges who are capable of applying law are the members of the Privy Council. I emphasize the point that the significant decision in Achille Charles, for all its reasoned decision, the Board accepted, endorsed, and embraced the rationale and the reasoning of the Court of Appeal of the Supreme Court of Trinidad and Tobago. On the second principal issue, with reference to which the Board in Achille Charles had to apply Section 13 of our Constitution, the Board reminded itself of the now refined and applicable proportionality test as defined in Suraj. Mr. President, in examining and discussing this bill today, it is useful to remind ourselves as parliamentarians, that is to say, members of this honorable chamber, of the powerful reasoning of the Board at paragraph 56 of the Achille Charles decision, and I refer in that regard to paragraph 56, subparagraphs 1, 2, 3, and 4 of that decision, which state, and I quote, 1. The onus is on the complainant to show that the measure is not reasonably justifiable, that is to say, the measure proposed by the draft legislation, the bill. This places a heavy burden on the complainant, and a court will be slow to conclude that this has been shown. Secondly, Achille Charles states, the test of proportionality appropriate under Section 13(1) involves a lesser intensity of review by the courts and a wider margin of appreciation or discretion for the state acting by legislation passed by a supermajority in both chambers of Parliament. Thirdly, in relation to such legislation, Parliament will have identified in a particular clear and forceful way its opinion as to where the public interest lies. I pause there to emphasize and to repeat, because we are the Parliament of Trinidad and Tobago. We are the Senate chamber of the bicameral Parliament of this chamber and the other place. In relation to such legislation, Parliament will have identified in a particularly clear and forceful way its opinion as to where the public interest lies. In a democratic state, the courts must be expected to be especially respectful of the choice made by Parliament to pass legislation in that form, and slow to substitute their own view of the necessity for and proportionality of the measure taken. Fourthly, although the court has to make the ultimate judgment whether the proviso in Section 13(1) has been satisfied or not, it is obliged in doing so to give especially great weight to the judgment of Parliament regarding the importance of the public interest which is sought to be promoted by the measure in question. I've read from 4 paragraphs of the judgment of Achille Charles, and in those 4 paragraphs, twice the Privy Council repeats its focus on the role of Parliament to determine what is in the public interest of the democratic country of Trinidad and Tobago. And what we are here about today, Mr. President, is the public interest of securing the safety of our citizens from crime, and in particular, crime constantly being committed by repeat offenders who are given bail and come back out to continue to perpetrate their dastardly deeds on an unsuspecting innocent citizen. And the point which I wish to emphasize, emerging from Achille Charles and relying on the Suraj decision and applicable now to this bill, applying the reason of the Privy Council, which I have just quoted from, is that it is for this Parliament, Mr. President, members of this august chamber, in our consideration of this bill, and all that I will place before this chamber today, to apply the proportionality test, framed in a way which gives especially strong judgment to our decision in Parliament regarding the imperative nature of that public interest. To identify in a particularly clear and forceful way its opinion, Parliament's opinion, as to where the public interest lies. So that it is for us today, Mr. President, as responsible senators, to accept our mandate conferred by Section 40 and 53 of our Constitution as legislators in these challenging times to pass constitutionally compliant legislation, whether by simple or supermajority, tailored to protect and serve the public interest. Reminded of the injunction of the Privy Council that, and I quote, in a democratic state, the courts must be expected to be respectful, especially respectful of the choice made by us, I interpose, in Parliament to pass legislation in that form, and I interpose, by a balanced and appropriate exercise of our discretion and respecting the decision of the judiciary dating back to 1898, the courts must be slow to substitute their view of the necessity for and proportionality of the measure taken. Mr. President, the passing of this bill today, which this government puts before this chamber, is the point of opportunity for us as responsible members of legislature to have confidence in ourselves, to do our job, to pass this amendment bill in the public interest, and equally to have the confidence in our judges exercising their ancient 1898 discretionary jurisdiction to respect and to interpret this amending legislation with appropriate balance, as the Privy Council has reminded us in Achille Charles. Accordingly, Mr. President, by the presentation of this bill for debate and passage today, it is the intention of this government, one, for this chamber, constituted as it has been under the mandate of the Constitution, Section 53, to make laws for the peace, order, and good government of Trinidad and Tobago, and by the first amendments to the Bail Act, and I stress that, the first amendments to the Bail Act brought before this Parliament since the 28th of July 2022 decision to pass this bill in recognition and affirmation of that Achille Charles decision. And that decision has affirmed the confidence of the Privy Council in the correctness of our judges of Trinidad and Tobago, our Court of Appeal, and the discretion of our judges to exercise their ancient judicial discretion to grant or refuse bail in accordance with well-established common law principles. So that the guidelines which by this bill we ask Parliament to pass into law, serving the public interest, are guidelines to assist our judiciary in serving that public interest, to get the balance right in the conditions and the exercise of their discretion as to when or when not they will grant bail on applications brought before the courts for that bail to be granted. It is the intention of this government, Mr. President, to introduce, therefore, legislative guidelines with respect to to the grant or refusal of that bail for serious offenses, unless the accused can prove to the satisfaction of the court that his continuation in remand is not justified, because he, as the applicant before the courts, can show sufficient cause or exceptional circumstances why he should be granted bail. Otherwise, the courts will say, no, you must remain there until your trial comes up. Thirdly, as part of this government's continuing commitment to make laws for the peace, order, and good government of Trinidad and Tobago citizens, we wish to introduce, and we have been over the last several years, Mr. President, and this piece of legislation, this bill, is but part of that tapestry which this government has been putting onto our law books to introduce a more expeditious criminal justice system to facilitate expeditious judgment and justice. And in that regard, I cite as one of the more recent examples the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, a JIPA, which has accomplished, among other things, the abolition of preliminary inquiries, which have been a blot on due process and respect for our fundamental rights and freedoms. There are cases in our courts today which are still in year 13 of the preliminary inquiry process. And a JIPA has been introduced by this government out of respect for the rights of accused persons who are in remand awaiting trial to stop that insufferable delay in the delivery of justice and give them their right to a fair trial in an expeditious period of time. And in that period of time, if they can satisfy the judiciary that there are exceptional reasons why they should be granted bail and put back out into society, so be it. The court will have exercised its jurisdiction. But if they are not able to satisfy the court that exceptional reasons exist why they should be released back onto the society while they await trial, they shall remain on remand. Mr. President, the Achille Charles decision is of major significance since it was settled on the 20th of July. Prior to that decision, Mr. President, the offense of murder was one of the non-bailable offenses listed in Part 1 of the first schedule to the Act. And we've seen that the Privy Council has said that that non-bailable aspect of murder was contrary to the common law and therefore unconstitutional. So as a result, the Privy Council declared that Section 5.1 of that 1994 Act was unconstitutional. And the Privy Council declared Section 5.1 to be unconstitutional as being disproportionate because what it introduced in 5.1 was a blanket approach. And one of the examples which is given in the Privy Council decision of Achille Charles, one of the cases that they considered in arriving at the decision to find that bail was not, the denial of bail was not constitutional, is a very good practical example. You can have two people on trial for murder. One who is an accused terrorist who has just blown up 100 people. That person is in remand awaiting trial for a serious offense and applies for bail. Another person is also on remand for bail because he or she is a partner of someone who was terminally ill and participated in what is known as a mercy killing. So that person is now also charged with murder, and that person is also on remand. The blanket approach to deny the judiciary the exercise of jurisdiction to be able to say in the case of the person on trial for a mercy killing that you are not allowed bail because no bail must be allowed for anyone charged with murder is what the Privy Council found to be disproportionate, because you cannot apply that blanket approach to everyone charged with the bail. The alleged terrorist justifiably should remain in jail because of the fears of what he may do if he's released back onto the society. But someone who, out of compassion, living for years with her partner or his partner, and unable to deal with the agony of seeing that person continue to suffer, bedridden for years, does what the law refers to as a mercy killing. And are you going to say that that person must remain in jail for the 5 years it takes for the trial to come around? The Privy Council said no, that is wrong, that is disproportionate. That was one of the examples that was looked at by the Privy Council in the Achille Charles decision. So the Privy Council has told us, Mr. President, that the objectives which are being achieved must be achieved by less intrusive means. And the board explained that instead of removing the court's discretion altogether, conditions in relation to that 1994 Act could have been introduced by Parliament to guide the court's discretion. And that is exactly what we are asking the Parliament today to do, to introduce, respecting and recognizing the decision of Achille Charles that bail is, the denial of bail, the blanket approach is unlawful. We are asking this court today to pass a bill which will introduce conditions by which the judicial discretion dating back to 1898 can be properly exercised in balanced terms, in other words, in proportionate terms. Mr. President, we accept that the effect of the board's ruling is that persons now have a right to apply for bail, but not a right to be granted bail. You have the right to apply to the judge, and you must now satisfy the judge if we, in our legitimate, proper exercise of our legislative authority today, pass this bill into law. You have the right to apply for bail, but the judge will determine on the particular facts and circumstances of your case as an applicant whether you have an entitlement to be granted that bail or not. Mr. President, in preparation for presenting this bill before this House today, I asked the Law Reform Commission, a very resourceful part of the Ministry of the Office of Attorney General and Ministry of Legal Affairs, to consider and advise upon the specific issues and any other pertinent issues to the reform of the Bail Act. And the Commission did a number of things. One, they examined the bail legislation in other Commonwealth countries to take guidance from those other jurisdictions, including England, Australia, Canada, South Africa, and New Zealand. Secondly, they gave due consideration to the constitutional rights and freedoms of an accused under sections 4 and 5 of our Constitution, and to the relevant jurisprudence which provides guidelines on how those rights are to be treated and respected. Thirdly, they considered recent legislative developments which have had significant impact on the granting of bail, particularly in relation to the offense of murder and other serious offenses. And fourthly, they considered the crime situation in Trinidad and Tobago, particularly the commission of serious offenses, including murder, gang, and firearm-related offenses within the last 5 years. And in consequence, Mr. President, the Commission recommended that the Bail Act be amended, 1, to give to masters of the Supreme Court the jurisdiction to grant bail for the offense of murder, where before masters had no such jurisdiction. 2, to provide that a person charged with the offense of murder may be granted bail if he can show that there exist exceptional circumstances why she or he may be granted bail. And this assists and gives support and guidelines for the exercise of judicial discretion, applying the principles of Achille Charles, recommending that instead of the absolute ban imposed by the legislation of 1994, Parliament could have imposed conditions on the exercise of the court's discretion. I've already dealt with that. Thirdly, they recommended the repeal of Part 2 of the first schedule of the Bail Act and to substitute a new Part 2 setting out the serious offenses which will attract enhanced bail restrictions. Fourthly, they require a judge or master, and this is important, Mr. President. The recommendations of the Law Commission were to require, by parliamentary provision, which we will pass today, it is my hope, require a judge or master to give to the accused and the prosecution reasons for their decision to grant or refuse bail or to impose conditions on that bail in criminal proceedings originating in the High Court. There can be no more transparent, fair process for anyone if a decision is made affecting your rights to be told, these are the reasons why I have arrived at this decision. Because it gives you the opportunity on the existing and undoubted right of appeal, which is the fifth recommendation of the Law Commission. It gives you, as the accused person, applying for bail and having had your bail refused, you have the reasons, you can go to the Court of Appeal and you could point to one or more of the reasons to say that reason is erroneous in point of law or erroneous in point of fact in relation to me, the person who made the application. That is what is known as due process and the protection of the law. So the recommendations of the Law Commission to me, put forward now in the bill before this House, provide reasons, judges and masters, and give to the accused and the prosecution the right to go to the Court of Appeal to challenge that decision. And the sixth recommendation of the Law Commission, Mr. President, was to introduce enhanced bail restrictions guiding that judicial discretion with respect to persons charged with specified serious offenses or where a firearm or prohibited weapon or imitation firearm was used or in the possession of the accused or any other person involved in the commission of the offense. Mr. President, consideration has also been given to the following recent developments which have had significant impact on the granting of bail, particularly in relation to the offense of murder and other serious offenses. The Commission took note of the fact that there have been a number of different attempts in this country to pass bail legislation which have expired either by effluxion of time or by the arrival of the sunset clause. All of that was considered in the round as they sat to the task of making recommendations, which recommendations were then taken to the Chief Parliamentary Counsel, who has the responsibility in the Office of the Attorney General and the Ministry of Legal Affairs for the drafting of legislation. And therefore, Mr. President, we have a situation now by which we have come to this Parliament with the bill before the Parliament. And one of the matters that the Law Reform Commission addressed was the tangible concern that under the current bail regime, there is the rare likelihood that repeat offenders of serious offenses will continue to obtain bail unless we, the parliamentarians, do something about that. And the work of the Commission, Mr. President, interrogated and took into consideration by research and policy advice to me as the Attorney General, the high levels of crime in Trinidad and Tobago, particularly the commission of serious crimes, serious offenses including murder, gang, and firearm-related offenses within the last 5 years. And they provided me with statistics that I provided to the draftspersons for the drafting of the bill, which is now before this House. So for the period 2019 to 2024, Mr. President, the statistics which were obtained from our various law enforcement and national security arms of the state tell us that the Trinidad and Tobago Police Service has identified 772 persons as being repeat offenders. Data provided by the Commissioner of Prisons tells us that out of a total of 2,000, 261 convicted male offenders in 2019, there were 1,110 repeat offenders, which represented 49% of the total of all male convictions in that period. In the following 2 years, that is to say, in the heart of the pandemic, there was an average decrease of male convicted repeat offenders by 10%. Thank God for the pandemic, if one could ever say that. But towards the end of the pandemic, in 2022, there was an increase of immediately 5%, that is to say, 451 instances of repeat offenders out of 1,366. And in 2023, the percentage of reoffenders had surged from the 5% in 2022 to 52%. That is to say, 1,076 out of 2,070 convictions. And in the period 2022 to 2023, the year just preceding the year in which, by the grace of the Lord, we now live, that is to say, 2022 to 2023, there was a 139% increase of convicted male reoffenders. The data also reflects a steady increase in the number of male convictions for firearms and dangerous drug offenses following the COVID-19 pandemic. And this government, Mr. President, is therefore of the view that it is necessary, it is imperative for Parliament to intervene, to introduce conditions to guide the exercise of the court's discretion to grant bail to persons charged with serious offenses, including murder, by requiring such persons to show sufficient cause or that exceptional circumstances exist to justify granting bail to them, particularly in the face of a continuing percentage increase in recidivism. That is to say, the ability of offenders to repeat their offenses once they are back out on bail. So the Bail Amendment Bill 2024, which is before this August chamber, Mr. President, that bill contains 9 clauses and requires a 3/5 majority vote pursuant to Section 13(2) of the Constitution because, acceptedly, some of the proposed measures introduce restrictions on a person's right to reasonable bail. What does that mean? What does a 3/5 majority vote mean? It does not mean, as I have heard to my dismay many times in this Parliament, when the United National Congress opposition comes to speak with it, it doesn't mean that because a bill requires a 3/5 majority, that by itself is a reason to vote against the bill. The requirement for a 3/5 majority is not a reason to say, because it requires a 3/5 majority, I'm voting against it. What it means is that we must look at the data and the facts which I have presented in this case, or are presented otherwise, before the Parliament, to show the threat that exists, the dangers that exist, the public interest that must be served, and the measures which this Parliament can take to intervene, to introduce controls, to save the society, innocent men and women, young girls coming from school, young women going to work, many of whom work on shift and are coming from work at night or going to work at night, to save them from the scourge of repeat offenders. That 139% increase in 1 year, the period 2022 to 2023. So when the opposition comes today to vote, they must reflect on that. Are they here to protect young, innocent people, the elderly and the infirm, and the other citizens of this country from a preventable scourge of crime, or will they throw their hands up and say, we are not voting for it because it requires a 3/5 majority? Nonsense, baloney. The purpose of this bill, Mr. President, is to amend the Bail Act to make provision for the restriction of bail to persons charged with serious offenses, to provide guidelines, not to deny bail, to provide guidelines for the judges of our country to determine when an application is before them whether the applicant has shown good sufficient cause or exceptional circumstances why that applicant ought, in the discretion of the judge, a discretion that existed that the Privy Council has determined since 1898, to determine whether that bail should be granted. The bill seeks to introduce conditions, therefore, Mr. President, for the exercise of the High Court's discretion in granting bail for persons charged with murder, serious offenses listed in Part 2 of the bill, and for other offenses, firearms offenses. And if one can just give an example, Mr. President, of the serious offenses listed in Part 2. Serious offenses specified in Part 2, just so that we don't have words that can be passed on as if they mean nothing. A, an offense committed by a person over the age of 18 years under the Anti-Gang Act 2021, which is punishable by imprisonment for 10 years or more. B, an offense under the Offences Against the Person Act, punishable by imprisonment for 10 years or more, or an offense under Section 48 of that Act. C, an offense under the Dangerous Drugs Act, punishable by imprisonment for 10 years or more. D, an offense under the Kidnapping Act, which is punishable by imprisonment of 10 years or more. E, an offense under sexual offense under the Sexual Offences Act or the Children Act, in which the alleged victim is a child. So when we come to vote today, let us reflect on that. Let the public reflect on that as they judge how this vote goes. The capacity of a judge with proper guidelines, where the person before her or him is for bail to show good, sufficient reason, exceptional circumstances why they should be allowed back out to continue to rape children. That is what this bill is about. F, an offense under the Sexual Offences Act, punishable by imprisonment for 10 years or more. G, an offense under the Anti-Terrorism Act, which is punishable by imprisonment for 10 years or more. H, an offense under the Trafficking in Persons Act, which is punishable by imprisonment of 10 years or more. Trafficking in children. Those are the offenses that have been committed in this society, Mr. President. And H, an offense under the Firearms Act, punishable by imprisonment for 10 years or more. So when we go to look at the bill and we look at the term serious offenses, these are the offenses that we are talking about. So it's murder, serious offenses, and firearms offenses. And the bill, therefore, seeks to impose a reversal of burden on the persons charged with those offenses, murder, firearms-related offenses, to require those persons to show exceptional circumstances or sufficient cause to persuade the judge to justify granting them bail to be released back into society while they await trial. Mr. President, the case that was cited by the Akeli Charles decision, which I referred to earlier, is actually a Trinidad and Tobago case. It's not an occasion of what occurred here, but they used it as an example. It is a case of Boudram, an Attorney General of Trinidad and Tobago, determined in the Privy Council. And at paragraph 30 of Boudram, this is what the Privy Council said in relation to the crime of murder. The crime of murder is, of course, always very serious. But some murders are more serious than others. The circumstances of murder cases vary across a wide range, from the terrorist who aims to overthrow a state by killing as many of its citizens as possible, to the devoted partner who commits a mercy killing in order to end the unbearable pain suffered by a loved one who is terminally ill. That was the example given by the Privy Council when they ruled, as Achille Charles did, that a blanket approach to bail was unconstitutional because you have to weigh the different circumstances into account. And the bill also seeks to provide a provision for a review of the Act to be conducted every 5 years after its commencement. And finally, the bill seeks to provide that bail granted to an accused under Section 5 of the Act proposed to be deleted and substituted by a new subsection 5 will continue to apply after this amending Act comes into operation. Clause by clause, Mr. President. 1 to 3 speak to preliminary matters. We remind ourselves of the Queen and Spilsbury dictum that the judicial discretion has existed since 1898. And the new subsection 5, Mr. President, which will firstly accept that a magistrate will continue to have jurisdiction to grant bail for summary offenses. Secondly, will grant to a judge and master the express jurisdiction to grant bail to a person charged for murder in those exceptional circumstances or sufficient cause. Thirdly, offenses listed in Part 1 of the first schedule will continue to be non-bailable offenses. So murder is removed from Part 1, but the offenses of treason and piracy remain. Those remain non-bailable offenses. Fourthly, a judge and master will have the jurisdiction to grant bail for indictable offenses except those listed in Part 1 of the first schedule. And fifthly, as seen in the proposed Section 3, a judge or master may not grant bail to a person who, on or after this bill becomes law, is charged with an offense under Part 2, that's the serious offenses. Those would be carrying imprisonment for 10 years or more, and he, A, has a previous conviction for any offense punishable with 10 years or more, and B, has a pending charge for an offense listed in Part 2, unless he can show sufficient cause or exceptional circumstances. And in relation to that exercise of discretion, Mr. President, the judge's ancient discretion is preserved. Mr. President, I could continue at length. I have looked at a number of different jurisdictions in India, for instance, Section 35 of the Narcotics, Drugs, and Psychotropic Substances.
Attorney General, you have 5 more minutes.
Thank you very much, Mr. President. But I am not going to dwell at length on all of the particular cases which we have looked at, which I had the benefit and the opportunity from the Law Reform Commission to look at the jurisdictions and the judicial decisions coming out of those jurisdictions. I have presented the relevant data to support the restriction on bail for persons charged with serious offenses, and in particular, data in relation to repeat offenses. Mr. President, I have advised the government that the proposed measures, although they will amount to an infringement of the rights to bail, are proportionate and in pursuit of a legitimate aim. That is to say, to explain the rationale behind the clauses to the bill. 1, to give effect to the ruling in Achille Charles. 2, to give to masters the jurisdiction to grant bail for the offense of murder, a jurisdiction which they did not have at common law and is being created by statute. 3, to provide that right of appeal for the accused or the prosecution against a decision of a judge or master to grant or refuse bail. 4, to impose in conditions on the exercise of the court's discretion. And 5, to impose an enhanced burden on persons charged with serious offenses to justify the granting of bail. In conclusion, Mr. President, this government recognizes that the proposed restrictions do impact fundamental rights and freedoms, but we believe that they are crucial to serve the public interest, and that is in particular to reduce the likelihood of repeat offenders, particularly seasoned criminals, from obtaining bail. We believe that the legitimate aim cannot be disputed of protecting the citizenry from crime. The legitimate aim is to keep our citizens safe. It's as simple as that. And the proportionality introduced in the bill before this House, that is to say, to reserve to the judges the discretion on a case made out to them appropriately by the accused who is applying for bail, who can show sufficient cause or justifiable circumstances to an exceptional degree for them to be granted bail. Those are reasonable, balanced considerations, legitimate for the judges to consider. And in the circumstances, we believe that the bill before this House is constitutionally compliant, albeit with the restrictions, if passed by a 3/5 majority. And in begging to move, Mr. President, I call on the opposition to do the responsible thing. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled an Act to amend the Bail Act, Chapter 460, be now read a second time. Senator Lutchmedial-Ramdial.
Thank you, Mr. President. Mr. President, in my present condition, I don't want to get too much into what the Attorney General has stood here today, where he has tried to shamelessly ignore the history of what transpired in this Senate. Because it is appalling. It is actually embarrassing to sit here and listen to the Attorney General. Because, Mr. President, I have to remind, if not people in here who may have forgotten, I have to remind the country that last year, around this time, I think it was the last sitting of last year's, of our term last year, that the opposition came to this Parliament, asked for members of the independent bench to support us in voting against a bill which removed all judicial discretion for the grant of bail.
Memories are short.
Memory, no, conveniently short. Memory very conveniently short on that side. And they want to stand here today. The only person talking baloney here today is the Attorney General. The government has come here today with a bill that we forced them to go and do and bring.
They lost.
We stood up here last year and said it was a violation of the separation of powers for Parliament to remove altogether that discretion to grant bail. We stood here and fought for that. We did, the six of us alone. The six of us here stood here and stood up for that because you know something? The UNC stands in defense of the Constitution and the rule of law. And the Attorney General has the audacity to say that there are some people who only believe that the Privy Council judges and then their decisions and so on and so forth. We won the Achilles Charles matter in the Court of Appeal, and you appealed the decision of our local judges to the Privy Council.
Bring it home.
Our local judges said, who is we? Me.
Members, Senator Leiter, I cannot hear Senator Lutchmedial-Ramdial at all. As much as you may want to support your colleague, you cannot be louder than her. Senator, continue.
Mr. President, I know my colleagues are equally as outraged as I am to have to sit here and listen to this. We can't sit down and listen to this. I can't sit down and listen to people so shamelessly ignore facts. Facts, Mr. President. Facts that since 2020, when the Achilles Charles matter was filed in the High Court of Trinidad and Tobago, the issue of Judicial discretion in the grant of bail was at the forefront of discussion and ought to have been at the forefront of the discussion. What was the response of the government in 2020 when we were going before the High Court? The Prime Minister mounted a political platform, called up all our name, mine included, and said, bail for murder, no bail for murder must remain the law in this country, commenting on a case that was before the judge and that the judge was awaiting to hear and decide on. Breach, total disregard for the issue of sub judice. Yeah. We went before the Court of Appeal. The Court of Appeal ruled, and let me quote, our unanimous view is that while a breach of this doctrine of separation of powers is not standalone reason for striking down a statute, it is a central consideration in determining whether the impugned statute is outside the umbrella of protection offered by Section 13. The unanimous view of this panel, that by removing the jurisdiction of High Court judges to grant bail to persons charged with murder, Section 5 has trespassed on a core judicial function.
Teach him. Educate
This was, what was the date of this? February the 17th, 2020. And it's about law, the Law Association supported us in this matter. They agreed, and that was a novel situation for the Trinidad and Tobago. The Law Association agreed with the Achille Charles, the attorneys representing Achille Charles, and said that, you know, that it was a violation of separation of powers. But the Attorney General, did he accept the view of our local judges that we hold in such very high esteem? I hold them in high esteem. No. He took it to the Privy Council. And now, having been told by the Privy Council, in a nutshell, the UNC was right. The UNC was right. Because when we voted here last year on this bail, on the bail bill that they then brought, when we voted on that bill last year, the Achille Charles decision was outstanding. And it came not too long after that. And I remember saying that decision vindicated the position that the opposition took here last year. And, Mr. President, I don't know who they're trying to fool by they were so outraged by all of this and all that, you know, because we did them a favor. For one entire year, they have used the opposition as a scapegoat for their failure to deal with crime in this country. Every time they are confronted with the issue of crime, the opposition don't support us, you know. The opposition don't support us on bail. They will, well, I want to see who you're going to blame after today. When the opposition has now forced you, you take a whole year. You could have done this since 2020 when the Achille Charles judgment when the Achille Charles claim was filed. But we have forced you to come here with a proper piece of legislation that respects the rule of law, that does not violate the separation of powers, that has built into it sufficient safeguards and so on, and does not remove judicial discretion. But they land here today expecting, like everybody else, land from Mars like them and forget their record and suddenly talking about what? Proper respect for judicial discretion. If you had proper respect for judicial discretion, you would not have brought that bill here last year. And it is the opposition having proper respect for judicial discretion told you no. And we told you no, and we forced you to come back here today. Suddenly, you have proper respect for judicial discretion. And had it not been for the people who took that Achille Charles matter all the way to the Privy Council, and I'm proud to say I was associated with that matter, you still would not have proper respect for judicial discretion. So, Mr. President, let me just start by saying, it's a very difficult thing to stand up for what is right in this country. It's a very difficult thing to have courage to go against the grain of public opinion. It's a very difficult thing to challenge the status quo. But I will tell you something, there are two people in my life that have given me the courage to do those things. One is the Honorable Kamala Prasad-Bissessar, Senior Counsel, who last year, I remember very, I will never forget, when we were discussing that bail bill, and I told her all of the arguments, and of course we go through all of the political backlash that we will face and so on, had two words for me: go brave. Go brave and stand up for what you know to be right, and that is what we did in this house last year. And the second person who I will pay tribute to, because nobody else will, but who I know is the reason why we are here today, is Mr. Anand Logan, Senior Counsel. Because if Anand Logan, Senior Counsel, did not take it upon, and Achilles Charles wasn't the first bail matter that we did. We did Ryan Reno Mahabir, we did Justin Stewart Charles.
Yes,
let me pay tribute to somebody who stood with us in that matter where we were challenging Section 5, and that was Mr.
Senator Leiter, Senator Roberts. Poor Senator Lutchmedial is trying to shout over y'all in order to make a contribution. I don't want to raise to my legs to make her sit and get up, sit and get up. I would love for her to just make her contribution, being on her legs, in peace. So, that being said, let us have silence so that the senator can finish her contribution. Continue, Senator Lutchmedial.
Yes. Thank you, Mr. President. Mr. President, it's all right. I could shout. I'm fired up today because when you listen to what when you have to sit down for 40 minutes and listen to what I had to listen to here today, right? The adrenaline pumping. But let me go. Let me go. No, let one debate. Let me go. And I want to pay tribute to somebody who actually was part of that matter because they were consolidated matters dealing with bail, and that is the Member of Parliament for Port of Spain South, Mr. Keith Scotland, Senior Counsel. Because all what is like to quarrel about the opposition and the opposition and the opposition, Mr. Scotland joined with us in a matter that also challenged Senior Counsel, forget the word, the deserving one. The deserving one. The deserving Senior Counsel. I had to premise Senior Counsel, not with deserving. The deserving Senior Counsel in the person of Mr. Scotland was also part of those matters to challenge. So when the whole country wants to come down on attorneys and say this about us and that about us and so on, I even remember speaking to my senior and telling him, I said, I think you had to be mad with this bail for murder thing. I said, you know what they're going to do to us? He says, no, we're right. And it's not about what is convenient, it's about what is right. It is about it's not about what is easy. It's not about what is easy. It's very easy to sit down in here and rubber stamp and pass laws because it sounds good. And the population can say, yeah boy, put all them criminals in jail. Yeah boy, let me lock up all of them. Right? Everybody's a criminal. Everybody in the police charge is a criminal. Okay, well, you know what? Until it's your child in the police station and you're getting the Attorney General to call and say, no crime was committed. Everybody's a criminal until then. Right? But anyway, let's go on. Mr. President, there is no right to bail in the Constitution. And nobody on this side or anywhere or anybody in their right mind has ever said that you have a right to bail. Correct. What you have a right to under our Constitution is not to be deprived of reasonable bail without just cause. And so what the bill here today that the government finally has found, put the tail between the legs last year, took a whole year to bring back. As I said, they could have done this since 2020. So all this recidivism they're talking about and repeat offenders and children being murdered and girls being attacked and so on, all that's on you, because you could have brought a good law for a very long time. And the people who have failed in many aspects, not just legislatively, but in every aspect of controlling crime in this country since 2015 is you. Right? So don't talk like if the opposition voting last year on your special majority bill that was a bad law has anything to do with it. It's you that have failed to control crime in this country, and it is out of control. And nobody will argue on this side that crime is not out of control. It continues to get worse every day that they remain in office. And so we only have one solution that we could propose right now, and we will support good legislation, as we always do, as we have shown. We will support good legislation that does not encroach upon the doctrine of separation of powers. We will support good legislation that we believe meets the criteria of how the courts have interpreted separation of powers and what is a core judicial function and what is an encroachment and so on. No problem, we will do all of that. But the major thing that we will do in order to assist this country in getting rid of this crime situation and helping and alleviating the suffering of citizens is to get rid of the PNM. Because that's the only real solution.
Time to go. Time to go.
That being said, you have a right not to be deprived of bail without reasonable bail without just cause. And what the bill before us does, it preserves the judicial discretion. And that's all we was asking for last year. That's all we were asking for, preserve the judicial discretion. It goes into more detail about criteria, and it introduced a concept of flipping the burden of proof so that the judicial officer can, and Mr. President, I sat here and I listened to all of my arguments from last year being repeated by the Attorney General as though something novel and new that he stumbled across. I also, I listened as well to the arguments, and these are the exact submissions that we were making before the court, that there are different facts in every case. And the scenario that I remember from the High Court to the Court of Appeal to the Privy Council that we used is, does a man who for the first time commits a murder because he found out that the neighbor or uncle or somebody was molesting his child, is he the danger to society that should be denied bail the same way that the gang leader who passed by a hard place and shoot 5 or 6 people? No, it's not the same. Every case should be judged on its own facts, and that is what the bill here today, finally, the government, trying to get it right, has brought before us today. It preserves, forcibly. They should thank us. They shouldn't be here trying to beat their chest and trying to make people forget their track record. They should be thanking us.
Thank us. Save your money.
So they
Take a walk, please. Take a walk. You can return when Senator Lutchmedial has ended her contribution. Continue, Senator.
Mr. President. So they have come today and they have introduced 3 scenarios in which a person must convince the judicial officer that there are extenuating circumstances, but it boils down to, on the particular facts of their case, that they should be granted bail. But it goes beyond that because, and anybody who practices in court would know this, circumstances change. And circumstances continue to change during the course of a person appearing before a judge or a master or a magistrate, which may warrant the grant of bail. And I will get into some of those examples and show you, because there's a lot of outrage. There's a lot of outrage in the country right now when you hear about people getting bail. And in a lot of those cases, people don't get bail at first instance, but they are later granted bail. And so I did my homework, and I made some inquiries into some of those cases, and I will share with this Honorable House what are some of the circumstances that led to people charged with serious offenses being granted bail. And so we'll go through them. And then, Mr. President, I will take my contribution down. Of course, well, I'm tired of saying this, but I think we need to examine, at the end of the day, not just why people are granting bail, but why we have such a high rate of recidivism. Because the Attorney General is anchoring his contribution and has anchored his call for support for this bill on the high rate of recidivism. And the fact of the matter is that the government has failed to adequately put measures in place to address the high rate of recidivism.
That is true.
Recidivism is something rooted in social and economic factors. And if you don't put things in place to address that, well, we are hamsters on a wheel. Because here's what, the reality that all of them need to wake up and realize is that you can't keep people locked up in remand yard forever. You can't. And unless you are convicting people, well, first, let me start with detection. Unless you are raising your rate of detection, and unless you are raising your rate of conviction, and unless you are putting proper measures in place to address repeat offenses and repeat offenders and get them out of that cycle, we are all hamsters on a wheel waiting until it's our turn to be the victims of crime. I know out there, and the trolls on social media, everybody, they think I like criminals, I've never seen so much horrific things written about me, even by people related to members opposite. I've seen it all on social media. All of it. People related, carrying the same last name as members who sit opposite me here. I've seen it. Well, let me tell you something. You think that I am out of touch with the criminal situation? I have had the closest members of my family held up at gunpoint. Held up at gunpoint. When I was 16 years old, when I was 21 years old. I was a prosecutor. I sat with victims 7 and 8 years old who were filmed being sexually assaulted by their stepfather and watched the videos with them. I prosecuted people who sodomized women with bamboo in front of their in-laws and their husbands. Mr. President, I remember I don't forget the cases I involved in like some people. I remember all of their names and their faces, and if it was up to me, personally, Jayanti Lutchmedial, I could give you a list now about 100 people that I wish I could put into that square and open a firing squad on them right now, because I don't think that they deserve to live in our society. I am as outraged about crime as anybody in this country. But you see that prayer that we say when we start every session here, putting aside public, private interests and affections.
They can't do that.
We're not here, and prejudices. We are not here to legislate based on emotion. We are here to legislate on what falls within the ambit of the rule of law and what is best for society. Because you know what? I could also tell you that I've prosecuted people. I've stood up and I've done bail applications where I've opposed bail for people accused of rape. Young men who remained in jail because there was an allegation that they were threatening and interfering with witnesses and all of that. Underage person. The victim was underage. A child, when I hear you're talking about a child, raping a child. Yes, a child is under 18. So when you have a 15 or a 16-year-old saying that this man raped me and he's threatening me and so on, you fight, tooth and nail to keep that person in jail, only to realize that that girl was lying because she didn't want her family to know that she had a boyfriend somewhere that she was engaging in sexual activity with, and she pinned it on somebody who had given her a drop home when they found out. I carry that around too, just like I carry around what I did, and I kept that person in jail for years. I argued for it. So, Mr. President, when I stand here today and I say that I support judicial discretion, I support that I have confidence. They didn't have the confidence last year. I have confidence in our judicial officers that they can assess circumstances and make the right decision. And that's all the UNC has ever asked them to do when it comes to the matter of bail. And they finally seem to have gotten it correct. So for serious offenses, firearm offenses, and of the offense of murder, that is what is dealt with in Section 5, where the discretion can be exercised by a judicial officer, and the person who is before that judicial officer has the opportunity to now come and present the circumstances of his case. After 180 days, it used to be 120 days without the case starting. They've increased it to 180 days. When we should be moving backwards in terms of the time it takes to start a trial, we're moving forward. And I really don't, but I understand the state that the justice system is in. I know that the 120-day limit sometimes poses a challenge for the prosecution and the police in order to get things started and to get their case files prepared and to start a matter. And so it has been increased to 180 days. I don't necessarily like it, but I wouldn't oppose it because, like I say, I would have felt very happy with all the chest beating and trumpets blowing and all of that on the part of the government. I would have expected to see from 120 we move down to 90. But instead, we're moving up now and giving more time where a person can be held on remand and their case not start and given an opportunity for them to be kept. That's, well, you know, we work with what we have. And unfortunately, we don't have much to work with this government. In Section 5(6), it includes a provision that when you are calculating and looking at previous convictions, you only look at things that have occurred within the last 10 years. That is a safeguard to ensure that a person isn't denied bail unreasonably because you're looking at one offense that may have occurred 20 years ago or beyond that 10-year scope, and so on. But, Mr. President, and a point that I want to make here again today, because, again, this is nothing very so novel that, you know, the government will try to make it out to be, because, and this is, again, part of the argument in Achille Charles and all the other Justin Stewart Charles, all of them matters that we did about the judicial discretion. It has been, and has always been, I think since 2005 amendments to the Bail Act, to the 1994 Act, there has been a provision which lists all of the criteria that a judge should consider when they are granting bail, and that is Section 6.2 of the Bail Act. And that provision specifically has been in existence for decades. So at the end of the day, saying that, you only take into account previous convictions of this amount of time and all of that thing, it's a guide that the judge could now use, but it doesn't change the law. Because on every occasion, and anybody who has ever done a bail application should know that what a judge asks or a magistrate asks when somebody comes before them and asks for bail, whether it is a murder, well, now it's murder, but before, if it was manslaughter, if it was any type of serious offense, firearms, etc., you inquire, what are the antecedents of the accused? First question out of the mouth of a judicial officer, what are the accused antecedents? What is the status of the victim in the matter? Is he still hospitalized? If it's on the first hearing and so on, you usually get an update on the state of the victim. If there's a physical injury and so on, you want to know what has happened to the victim. The police have an opportunity to make presentation to the court about any evidence and any allegation about threats being made to witnesses. And so that Section 6.2 stipulates already in the law about the conditions, and the conditions that you must take into account in granting bail, and they include whether or not there's a likelihood the person might fail to surrender, whether there's a likelihood that the person will commit an offense whilst out on bail, recidivism. You can look at a person's track record, and if you see that every time they get bail, or they have gotten bail once or twice before, and they are now before the courts again, the judicial officer can refuse them bail, and that happens every day in courts throughout the length and breadth of Trinidad and Tobago. So all of this novelty that they think that they have suddenly stumbled across has been in existence for a very long time. Interfering with witnesses. If he has absconded, if you have previously absconded on bail, that is a serious consideration that will work against you when you come before the court to now ask for bail again. If it is that the allegation is that you were out on bail and you are now back before the court and you have reoffended, they must consider that. I remember there was a time when former President, then Justice Anthony Carmona, had started on his own volition a very good initiative in San Fernando. Every Thursday morning we used to do bail. And he insisted that before granting bail, particularly to young men, because of the high rate of recidivism amongst young men, that he was sending everybody for a probation officer's report. And until that probation report came back and he was satisfied, he was not granting bail. And he was also not granting bail until you had a parent who you were going to live with come before the courts, and he went through that report with them. Now, it was long, it was painstaking. People had to come and go, ride that prison truck 3 or 4 times, wait until the report came before him and so on. He came up with that on his own, and he was looking at those things because he was considering these factors. And I commend him for that because I thought it was quite good. In many cases, he denied bail because of what the probation officers reported. The probation officers, and if you go to the children's court now, they have more staff who deal with, like social workers and stuff who deal with children. And when you read those reports, you realize why some people are denied bail. And you ask the court to deny them bail. But there will always be a case where someone might be entitled. And we have to, as lawmakers, make provision for those people. So we have seen the light a long time ago about that, and it looks like my friends have now seen the light. We've had to drag them there, kicking and screaming, but I think they have seen the light. Now, they also seem to have seen the light when this bill was debated in the other place, because they took on board some very good suggestions coming from the opposition and others, and they have made some amendments. They have defined the standard by which the exceptional circumstances where the judge has to be convinced, and they've included it to be the balance of probabilities. I believe that to be the correct position. That is how a magistrate or a judge or a master ought to exercise that discretion. Mr. President, as I said before, the 2 questions, burning questions coming out of all of this, now that we've agreed that this bill can pass the test of scrutiny in terms of its compliance with the rule of law and not being an encroachment on the separation of powers, the next thing that we really have to examine as a parliament is why do we have such a high rate of recidivism and why are people getting bail? I'll start with the latter one first. I, like many other people in this country, read the newspapers every day and hear about people getting bail and wonder, well, why? Because those reasons aren't included in the newspaper reports, right? And I see they've included a paragraph here on the Law Commission. Law Commission, they do brilliant work. I commend them too. That they've included it on the recommendation of the Law Commission for the provision of reasons. That's good, because maybe the reasons why somebody's granted bail, if they are documented, ought to be published in the newspaper as well, because people have a sense of outrage towards even judicial officers for granting bail now. I made some inquiries about one, I don't want to get into the facts, but it's a murder. Persons who were charged were not granted bail initially, and then eventually I see they all get bail. So I know the defense attorney, I know the prosecutor in the matter. I made some calls, I wanted to find out why. How? Because it was a, well-publicized case, quite egregious matter and so on, and these people are out on bail. What would have possessed a master or a judge, I think it was a judge actually of the High Court, to grant these people bail? Well, you know what happened? You know what are the reasons? You know how they were able to satisfy a judge that they should be entitled to bail even without this, so on and so forth. And I want them to listen very carefully, because these reasons will be used as the exceptional circumstances for people to continue to apply for bail. A year after being charged for the murder, a file had not yet been sent to the DPP's office for a prosecutor to be assigned. The police had not complied with 3 separate orders for disclosure. The police had directions to file witness statements on 3 separate occasions. They had not complied with the directions of the court to progress the matter. The firearm that was allegedly used in the commission of the offense had not yet been processed. There was no forensic record a year later that could, and the firearm was a key issue in the case. So, what does the judicial officer do? They grant bail. They grant bail. The failure or the reason people are getting bail is not Jayanti's fault. It's not Kamala's fault, it's not Anand's fault, it's not the UNC fault, it is a failure of various institutions of the state. And unless you address those things, you're not going to have this automatic or this high level of bail denial that you seem so thirsty for. So if you want magistrates and judges and masters to deny people bail, then you have to give them the material. I will go back again. I remember a man once getting bail for a sexual offense that I was prosecuting. And when it was the only time, and he had prior convictions for, he had prior charges, pending charges for robbery offenses. And this rape allegedly occurred in the course of a robbery. So it wasn't like they knew each other or anything like that. It was strangers between himself and the victim. And the only time I was able to get his bail revoked is, that was one of the few cases I did at that time, talking about, about more than 10 years ago, was because I came to the court and I showed them a DNA analysis that had gone to Jamaica and come back, proving that that person was a 99% match for the semen found in the victim. And that was the end of that. That person never saw the light of day again. He's still in jail today. Because I had in my possession the type of information needed to convince a judicial officer that bail should not be granted. So until we get forensics right, until we get CCTV footage right, when you have CCTV, good CCTV footage and so on that you can use to support your case and your claim as a prosecutor, as a police officer, that this person I have before you here, who might have to wait 5 years or 6 years or 10 years for the day in court, but I have the evidence linking them to this crime. Mr. President, I don't put my head on a block for many people, but I could put my head on a block for many of our judicial officers that they would be very hesitant to grant bail in circumstances like that, because you give them the tools that they need, and the government has to give the prosecution and the police the tools that they need to be able to stand up in court and make proper bail applications. The court does not just come out of the judicial officer doesn't walk outside of the chamber every Monday morning and say, okay, bail for you, bail for you, bail for you, bail for you, bail for you. It is a process. And the participants in the process have to have the tools that they need. So until we have working, functional CCTV cameras that can pick up crimes whilst they are happening, that can pick up license plate, that could help the police to solve matters faster, that could help convince a judicial officer that there is a high likelihood that this person is in fact guilty and that the correct culprit is before the court, they won't mind keeping you in jail for 120 days, a year, 2 years, 4 years, even if it's 5 years that you remain in remand yard, because the justice system, is a bit we have a backlog to deal with and you have to wait your turn because you feel fairly certain that that is the person. When you have DNA, you feel so. Since 2018, this government has announced that they are building a new forensic science center on 3 separate occasions. I have read in the media that they met with the Chinese team and investors and so on, and 3 times I see them cut ribbon, shake hands, sign agreement, all kind of thing. And up to now, I don't think a blade of grass cut on the piece of land that they identified to build this forensic science center. Nothing. And when I asked a question some time ago in this parliament about the amount of samples being awaiting processing at the Forensic Science Center, you know what they stood up and said? They had about 19,000 in total, right? But you know what the Minister of National Security has been telling us? Oh, we now have CIRU.
Senator, you have 5 more minutes.
Thank you, Mr. President. We have something called CIRU, and that is something Evidence Recovery Unit up in Komoto, and that they're recovering crime. I sit on the Joint Select Committee of National Security, so I sit down here and I say, well, we have this CIRU and then processing all these things, and how come firearm cases not moving through the court? And firearm cases are very central to this bill because it's a big focus. I will leave it for Senator Richards to talk about how much firearm coming in the country because scanners not working and so on. That's a whole other issue. But they allow all the guns to come in, and now they come in here to say deny everybody bail, and nobody should get bail for firearm offenses, right? But okay, no problem. The firearms are here, thanks to them, and the open borders and the failures on the port and everything else. But the firearms are here and we have to deal with it. So what is CIRU doing? So I had to ask myself, well, how it is with CIRU and the minister praising the work of CIRU and how fast these things are being processed and going before the court. I asked the director of the Forensic Sciences Center in the Joint Select Committee, Mr. President, CIRU will swab the firearm if they find it. CIRU will try to collect DNA or fingerprints or something like that from the firearm. But at the end of the day, after CIRU done with it now, it's still going down St. James in the Forensic Science Center for a toolmark examiner to have to sit down, analyze it, prepare the report, and then give it to the police, and then the police can start the matter in court if they get that. And that is where the bottleneck is, and they have not addressed that. I don't even know if they are aware of it, because kill them dead, CIRU is solve the problem of firearms, and it has not. And I asked the director of forensics that. I asked him direct question, has this cleared the backlog and has it made your firearms and so on available, your reports available to say, are the toolmark examiners, attached to CIRU now? Like, no, they are not. It's still going down to forensics, where they have a shortage of staff. So, Mr. President, saying that you come here today to pass a bill that the UNC forced you to bring, and trying to, again, make the population forget that you dropped the ball last year and many times before, trying to make everybody forget that you fought vociferously even against the decision of our local judges at the Court of Appeal, including the Chief Justice, that the bail for murder law was wrong, that you had to leave here last year and in defeat, and that you have now come back here, thanks to the UNC, thanks to the bravery of the opposition to stand against, to go against public opinion that the government likes to, fuel and mislead and with propaganda and so on, and go out on public platform and call up all our name and blame us for everything and so on. Like I say, I don't know who they're going to blame after today. I don't know who they're going to blame after today for all of this. But let's see after today how they will deal with all of the issues. Because if they don't want to address the issue, Mr. President, there are other measures apart from bail as well that I think they have to address as a government, because it will help the criminal justice system along. There's a very high cost attached to keeping people on remand. Very, very high cost to the taxpayer. And, you know, we set up, the UNC passed the electronic monitoring law. They have amended it several times. And again, today, through my own inquiries and through my sitting on the Joint Select Committee on National Security, the court has made 288 requests for persons to be assessed for electronic monitoring, which is an alternative to keeping people in remand yard. And only 93 of them have been recommended. And several of the persons who, you know, should be working there, there are several vacant positions still today in that electronic monitoring unit. So unless you are prepared to do what is necessary on the parallel roads towards offender management, then I have to say, you may not find yourself making much progress along the route of managing offenders. I did not get an opportunity. Perhaps one of my colleagues will discuss the social and economic problems that lead to recidivism, but I think we all know why that occurs. And so, Mr. President, with those few words, I thank you.
Senator Richards.
Thank you, Mr. President, for the opportunity to make a contribution to this bill, which I think it's a vast improvement over the last iteration, which failed to gain the support across the board in the Parliament. And one of the main reasons for this, the presentation of this bill, is really a lot of information that persons on multiple charges, including gun charges and serious charges, are obtaining bail and continuing to commit crimes while on bail. And I think the government has, in this instance, struck a balance between the denial, absolute denial of the remit of the judicial officer, and provided for exceptional circumstances. And I think the balance has been struck between the rights of the accused and the paramount safety of citizens in Trinidad and Tobago. And I think that's commendable. The Attorney General did make a commitment to bring it back to the Parliament with amendments, and I'd like to take time to commend the Attorney General and government for doing that. And I think, based on the occurrences in the other place and support across the aisle, and certainly from Senator Lutchmedial-Ramdial's presentation, commending this iteration of the bill, I think the outcome will be very different to what we saw the last time around, because it has upheld the important separation of powers principle and also the oath we all take to uphold the Constitution and the law. So I think it's very easy for me, I can't speak for anybody else, to present an aye to this bill and support it, because it strikes a great balance. But of course, it is one of the measures that is needed in an effort to quell the dangerous levels of crime we see, in particular murder, the recent evolving phenomenon of mass shootings. We've seen 3 so far, which is another step in the wrong direction. And the suspicion is that many of the people who are perpetrating these crimes are persons who may be out on bail. But bail is not a panacea. And I think, in addition to the amendments to this iteration of the bill, which is very, as I said, is very commendable, I think the last time around, the government really failed, to me, to present as convincing an argument as they could have, given the level of data that the government has available to it and the resources. And over the time since that debate, I think in 2022, a lot of questions have been asked in this Honorable House and the other place, and information coming out in relation to bail. And I can point your attention, through the chair, to a Newsday newspaper article Wednesday, the 21st of February, titled by Narissa Fraser, titled "Government Reveals Crime Data for the Last 5 Years, 13,800 Get Bail for Serious Crimes." And it's interesting that the question asked by myself to the Minister of National Security provided this information, which easily could have been available to the government at that time, to present a forceful argument about what was happening in the country. And the Minister of National Security, in 2022, he said 2,488 got bail for serious crimes, while 2,996 did in 2021. In 2020, 2,202 got bail. In 2019, 2,098. In 2018, the total was 1,030. The group of offences with the highest number for 2023 was narcotics offences with 379 getting bail, while the lowest serious was a serious indecency with 12. When it came to violent crime, it says last year, which I'm presuming is 2020 because the article was written in 2021, 24 were granted bail for murder, 143 for shooting and wounding, and 236 for rape, incest, and other sexual offences. And when this information was presented, I found it shocking information, to say the least. In addition, in 2023, the article goes on to state, the number of people granted bail for kidnapping was 88. Kidnapping with ransom, 17, burglaries and break-ins, 148, and 218 for robberies. Again, in 2020, a total of 320 were granted bail for possession of firearms and ammunition and charges, and 2029 got bail while facing charges for other serious offences. There was also bail granted for fraud offences, general larceny, larceny of motor vehicles, and larceny of a dwelling house. So those statistics speak for themselves and bolster the argument. Because of those, one can only imagine, particularly ones on gun charges, how many of those are multiple offenders which had not been disaggregated by the information presented by the Honourable Minister of National Security. We also ask how many matters, or I also ask how many matters were awaiting filing of indictment by the Director of Public Prosecution between 2018 to 2023. And the total number for that period revealed to be 1,332 by the Honourable Attorney General, Reginald Armour Senior Counsel. And of course, given the public discourse on the backlog in the criminal justice system, there were inquiries about whether or not conversations were afoot in terms of the filings and the resolution of those situations. Minister Hines also identified that in each of the years from 2018 to 2023, 2,053 persons were on remand, 1,985 men and 68 women. And so it bolstered the case related to the potential, for Senator Lutchmedial-Ramdial indicated, high levels of recidivism in the country, which some of the information that was received by the Joint Select Committee on National Security to be in the vicinity of 65 to 70%, which is startling, which means it's signaling a revolving door scenario, and also speaks to the issue of whether or not we have an effective restorative justice system in place in Trinidad and Tobago. Mr. President, through you, the issue is another article I can point our attention to is in the Trinidad Guardian. It doesn't state a date. Titled, Judicial Officers Admit Country's Crime Rate Too High. Urge state to find resources to solve issues, which Senator Lutchmedial-Ramdial spoke to, because while we, if we are to follow the trend in the other place, the government hopes to get the support to pass this bill today, it is not a panacea, and there's several other factors and variables involved in ensuring that this redounds to a reduced level of criminality in Trinidad and Tobago, dealing with the throughput in the criminal justice system, and also on the input end of it, finding the ways to deal with the factors that lead young people into criminality in the first place. Because, as I said before, we can't continue thinking that pumping money into national security, the TT Police Service, and prisons is the answer to our crime situation. Because it seems that the production side of criminals, let me put it like that, is outstripping the ability of the country to interdict, intercept, and deal with them through the criminal justice system. So we have to be preventative and proactive as opposed to reactionary. So the article is by Annalisa Paul in the Trinidad Guardian, and the Judiciary Court Planning Director Anderson Gordon told the GSC National Security, open quotations, "We have a problem. Crime rate is too high. Matters taking longer than we would like to be completed." They presented a comprehensive view of the challenges the judiciary faces. Gordon said in addition to the high crime rate, TNT is also facing high domestic violence rates, which leads to children exposed to that having a higher potential for also being abusive and ending up in harder forms of criminality. A larger than expected criminal caseload at the Children's Court, a much lower than desired rate for completion of matters, a large pending criminal caseload, lengthy delays in the courts due to a significant number of adjournments. He said they were working on enhancing delivery and reducing delays and backlog. On the issue of over-incarceration, they said there are too many people on remand or as part of their sentence. Appealing for more support services to address the issue, Master Christian Morris Allen rubbished public claims that judges were simply opening jail doors and allowing persons accused of murder to access bail and their freedom. And Master Morris Allen presented the following statistics to corroborate her answer. She said, in May of 2022, 27 matters were listed, only 6 were granted bail. In June 2022, 87 were listed, 3 were granted bail. In July 2022, 70 were listed, 4 were granted bail. In August 2022, 67 were listed and 4 were granted bail. September 2022, 65 listed, 5 granted bail. October 22, 38 were listed, 2 were granted bail. November 2022, 46 listed, 3 granted bail. December 2022, 53 were listed, 5 granted bail. January 2023, 58 listed, none granted bail. February 2023, 54 were listed, 3 granted bail. And in March of 2023, 61 were listed and 3 granted bail. So the narrative that judicial officers were just opening the doors and letting people who were accused of murder out onto the street to continue carnage, by this information, is utter nonsense. And it should be stopped. In April 2023, 46 were listed and 1 granted bail. And in May of 2023, 26 were listed and none granted bail. So, I mean, this is incontrovertible data from the court, a master of the court. One of the issues that the judiciary also identified can be seen in a Newsday newspaper article. Judiciary calls for scientific evidence and more expertise in policing by Ryan Hamilton Davis, dated Saturday, 17th of June, 2023, because as Senator Lutchmedial-Ramdial indicated, and the Attorney General in his presentation, the accused has the ability to present to the judicial officer a case for exigent or exceptional circumstances to get that bail. On the other side of that, the police, TT Police Service, and the police prosecutors also have a duty to present the most formidable case to the judiciary. And Master Christian Morris Allen said the quality, and I quote, the quality of evidence is having a significant effect on the outcome of matters before the court. When you're coming to negotiate, and I quote, when you're coming to negotiate a plea, and the evidence that you have is scientific evidence, then you are in a better position to negotiate an appropriate plea. And she's speaking about plea bargaining here. And of course, it extends to whether or not the bail is granted or the case goes through successfully for the prosecution or not. If the evidence you have is only eyewitness testimony, for want of a better term, it is a bit of a poker game. One of the things that an accused and his lawyers will be thinking about in that case would be to hedge his or her bets. She also identified that the shortcomings that the judiciary was facing was that the inability of the police to keep up with crime, a lack of data-driven processes, insufficient support, prevention, and restoration. She also went on to say the country's approach to policing has not advanced as quickly as its crime. It has not been recognized in the police service in its organizational design that in modern policing, people who are called upon or even suited to walking the beat must be involved and play a critical role in crime fighting. She also said from talks with police agencies in different parts of the world, it was recognized that the police placed an importance on support from psychologists, criminologists, and well-trained scientists for intelligence and evidence gathering. These things are critical, she said. There can't be an adjunct somewhere outside. They have to be part and parcel of the process. Maurice Allen also shared the numbers of murders and cases before the courts, which I would have read out before. She also said, since this decision, which has made it clear that one can be bailed for murder, it seems that in the public domain, that judges have been opening the jail doors and allowing everyone charged with murder to walk out. But I spoke to that before. And she also indicated that in July, the Privy Council determined that people accused of murder would apply to the High Court for bail, which changes the practice of denying a murder-accused bail that has been ongoing since 1917. Mr. President, through you, I'd like to also add another dimension to this conversation, which also speaks to the quality of evidence going before the courts. One, for police to maintain their case that this accused should not be granted bail, or in aiding of the prosecution process in the case. And in a report from an 8-year period to the police showed an approximation of an average of 36% of reported crime led to an actual prosecution, and of that 36%, only 5.7% led to convictions. That's a really poor track record. Which means that if only 5.7% in an 8-year period led to convictions, guess what's happened to the person who went to courts? They back out. It may be that they were innocent, but it may also be that they had committed the offense, and the case was not a great case that was presented to the judicial officers. So a lot of this is not only on the courts and the bail, the option for bail. One of the other things which I saw, and another issue related to the police operations in these cases, because the police are critical in these matters, and it's listed in the Joint Select Committee National Security Report on the 3rd session, 2022-2023, 12th Parliament, on an inquiry into the criminal justice system in Trinidad and Tobago to determine strategies to achieve greater efficiency and effectiveness. And I would commit this document and all these documents to members. And I think it's also listed on the Parliament website, because we do such great work. The Parliament does such great work in these JSCs. And I don't know how much of this information or these recommendations actually are taken into consideration. So one of the other issues the courts are facing is listed in page 39 of this document, titled Non-Appearance of Police Complainants in Court. The Monitoring and Evaluation Unit of the Police Service Commission Secretariat, on behalf of the Police Service Commission, continue to monitor the non-appearance of police complainants in court and to report on systems implemented by the Commissioner of Police and progress on the matter for the period under review, which is 2016 to 2021. The number of court matters dismissed due to non-appearance of police complainants continue to decline. Good news. Interim data from the police service showed 308 court matters were dismissed due to non-appearance of police complainants in 2021. That's the good news. Let's go from 2016. 1,345 dismissed. 2017, 1,825, the peak. 2018, 1,627. 2019, 1,726. 2020, clearly some measures were put in place. It went down to 729, and 2021, it was down to 308. All those things over the years that we under consideration here have an impact on criminals ending back out on the streets. The primary challenge, flagged in submissions received by this committee was the inability of police prosecutors to efficiently and effectively prosecute matters due to insufficient training. The following submissions from the Public Defender's Department provide further details. Police prosecutors are not always legally trained, and furthermore, have very limited prosecutorial training as compared to state counsel. As such, they often require lengthy and frequent adjournments to research points of law and to seek advice from the DPP's office and their superiors. And of course, in many cases, they're coming up against senior counsels. Thus, the progress on the matters before the courts is often stymied in this regard, and judicial time set aside to deal with particular matters is wasted. Police prosecutors are not always properly equipped to deal with vulnerable witnesses, including child witnesses and rape victims, hostile witnesses, and often not able to properly utilize hearsay applications under the Evidence Act, Chapter 702, for witnesses who cannot be found or who are unfair, etc. So this is another layer of the issues facing the courts in this regard. So while as I said when I started, I commend the state, the government, the Attorney General for the amendments in this bail bill, because certainly it is much more palatable and has found favor in the other place, and certainly with me, and will go a long way in balancing the rights of the accused and also the considerations which are to me the priority of the citizens of Trinidad and Tobago, to curtail and reduce persons who are charged with, in some cases, are convicted and back out, and continue their errant ways, and continue to create carnage in the society. This is only one measure. There are a lot of factors that go into whether this measure is successful or not. It is overall intention, because the overall intention is to reduce crime in Trinidad and Tobago. And one of the ways to reduce crime is contained in this bill in terms of reducing the number of persons who are on multiple charges going back out and creating carnage. But the other factors are equally as important and can only, on one hand, work to complement this measure or diminish the effectiveness of this measure if they're not working in concert and all effectively. I want to take off where Senator Lutchmedial-Ramdial left off and speak to what I consider, and I've spoken about this before, the issue of the input side of crime. And of course, in many other contributions, I would have spoken about the education system and its shortcomings, and the fact that we like to look at the high performers and celebrate them, which is fine because they've worked hard, don't get me wrong. We're supposed to celebrate people who work hard, but we don't place the kind of emphasis we should be placing on those who are underperforming. And I use the word underperforming deliberately because underperformance has certain prerequisites or prevailing factors. And while I know we have the student support services of the education ministry, it is woefully overloaded and under-resourced because of the numbers of issues that are coming to that agency. So let me just quote quickly two articles. Shocking state of TNT's children, because that's the next generation of scholars, scientists, productive citizens, or the next generation of criminals, depending on how we deal with them, how we raise them, and what kind of citizen our systems, education system, which includes the formal and informal education systems, are treating with them. Article by Anna Ramdas of the Trinidad Express dated March 15, 2019, titled Shocking State of TNT's Children. A red flag was raised yesterday over the hundreds of children coming before the courts as offenders. The Judiciary's Court Executive Administrator, Master Christian Morris Allen, said it was initially projected that the Children's Court would hear 1,500 matters annually, but shockingly, in just 3 months, that figure had already at that point reached to 500. Another article, Melissa Maynard, Trinidad Express, Youths Living in Culture of Violence. Education Minister, crime statistics, a cause for concern. Between 2015 and 2019, of the 510 people charged with murder, 62 of them were between the ages of 15 and 29. And 96% of them were male. These statistics were quoted by Education Minister Dr. Nian Gatsby-Dolly to support her point that a high number of young people have committed violent crimes in this country. The same ones who are ending up trying to get bail in many cases. She was speaking at the ministry's breakfast meeting, Education is Good Business, at the Hilton Trinidad St. Anne's, Gatsby-Dolly noted that crime, which she said is considered a public health issue, is crippling national development. I fully agree. Because every one of those young people who end up on the wrong side of the criminal justice system could be a productive contributor to national development. And it is worrying. She cited more recent statistics that underline the unfortunate reality of youth falling into criminal activities. And if we look at 2022 more recent statistics, 54% of all violent crimes, including murder, is being committed by youth between 15 and 29, and this is our reality, this is where we are. So, while we do this part of it, we have to look at the failings of the education and other systems that is seemingly not identifying young people with emotional behavioral disorders and, in some instances, deviant behavior tendencies for many different reasons. It's easy to do like 40 years ago and say they're just bad. That is a 40 years ago mindset. They're just bad. They grew up bad. The parents bad. The grandparents bad. They come from a bad area. They're just bad seed. But the modern thinking, the contemporary thinking, that is not it. There are many, many factors that lead those young people to not choosing in many cases, but erring on the side of crime. And we have to start to focus more on that as opposed to just being reactive. There's an interesting letter to the editor by Mohan Ramcharan in the Newsday newspaper, Crime Poverty Connection, Tuesday, 11th April, 2023, and I quote the editor.
As much as in treating with this Bail Amendment Act, we would need to veer into the causes of crime, which would cause someone to actually request bail. We don't want to veer too much into it because then we end up debating crime itself and the causes thereof. So I just want to caution you to sort of tighten a little bit more to the actual clauses in the bill.
Thank you, Mr. President. I am guided. One of the ways that we can have less need for persons coming before the courts and having to apply for bail in the first place is to make sure that they don't run the errant road. And I'm just asking your indulgence, President. There's just a couple points I want to make because I'm heading to closing very soon. And the article, and I'm going to paraphrase here, not to run up the ruling of the chair, speaks to important understandings of when people end up in the criminal justice system and asking for bail, they don't do that overnight. There's a process and a system that either facilitates that or diminishes that, including, of course, social determinants, poverty, education, family structure, peer influence, unemployment, social disorganization, substance abuse, a big issue in Trinidad and Tobago because many of the persons who are repeat offenders, if you do the data search, they are also in many cases high substance abusers. Inequality and social exclusion, cultural factors, and mental health issues. In some jurisdictions, that's a big issue. In conclusion, Mr. President, the holistic long-term solution does not lie in more money being spent on national security, more laws, legislation, building more prisons and systems, interdiction and penalizing of offenders. Yes, society will also have persons who, for one reason or another, start off having incursions with the criminal justice system as youth offenders. We need more comprehensive identification, rehabilitation. The fact that recidivism rates are so high and the same people are ending up before the magistrates, masters, and judges to get bail is because of the failure of the restorative and rehabilitative justice systems in our prisons to start with. There need to be significant investment in psychosocial and emotional behavioral issues from as early as young children, teens, and adolescents. System needs to be ensuring that upcoming generations need to be raised in a different way, producing the kind of citizens we need to move the country forward. A lot of emphasis is placed on student support services, which is overburdened, but youth are not being identified and remediated in the school system. Literally, there are thousands between primary and secondary school. I hope that this bill is one step, and we understand it's one step and one aspect in what is a very multidisciplinary and complex approach to dealing with criminality in Trinidad and Tobago. And I commend the Attorney General and the government for bringing this and heeding not only the cause of the opposition, but other civil society groups, and bringing this bill. I think it's very commendable. That's the kind of lawmaking that moves the country forward. And I congratulate the government on that. And if I could just end, Mr. President, on a slight note of voicing a bit of concern. While I will come here Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, I have no problem coming here and working. We swore to uphold our duty to this country. And while I am here willingly, and I'm sure other colleagues are here willingly, it is very stressful under the conditions that we are here to exercise due diligence on all the bills that we are asked to deal with between Tuesday, Wednesday, and today. And I have no problem. I acknowledge that the government has the right to do this. And we are heading to recess. But I certainly can't function if I'm exhausted. I can't, there are no simple bills to me. Every bill is critical and important. Every aspect of the bill must be scrutinized. And while we are here willingly to do this, it is under duress, not duress that you force us to be here, but I cannot function at the optimal level that I need to function to fulfill my duties to Trinidad and Tobago. So I'm pleading that this sort of scenario not be allowed to happen again, with the greatest of respect. And with this few words, Mr. President, I thank you.
Minister in the Office of the Attorney General.
Mr. President, I thank you most sincerely for the opportunity to join this debate and add my voice, of course, in support of this Bail Amendment Bill 2024. I want to begin, of course, by commending the Attorney General for all of the work that he has embarked upon together with the Law Reform Commission to present the bill in the manner and form in which it appears before the people and more so the Parliament of Trinidad and Tobago. Mr. President, as I begin, I would have heard some of the words. Of course, I listened, keenly to the presentation by all the previous members. And of course, Senator Richards would have spoken to there being very many reasons why young people turn to a life of crime. And as I get into the crux of my presentation, Mr. President, there are three major principles that this government has and continuously build our fight against crime on. And these three principles, Mr. President, are preventative measures, prevention, detection, and conviction. There are three critical principles, Mr. President, that is at the core of every policy driven by the People's National Movement and driven by our government. And once I get into those prevention mechanisms, detection mechanisms, conviction mechanisms, and more so how this bail amendment bill finds itself assisting us in preventing, detecting, and of course, convictions for crime, I would be able to respond to some of the statements. At that stage, at that juncture, I would respond and like to add a little to the submissions made by Senator Paul Richards. Now, I too had the unfortunate situation where I had to sit here and listen to the rant and rave of an opposition senator who, of course, she spoke about her condition, but after her presentation, with all due respect, Mr. President, the only condition I saw was a mental one. And I would say that because, Mr. President, this Senator Lutchmedial-Ramdial, had the gall to stand before this Parliament and had the gall to pay tribute to people who she believed was so significant in the passage of this, in the failure, of the 2022 bail bill. And to this point, I have not heard in her tribute that she reminded this nation and paid a tribute to what happened to Achille Charles just a few days after, Mr. President, that this judgment was given in the Privy Council. And that is the serious nature. And what happened to Achille Charles, to the members of the public? More than 2 days after a judgment was given by the Privy Council, Achille Charles was gunned down. He was gunned down and killed and murdered and slaughtered, Mr. President. Of course, and why I raise that issue, Mr. President, it is because in 2022, when we brought the bail amendment bill, it was because as a government, we recognized that that time had come for us to take draconian measures, Mr. President, as draconian as it may seem, in an effort to fight against crime. So in all the senators' tribute, I'm very amazed that in all the tribute and all the ranting and all the raving and all the behavior, that she did not remind the public of what happened to that. Yes, his name will live on in the dicta and, of course, the case that is before the Privy Council. But the reality was his detriment. And that is...
Continue, Minister.
Mr. President, and that, Mr. President, was the situation in 2022, and it spiraled even more after that, and that is why in 2022, when this government came with that bill, it was not because we were inadequate, it was not because of the failure of the Attorney General, it was not because we did not understand what good law is or law is, but sometimes there comes a time as policy makers, Mr. President, that we are required to make decisions in the interest of the public. And that is why our Honorable AG always speaks to the position given forward, yes, in Suraj and Surat, about that public interest position. And you know, this same senator stood here, Mr. President, and she spoke at length about thanking Mr. Ramdial. Well, thank God for my senior. Her senior is probably out and could see the lighter sun. But I will leave that right there. But she came to this house, Mr. President, and she spoke about Mr. Ramdial as if he's the protector of the voiceless. But I want to ask the senator, since she spoke about that, how come to this date I have not heard the senator tell the people of this country about the Children's Community Residence Foster Care and Nurseries Act, which was amended by the same minister, Anand Ramdial, when he was the Attorney General. And I'll tell you why I raise that issue, Mr. President. On the point of recidivism, on the point of why some young people turn to a life of crime, that particular act, which was amended when Anand Ramdial was the Attorney General of Trinidad and Tobago, the purpose of that act was to help some of those little boys and girls who are without parents, who don't have a home to go to, who their parents died, those and they found themselves in before the court. That piece of legislation, when it was created, of course, it has multiple functions. That piece of legislation was amended by that Attorney General in 2012 when he it was amended when he was Attorney General, Mr. President. And Mr. President, as soon as Mr. Ramdial and the bill, it was amended while he was Attorney General, nothing was put in place to operationalize the law. No structures, the community residences were not built when he was Attorney General. And she came here, the Honorable Senator spoke about our oath and our rights, and we want to protect the people of Trinidad and Tobago. That same Attorney General that Ms. Lutchmedial-Ramdial spoke about had an opportunity when he was the Attorney General, when he amended this foster care law, to put mechanisms and measures in place to ensure that the law was operationalized. And what did he do? Nothing. But you know what he did in 2016, Mr. President? What he did, and cases beyond there, CV 2016-004370B by his kin and next of kin K versus the Children's Authority of Trinidad and Tobago, fully well knowing that he did not operationalize the law, fully well knowing that structures were not put into place to breathe life into this legislation, he ran to the court and he challenged the law, knowing of the indeficiencies that already existed in the system, because when he was the AG, he simply didn't do it. And that is not the only case, Mr. President. I recall, Mr. President, sitting in a courtroom when that same Attorney General was doing a matter. I sat there waiting for my matter to be called, and it was a matter along the same act. And I heard the judge, the presiding judge, say to the attorney, the lawyer at that point, but counsel, weren't you the Attorney General at the time when this legislation was passed? Wouldn't you know that systems were not put in place to operationalize the law? I could recall that, Mr. President. And that is why, just like the senator, I am so appalled that they will have the gall to stand before the people of Trinidad and Tobago and make the people of Trinidad and Tobago believe that they genuinely care. When they had opportunities to make it right, Mr. President, did they do it? They did absolutely nothing. What they did is that they knew the indeficiencies in the law and then run CV after CV, as Mr. Ramlogan continues to do, and challenge loopholes or lacunas that he knew existed in law, and when he had an opportunity, did not fix it.
46-1.
Okay, so Minister, as much as you're responding to statements made by Senator Lutchmedial and her contribution, again, I would ask you to wrap up that point and then come back to the bill.
Of course, Mr. President, and I am so guided. And I will move on, Mr. President. Mr. President, the senator spoke about, pumping her chest again about, on the last occasion, all they wanted was the removal of judicial discretion. And here, based on the dicta coming out of the Achilles Charles, we now come before this parliament to include judicial discretion. And I hear the submissions made by the senator. But what I also want to remind the public of, Mr. President, in 2022, when the bail amendment bill came before this parliament, it came with a sunset clause, with an extension. There was a 2020, the defeated bill had a clause extending the sunset by 2 years. So at that stage, at that time when we brought the bill to this parliament, at that time when we did not have we did not agree at that stage, because of course we had foreseen where crime would go, where criminality was going. When we did not agree to having this judicial discretion inserted in the law, let us also remember that that law also had a sunset clause. So when we did come to the parliament back then, Mr. President, and we did ask for the support, as draconian as the law may have seemed at that stage, Mr. President, it was because there was a sunset clause extending that bill by only 2 years. Because we believe that that stage, that 2 years would have assisted the crime-fighting agencies, the government with policies to put things in place in order to deal with crime. And certainly, I would say, when that bill came here, it was not because of the inadequacy of our Attorney General. And I want to applaud our Attorney General again for all the work that he continues to do, Mr. President, in the office of the Attorney General, in fostering and creating law, not and balancing law, Mr. President, because that is what law is about. That is what we are called upon as legislators to do, Mr. President. Sometimes we are called upon to make hard decisions, yes, because sometimes it is only with making those hard decisions we can protect the people that we took that same oath the senator spoke about. It is only then we could protect those people we took the oath to protect. So, Mr. President, I just wanted to place that and remind the members of the public in particular about back then when the judicial discretion was not included. Remember, at that stage, there was a 2-year sunset. Of course, the bill that appears before us, Mr. President, it does not include a sunset clause, and therefore, coming again from the guidance given by the Achilles Charles, the bill that appears before us includes that judicial discretion. Mr. President, and those were just 2 of the things or 3 of the things that I wanted, Mr. President, to speak to coming out of, as I said before, the member with the condition. Mr. President, as I continue, I want to quote from the case, from the dicta of a decision given by Justice Ramsumir-Hines. And Judge is one of those judges in the criminal courts that I have the world of respect for. And Judge said liberty is the normative position and detention has to be justified by those who would deny a person their human right. This was the words of Her Ladyship, Mr. President, of course, in the matter of the bail application of Mikhail Rupchan. And, in that particular application, Her Ladyship would have gone through, the facts of what ought to be considered by any court, by any judicial officer, in denying, of course, an accused his human right, which is, of course, the right to freedom, liberty, all of that. And in this position, in this case, Mr. President, of course, would have spoken to the law as it then was, Section 6.2 of the Bail Act. And Section 6.2 of the Bail Act would have identified for criminal law practitioners, not those who work for a few years in the DPP and purport themselves to be the best criminal lawyer that there is, but for lawyers who actually practice and actually defended in the criminal court, Mr. President, and very much familiar with the Bail Act. We would know that Section 6.2 sets out, it would have set out the parameters, Mr. President, and the factors to be considered by any judicial officer in the grant of bail. Now, Mr. President, some of those in the old one, this is particularly for the members of the listening and viewing public. In the old law, as we know, Mr. President, there were certain factors before a judicial officer decides to grant or not grant bail, would consider. Some of those included, let's say, the failure to surrender to custody, whether the accused would commit an offense while on bail, whether the accused will interfere with witnesses or otherwise, whether or not the accused will obstruct just the whole layer of justice, all right? And of course, those were some of the factors that would have been alluded to, or Section 6.2, Mr. President, of the Bail Act spoke about. Now, what is the new position? And I don't want to belabor the point because the Attorney General in his piloting would have gone through at length as to what are the provisions in the clauses of this bill that appears before us. But very simply put, Mr. President, for practitioners, bail practitioners, criminal law practitioners, you would know that once you go before the court and you make your application for bail, Mr. President, it was for the prosecution, of course, to object to the application that is being made. And based on the provisions set out in 6.2 of the old law, or the current law, it was for the prosecution to show, Mr. President, that one of these risks can occur and therefore encourage a judicial officer not to grant bail. The current law, Mr. President, as my senator, Minister Randall Mitchell always speaks to lawyering up the thing, to lawyer up the thing a little bit, Mr. President, what we have now, the position as of now, is that, for want of a better word, there's a shifting of the burden. And there's a shifting of the burden where now defense counsel is called upon to make a case for his or her client that appears before the court, identifying, Mr. President, of course, and that's where the concept of exceptional circumstances come into being, identifying circumstances which the court ought to seriously consider before deciding to deny bail for those bailable offenses. Now, as a criminal law practitioner, myself, Mr. President, why do I raise what the then was and what the now is because there was a sense of discomfort every time. There is a sense of discomfort in me every time I hear about bail and the restriction of bail, because I know what it is to pound the pavement. I know what it is to do bail application after bail application. I know what it is to, at one and a different incarnation, to be the voice of the voiceless. So, of course, once I hear you're looking at a piece of legislation that speaks to the denial of bail, the first thing comes to my mind is, of course, the right of the accused. How is it that the rights of this defendant, how is his rights and his liberty and his human rights in particular, how is it going to be preserved? And more than that, what are the other mechanisms that are in place, whether it's in the bill that appears before us or in other existing pieces of legislation that will protect his rights and will protect him? And, Mr. President, the exceptional circumstances provision that this bill speaks to satisfied me as a criminal defense attorney, Mr. President, that there is the door to bail and the granting of bail is not, of course, closed to the accused. And I would have gone previously, I would have briefly explained the practical aspect of where defense counsel, now the burden being shifted to defense, has an opportunity to present to the court these exceptional circumstances that he or she wishes the judicial officer to consider in making a decision as it relates to bail. So exceptional circumstances satisfied me as, of course, a defense counsel. Then further in this bill, Mr. President, there's also due process to the right of appeal. So what we have, there are clauses in the bill, Mr. President, that allows, even if that right to bail or that application for bail is denied, the accused person has a further layer of protection. And the further layer of protection, Mr. President, is where, of course, he can now appeal the decision the decision given by the judicial officer. And Mr. President, of course, that is something that satisfied me again as a defense counsel. But there are other existing, and this too is especially because I know there are families of the accused. I know that there are children who are fatherless, sometimes because their fathers are stuck in remand, yet many of whom I would have represented with, of course, my seniors in a previous incarnation. But I wish to remind those families who are concerned, apart from the provisions in this law, today, Mr. President, we have a judge-alone trial bill that is currently before an SSC, which intends to expedite matters for that same accused, Mr. President. I am satisfied there's also plea bargaining legislation that exists that can also assist that accused and the families of the accused who may be concerned that because of even though there is judicial discretion, there may still be the uneasiness of whether or not my loved ones are going to be granted bail. There is the plea bargaining provision legislation. Don't talk about a JIPA and what a JIPA has done for revolutionizing. Of course, it's in embryonic stages, but don't talk about a JIPA and especially scheduling orders that are given with a JIPA, which seeks to fast track and set the time frames in which matters are heard, Mr. President. Mr. President, and beyond that, there is the Public Defender's Department, and to that end, I want to recognize Mr. Seen Sheikh, who, of course, was honored by SC Senior Counsel Sheikh now, who, of course, leads a battery of young, bright lawyers, public defender lawyers under the Office of the Attorney General and the Ministry of Legal Affairs, who serve a critical function as the voice of the voiceless. So, Mr. President, as I said, one of the major concerns that I would have had, the AG would have done a fantastic job, of course, in piloting, going through the depths of the bill. But I want to remind the family of the accused, those who believe that their members are there in prison, may still be there for many years. Please understand that the exceptional circumstances provision, please understand that, of course, the due process provision with the right to appeal. Then I mentioned judge alone, which is at a SSC, plea bargaining at JIPA, the PDD, all of these, Mr. President. Mind you, all of these are pieces of legislation that were passed by this government, pieces of legislation that are structures that were created by the People's National Movement, which ensures, Mr. President, that while, yes, we try to prevent crime, while we try to detect crime, while we try to convict those who commit crime, that we balance it by ensuring that the voice of the voiceless is heard and that there are measures and mechanisms put into place to even protect them. And Mr. President, again, just because of my experience coming from where I came from, I joined to just make this brief contribution, Mr. President, to this debate. And I thank you most sincerely for the opportunity.
Senator Nakhid.
The General one.
In the name of God, most gracious, especially merciful. Mr. President, I cannot relate at all to being second best. As a footballer, as an academic, I could never relate to being second best. Thank God. I put that praise, all praises is due to Almighty God. So when I hear the contribution from Senator Cuthbert. Who is that?
Again, okay. Members, let us not get down into the doldrums and just be respectful all around when we're making our contributions. Senator Nakhid.
Thank you very much, Mr. President. As I continue, when I heard the contribution from the Honorable Senator, Minister in the Ministry of the Office of the Attorney General, when I heard her contribution, not only this one, previous ones, I have to, at some point, have a discussion with her to try and comprehend how it feels to be second best. How it feels to be in the shadow of someone like the Honorable Senator Jayanti. I would like to let her know that it comes from hard work. There's a reason that coming out of St. Mary's College, onto American University, onto the professional league, there's a reason that I was number one, and it involves hard work, commitment, sacrifice. Never smoked a cigarette in my life. Never drank in my life. Was always in bed at 10, 10:30, and not on somebody's boat in COVID that pretend to be a restaurant. I was in my bed. So I was number one, 3 times MVP of the Caribbean, twice National Player of the Year, 2 times player in Belgium. So I understand what it means to be number one. So I want to tell my colleague, Senator Jayanti, Lutchmedial-Ramdial, take heart. You are number one. Yeah. I would like to say, the Honorable Senator,
don't vote.
work hard. Yeah. Work hard. Don't speak about the condition of your colleague. It is not unbecoming in this August Senate. Yes, even I have never cursed in the Senate.
Oh my goodness.
I've always had my language restricted to what is worthy of the Senate.
Yes, absolutely. Never say profanities.
I continue, Mr. President. Mr. President, despite all these personal attacks, there was also some very, I would say, indecisive, misleading comments by the Honorable Senator about several cases. And I mentioned Patasar versus AG. You know, the PNM did not build the community residences to implement the good law passed by the Honorable AG and Honorable Logan. They just did not do it. That is a fact. You know, so here we go with this misleading rhetoric, in emotional hysteria, trying to convince the public of something that just did not occur. And that is typical of the PNM. When they like to talk about we pass legislation and we do that, do they not realize that the public is very well aware right now that you have been in control of government for 52 years? 52 years, and the country is a mess because of you.
Yes, that's right.
How you want to gloss that over and talk about things about that? We have a stalemate in the judiciary. We have problems with the DPP. It's because of you.
Correct.
Nobody else. People in remand yard for years. It's because of you. I don't understand why you all feel you all can convince people. This is not a long time. People on social media, you see when this Gen Z, you see them watching their phones. That's why they caught everybody unaware. America, everybody thought they were just looking at their phones, just Gen Z. But they were sharing information. And that's what they're doing about you all. They know that the PNM is a waste of time. You're coming here with personal attacks and all kind of things. No, we had enough of that. We're not taking it.
Yes.
We're not accepting to you to attack anybody here. And look, Senator Hislop.
Point of order,
Have a
Mr.
seat.
President.
Hold on, 1 second. Point of order.
6-1, Mr. President.
Okay, so the member is still just a few minutes in to his contribution, and of course he's allowed to create context. Member, as is the case, create your context and get on to the bill.
President, I think the senator before went at length to try and not only insult, which it was painful to hear, because you would expect at some point in one of her submissions she would make some sense. You would at least expect that. And Mr. President, I do not normally ask, but I always get from the minister these outbursts. The Minister of Industry and Trade. You know, please, can you, if you want.
Protection, yes.
You know, because
she can't control herself.
Somebody could be looking at.
Like when Obama reached.
You know, go and find the $26,000 check.
Like when you grab Obama.
We've had enough, Minister and members to my left. We've had enough of the crosstalk. It slows the process down and it interrupts the member contributing. Continue, Senator Nakhid.
And they're talking about, the Honorable Senator spoke about Achilles Charles, but he was murdered because of the incompetence of the PNM. Yeah. The availability of firearms to gang members caused his death, caused his murder. And they always try to reinvent a narrative, thinking that the UNC is asleep on the job. But the UNC is wide awake, unlike a Minister of National Security, who is responsible for all the crimes. You know, it's clear to us. Listen, Mr. President, sorry. When the Attorney Generals based a lot of his submission on recidivism, I thought, once again, when the PNM speaks, you have to imagine yourself in some alternate reality. You know, and they speak. And here was the amazing thing about the PNM, especially this version, is that they speak like if they just came into power, and they don't know who was in charge before, and they're not there for 52 years. Every single time they speak, we're going to do this, and we don't do that. And we pass legislation. And when you ask them, well, did you operationalize it? No, they didn't do that yet. So we have all kind of legislation that yet to be, and being disturbed by Senator. You know, so I am thinking, let's look at what are the real causes of the recidivism that the Honorable Attorney General alluded to. And it's not what he's speaking about. Because if you under-resource the DPP, which the DPP spoke about, you under-resource the TTPS, which they always complain about. No cars, no gas to put in the cars, no diesel to put in the cars, no pen and paper in the station. I hear these things personally myself, in Tinapuna, in St. Joseph, in Lavante, all of this. No bulletproof vest, no CCTV. As a matter of fact, the gangs have more CCTV cameras than the TTPS. I mean, what more can we expect from a government that has clearly failed in every area of security? Every area of national security. The best thing they have is this recurring rhetoric. All the time. They do this and they do that. And the whole country looking around asking, but what do they really do?
Buy some ladders.
What do they really do? They buy wooden ladders.
Don't even worry with that.
I will leave that one alone. Costing $1 million a piece. A pop. I mean, you really have to ask yourself, you know, Mr. President.
It's best you sit on rest because I feel want to debate.
I tired talk. I tired talk about it. But let me tell you, Mr. President, what a UNC government do. Very soon. First thing, we'll find a COP that is appropriately qualified. Not somebody that they handpick,
Police number 15.
compromise the Police Service Commission, intercept merit lists, all kind of...
So, Senator, at this point, you've made your introduction, you've created your context, and so you're a bit broad. Remember, we have a bill before us with specific clauses requesting certain actions to be taken, or the suggestion is made by the Attorney General in the piloting. So even as you continue, remember to bring it back or connect it to what is before us.
I'm connecting it to how we can deal with crime fighting to really and truly address what the Attorney General so at length spoke to. I mean, a lot of his contribution was based on recidivism. And I'm trying to...
Recidivism as it relates to bail and the granting thereof. Now, whereas talking about crime might be allowed because it is connected to the act of giving bail. You have to commit a crime to get in front of the court in order to ask for bail. It's not a crime debate. You understand where I'm coming from? So you have to connect it to the fact that we're dealing with bail.
Mr. President, I'm guided, but before you reach bail, you have to detect. And our detection rate has been abysmal under this government.
And drop it.
Before you reach bail, you have to have charges laid. I mean, correct, Mr. President? So we heard the submission from the member for Diego Martin West yesterday. 45 minutes, I think it was, about who did what in the other place, sorry.
Remember, you're in the Senate, eh? So as much as just a passing reference, we're not debating what they debated in the House. You are in the Senate.
I'm bringing it back. So I'm just saying, talking about charges have to be laid. So if you listen to the member for Diego Martin West, responsible, the head of the National Security Council, speak about all these people who are so at fault and have committed crimes and with the intention to topple the political directorate. That's a direct quote. And so at the end, I was waiting to hear who was charged. Nobody can get charged.
So no need for bail.
So no need for bail. But that is the point exactly. So all of this smoke and mirrors, once again, wasting people's time. You know what I think is best? Call elections now.
Yeah.
I'm bringing you ready. Call elections now. You know, and they can't.
You wouldn't know you didn't run.
Anyway, coming back.
One agrees. Come on. Let's call the election.
However, they refuse to look at the reality of it because.
All right. Have a seat. So the member with the offending device, please take a walk, turn it off, and you can return in about 5 minutes. As to the crosstalk, I'm warning once again, it's getting a little bit louder than my ability to actually hear Senator Nakhid's contribution. Senator Nakhid, continue.
Thank you once again, Mr. President. And I'll bring it directly back to some of the submission from the Honorable Attorney General. And he spoke about how, after the COVID, how recidivism rose again and all that. But that is so duplicitous and disingenuous, it's unbelievable. The reason clearly why that happened is that when these offenders were on bail, they came out, there were no jobs. The PNM had failed us economically. We lost 6,000 SMEs during the COVID, and they never did anything to revive that. That is a fact, 6,000. And more closing. And these are the socio-economic factors that I've spoken to time and time again in this August chamber. Time and time again. And they do not want to acknowledge that because it doesn't concern them. Their constituencies are the ones in dire straits. Their constituencies that they've represented for over 60-something years in dire straits, where all the problems coming from. The constituencies I grew up playing football in. And that's why I get angry with them. Because they do nothing. They do nothing to alleviate those problems. And you know, you see them laugh.
It's not a crime debate.
46-1, relevant.
Yeah, so Senator Nakhid, the bill is about the granting of bail and the procedures in relation to that. What you're doing is talking about pre-granting of bail, after the granting of bail, and some of the reasons centered around that. If you follow the clauses in the bill, you should be fine. So speak to the granting of bail and the procedures set forth by the Attorney General in the piloting of the bill. Continue.
And you made my point for me. The granting of bail happens when a crime is committed. And I'm saying crimes are committed because they have failed us in a socio-economic manner.
Senator, saying that is fine when you are creating the context in your introduction, which you have far gone past now. Every single senator prior would have done the exact same thing and then got into the merits of the bill by way of its clauses. You at this point would need to do the exact same thing in order to remain relevant. So, if you have a clause in the bill that you would like to speak to, I invite you to do so now.
Thank you, Mr. President. Guided. Given that you have given that advice, I think my colleague Jayanti, Lutchmedial-Ramdial, handled that excellently. So, my point, basically, were to be brief, Mr. President, and if the Minister of Trade and Industry, would lower her voice.
Then you could wrap up, yes. Let her find the 26,000.
All I would like to say, Mr. President,
where the laser them?
I think we have made a point that we fought for this bill in the Senate. We got the support from the independents. We forced this government to copy-paste and come back and pretend that they were the initiators of this bill, where they were defeated. And I would like to, once again, thank this intellectually bankrupt government for finally realizing what we were telling them over a year ago. And once again, we look forward to always supporting good legislation, Mr. President, as we do. And I thank you very much, colleagues.
Senator Vieira.
Thank you, Mr. President. Before getting to the meat of my contribution, it might be useful to remind ourselves, first, as to the purposes of bail, and secondly, what has brought us to this point, where once again we are being asked to amend the Bail Act. Now, in the criminal justice system, bail serves several purposes. The primary purpose is to ensure that the accused person appears in court for his trial and other related proceedings. By posting bail, the accused provides a financial guarantee that he will return to court as and when required. Bail can also serve to protect the community by preventing potentially dangerous individuals from being released before their trial. Significantly, bail allows for the release of defendants who are presumed innocent until proven guilty, upholding their constitutional right to freedom while awaiting trial. This prevents unnecessary pretrial detention and associated hardships. Finally, by allowing defendants to be released while awaiting trial, the bail system helps to reduce overcrowding in jails and the associated costs for housing, feeding, and caring for inmates. Now, overall, the granting or refusing of bail, like so many of our other laws, requires a balancing exercise between competing interests and sometimes incompatible ends. Bail balances, on the one hand, the need to ensure that the defendant appears for his court dates and safety of the community, and on the other hand, protection of the constitutionally enshrined rights of the accused. Now, the reason we are here today is because the Privy Council, in the Achille Charles judgment, of which more shall be said later, has now given clear and authoritative guidelines on how that balancing exercise should be addressed. An exercise which has proven troublesome in practice, given historical uncertainties and concerns regarding the jurisdiction of magistrates and judges under the common law and certain legislation. In the event, the Achille Charles judgment has necessitated a number of amendments to the Bail Act and some important procedural changes. And let me just join with Senator Lutchmedial in commending Mr. Anand Ramlogan, SC, in representing his client in the manner he did, because in doing so, he has rendered great service to this country. It bears noting that in the Achille Charles judgment, our highest court also addresses public policy concerns regarding the need to reduce violent crime vis-a-vis the risk posed to public safety by repeat offenders, as well as concerns about the local courts being too willing to grant bail to people who then commit further crimes or seek to intimidate, even eliminate witnesses. However, before extrapolating the key points and principles arising from that judgment, it may be worthwhile noting that they offer no panacea for many of the associated problems regarding the bail system, such as how it disproportionately affects low-income individuals who don't own property and are unable to provide even modest surety, how those who are unable to get bail may lose their jobs, homes, custody of their children while awaiting trial. The destructive effects of prison on a prisoner's family life and prisoner's family ties can have long-term impact on their lives and relationships, even if they're eventually found not guilty. And what happens to those on remand when they spend time in the university of crime, not just having to deal with insanitary and overcrowded prisons, but being in proximity with seasoned criminals? This legislation does not address the failings of our educational system, as Senator Richards has said, and the failings and shortfalls within the forensic and other support systems necessary for successful prosecutions. This legislation does not address the fundamental challenge of how we might create a society with more equality, inclusion, and opportunity for all. We cannot be blind to the injustices in society, a defining challenge of our time. But I digress. The bottom line is that the Privy Council's judgment in the Achille Charles appeal and this legislation before us, which follows as a corollary, are seismic in that they lay out a framework which conclusively resolves long-standing uncertainties and concerns. That judgment and this legislation will put to rest previously divided opinion within the judiciary, magistracy, and the legal profession on whether the executive and parliament can preclude the courts from deciding on whether an accused person can get bail. The point of contention in the Achille Charles appeal concerned the constitutionality of a law passed by this parliament, that bail may not be granted to any person charged with murder. Now, without getting into the details of the case, suffice to say that Mr. Charles had been on remand for over 8 years because of the vicissitudes of the system. The nature of his constitutional challenge required the Privy Council to evaluate the separation of powers doctrine insofar as it applies to bail, to address public policy concerns behind the Bail Act, and to consider whether a blanket prohibition of bail is permissible or unlawful. Now, I would summarize the key points and principles emerging from the judgment of the Privy Council as follows. At common law, the higher courts have always had the discretion to grant bail, even in murder cases. Under certain laws, a magistrate could not grant bail to a person charged with treason, murder, or piracy. But those laws do not and cannot preclude judges of our higher courts from so doing. There is no prohibition on the grant of bail in such cases under the common law or under the applicable legislation. Parliament can pass laws which are reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual, including laws which limit fundamental rights, in particular, the right to liberty, once they are necessary in the public interest and they are proportionate. The proportionality test to be applied involves asking in relation to a measure, and I'm quoting from the Privy Council judgment, 1, whether its objective is sufficiently important to justify the limitation of a fundamental right. 2, whether it is rationally connected to the objective. 3, whether a less intrusive measure could have been used. And 4, whether having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. This is an adaptable test which is to be applied with due allowance for the particular context in which it falls to be applied. The Privy Council accepts that remand in custody is rationally connected to the identified objectives. As they put it, a person in custody is incapable of violent offending, repeat offending, or absconding. Being in custody will also make it more difficult to interfere with witnesses or otherwise obstruct the course of justice. However, blanket prohibitions which treat persons charged with listed offenses indiscriminately, denying the possibility of bail, whatever the circumstances, and however compelling the case for bail may be, well, that's unconstitutional. Blanket prohibitions against the granting of bail are unconstitutional because they operate in an arbitrary and potentially unjust and unfair way. They are unconstitutional because they infringe a number of the rights and freedoms recognized in sections 4 and 5 of the Constitution, including the right not to be deprived of liberty except by due process of law, the right not to be deprived of reasonable bail without just cause, and the right not to be deprived of procedural protections necessary for giving effect to the Section 5 rights and freedoms. So the Privy Council, and now this Senate, recognizes that the right of access to the courts on bail is a critical right. And while the courts are expected to be respectful of the choices made by Parliament to pass legislation which might limit the right to liberty, and while the courts are expected to give great weight to the judgment of Parliament regarding the importance of the public interest which is sought to be promoted by the measure in question, the courts are neither a tool of government policy nor a rubber stamp for Parliament. Ultimately, it falls to the courts to determine whether an accused should be granted or refused bail. Each case must be judged on its own merits. There can be no one-size-fits-all approach. Now, when weighing the balance to be struck between the rights of the accused and the interests of the community, Section 5 of the Constitution requires the court not to deny bail without just cause and to be mindful of the presumption of innocence enjoyed before trial. So, this is a serious, thoughtful, and innovative piece of legislation in how it attempts to reconcile competing ends, while staying within the parameters of the ruling in the Achille Charles judgment. First, it recognizes that bail can be granted to any accused, so there is no derogation from any of the fundamental rights. Secondly, it ensures that when applications for bail by persons charged with murder, firearms offenses, and other serious offenses, those applications are dealt with by a judge or a master. Thirdly, the bill seeks to impose conditions on the exercise of the court's discretion in granting bail to persons charged with serious offenses. And where a judge or a master grants or refuses bail, Clause 6 requires them to give reasons for granting or refusing bail or for imposing conditions. Last but not least, the bill importantly reverses the burden of proof. Yes, a person accused of murder and other serious offenses can apply for bail, but the court will not grant bail unless the accused can show sufficient cause why his remand in custody is not justified. The burden of proof now lies on the accused to show exceptional circumstances to justify the granting of bail. I believe that this legislation recognizes the proper boundaries between the judiciary, the executive, and Parliament. We are all partners in a common enterprise involving upholding the rule of law. The courts have their role to play in addressing the crime situation. Our judges are not blind to the crime crisis afflicting our country. They share the same space with us, and they're also affected by it. But as guardians of our democracy, our judges are duty-bound to uphold the constitutional guarantees in respect of fundamental rights. This legislation offers a blueprint to address legitimate public policy concerns regarding the rise in the incidence of violent crime and the risk to public safety posed by repeat offenders, while at the same time ensuring that fundamental rights are not abrogated or abused. A court is more than a courtroom. It is a process and a spirit. It is a place of law. Our judges understand the need to protect our citizens from violence, and we must have confidence in our courts that they are perfectly capable of protecting the public interest. This legislation has due and proper regard for the complexities of the situation. I see it as a small hinge, but as the saying goes, small hinges open big doors. This legislation will go a long way in enabling our courts to address some of the complex challenges arising in bail applications. I thank you.
Senator Hislop.
Thank you, Mr. President. Thank you for the opportunity to contribute. Even though it will be very brief contribution, Mr. President, I want to thank you for the opportunity to contribute in this debate. Mr. President, I want to firstly start off by thanking Senator Vieira for his sober words and restoring a level of dignity to the debate this afternoon. A couple of things that stood out for me in Senator Vieira's contribution was that the legislation or the bill recognizes the boundaries in the separation of powers. Also, the balance of the public public concern whilst the rights of even the accused are recognized. And I want to say that I believe the government has found, and I want to compliment the Attorney General and his team for finding what I will consider the balance, as you so aptly put it, Senator Vieira. And the old adage that you used, I remember my father used that some years ago when I was small hinges, open big doors. So he says you just have to take your time and do what you do. Things are going to happen when it is supposed to happen. Good advice. And I sat intently listening, Senator Vieira, through you, Mr. Vice President, and I believe that coming from you, I believe that not only you, Senator Vieira, get it, but I believe the majority of the public of Trinidad and Tobago gets it and understand what this government is attempting to do with this legislation. There are those who may shout and tout bombastically all sorts of things, but this government gets it. I painfully, at some point in time, it's a debate, Mr. Vice President, so I have to respond to Senator Nakhid. I am challenged by the fact that someone who claims to be a #1 intellect, #1 academic, what we had was a #1 intellectually bankrupt contribution. Because, well, he distinguished himself, Mr. Vice President, by having to sit after he recognized that he had nothing to contribute. Coming from, quote unquote, a self-proclaimed #1 academic. That is very unfortunate. I would have expected that at least some sort of contribution to the bill would have come. And when the opposition constantly seeks to say that the People's National Movement have been in governance for 52 years in this country. And we are proud of our record of governance in Trinidad. We are proud of our record. We are proud of the work that has gone in those 52 years of development, because I am sure that most of those sitting opposite benefited from policies of the People's National Movement, even though in some regard, Mr. Vice President, it appears that they did not make full use of, especially the education aspect of the policies of the People's National Movement. Well, when the UNC attempts, Mr. Vice President, to talk about what they will do, we have a clear example of what the UNC has done. When, Mr. Vice President, I sat very quietly and listened to Senator Lutchmedial-Ramdial's contribution.
Just kindly maintain a minimum crosstalk, and if so, keep the volume down.
Thank you, Mr. Vice President. We've seen what members opposite have done, so we don't need to try that experiment again. Because for one thing I know, fortunately, unfortunately, the bail amendment bill doesn't cover fraud. And so members opposite who now sit on bail would have to, in the other house, would have to just deal with it when it comes in due course, Mr. Vice President. I'm going to be, as I said, I'm going to be brief. I said the government has found a balance, and I am truly impressed by what, I'm no lawyer, but I'm impressed by what has been brought to us today. We are in the presence of great legal minds. But one thing I can say is that this bill goes beyond the legal aspect of things. This bill redounds right down to the man on the ground, to the small man who will find himself or may find him or herself, unfortunately, in a situation where they may have to go before the courts. And as Senator Vieira rightly said, the bill creates that balance, that if you, even for the accused, Mr. Vice President, because if you go before the judge or the master and you find yourself in problems, it is not that you are prevented from getting bail even for a serious offense, Mr. Vice President. And I am happy for that, because we have to ask ourselves the question, and I'll give credit to Senator Lutchmedial-Ramdial. When we asked the question, is bail a right or a privilege? And what we've done in this piece of legislation is created that balance that says that should speak to the fact that you have a right to access. But you, as the accused, still have a burden of proof as to why you should receive bail. Today is a day of phones, Mr. Vice President. You see, the bill, Mr. Vice President, seeks to impose an enhanced reversal burden on persons charged with the offense of murder and firearm-related offenses. So you've been arrested, stands on the foundation that you are innocent until proven guilty. But in order for you to walk out of the courtroom, you, as the accused, would have to prove to the court why. Why should I be, and as it puts it in the bill, exceptional circumstances. Why should I be considered as a citizen who could, even though I would have, quote unquote, committed a crime, how I could still walk amongst the population until my trial date? And so, for that, it gives the population that, hey, the government is serious about fighting crime, because we are making the strides towards making it even more difficult for persons who are accused of serious offenses. And I want to make that very clear in this. The bill makes it very clear that you have to be charged for a serious offense. And they all listed it. They all listed what that would look like. An offense committed by a person over the age of 18 or over the age of 18 years under the Anti-Gang Act. We know the situation in our country where it has been recorded that we have over 100 gangs. And so the gang culture is a serious scourge on our country. An offense under the Offenses Against the Persons Act, which covers a wide range of offenses. The Dangerous Drugs Act, the Kidnapping Act, and all of these, Mr. Vice President, are significant offenses. The bill seeks to repeal the existing Section 5 of the Act and substitute a new Section 5. If I could just jump very quickly, because I don't intend to be very long, Mr. Vice President. It says, subject to subsection 3, 4, and 5, a judge or master may grant bail to a person who is charged with the offense of murder before, on, or after the commencement of the Bail Amendment Act 2024, where he can show exceptional circumstances to justify the granting of bail. I just want to jump to I think this is what, subclause 3, I think it is. A judge or master may not grant bail to a person who, on or after the commencement of the Bail Amendment Act 2024, is charged with an offense specified in Part 2, or a previous conviction for an offense punishable with imprisonment for 10 years or more, or pending a pending charge for an offense listed in that part, unless he can show sufficient cause why his remand in custody is not justified. So again, Mr. Vice President, we make the point that you, as a citizen, even though you are an accused, you have right to access bail, but you have to show exceptional circumstances. And in those circumstances, you can be in a situation where you are a single parent, the only parent of maybe a minor, and you don't have close relatives who can take care of that child. We don't want a situation where your child ends up in the system, and we may just be creating another person to come into the criminal system. The person can also be a situation where the individual is terminally ill and requires significant medical attention. But again, Mr. Vice President, you have to show, you have to prove, and not only prove, but we also have to remember that that is at the discretion of the court. One of the final things I want to touch on, Mr. Vice President, is where it says in the bill, listed in Part 2 of the first schedule, except an offense under Section 6 of the Firearms Act, where the prosecution informs the court that the person or any other person involved in the commission of the offense used or had in his possession a firearm, imitation firearm, or a prohibited weapon during the commission of the offense. Mr. Vice President, we have seen in Tobago a significant uptick in gun crimes, gun-related offenses. Not only murders, but recently, within the last week, there was a shooting in Bethel. 4 persons were shot. And unfortunately, the gun culture has creeped into Tobago. We have information coming from the TTPS shows that between 2022 to 2023, we've had an increase of murders in Tobago. 2022, we had 10. 2023, we had 14. And at present, for 2024, we are at, I think it's 11. That's unfortunate. And the data shows that even sexual offenses, kidnappings, and if I'm supposed to also look at possession of firearms and ammunition, there has been a marked increase within that period. And so this is what this type of bill, Mr. Vice President, is seeking to treat with, is seeking to give that balance, as I said, that it shows to the population that the government is interested and is engaged with regards to our crime situation in the country, but it also does not take away the rights of the accused, because they're still citizens and they still have to have their day in court. And so, Mr. Vice President, I want to thank you for the opportunity to contribute. I believe that this is good law, and as the opposition has said over and over again, they are willing to support good law, and so we are hoping that for the benefit of the public of Trinidad and Tobago, they follow after their colleagues in the other place and vote wholeheartedly for this bill before us today, Mr. Vice President. I thank you.
Senator Sunity Maharaj.
Thank you very much, Mr. Acting President. Senator Hislop asked the question whether bail is a right or a privilege. I can't answer that, but what I can answer is that the right that we have is the right to liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof, except by due process of law. So this law, this bill that is before us, what we are engaged in actually is part of that due process of amending the legislation by a special majority to facilitate the non-granting of bail for a longer period. And that is something that is to be taken very seriously. Senator Lutchmedial-Ramdial spoke about the kind of trolling and the attacks she expected when she stood up against the automatic 120 days in a previous debate, and where this attempt failed. Because it is, I have no doubt it is a popular opinion in the face of unbearable crime for people to come to the position that you should just lock them up and throw away the key. And as painful as it is about every fiber of your being sometimes, that you want to, that you're being drawn to that position, you have to hold as though you're in a hurricane, hold on to the trunk of the tree, to the fundamental rights that we hope to one day get ourselves back to without having to encroach so often. Governments sometimes think that the public interest is the same thing as the government interest. And that governments know, obviously, because they've been elected by a majority of the people who vote, that they're on the solid ground. I want us not to miss the importance, really. I don't want us to miss what we sacrifice and what we are sacrificing in this period of intense crime, unrelieved crime, when we decide to allow the police to be able to lock people up for more than is the norm. We are sacrificing. It may seem to many people this is something you should do, in fact, do more of it. But I'm inclined to believe that the people who say that, they might be victims of crime, and that is probably more understandable. But many of those people do not believe it will ever happen to them, that they will be locked up. And it could happen to them, it could happen to their children, it could happen. And they think it's so because certain people just don't get locked up. You know, if you just look at the jails, who are the people who are going to be, who we expect to be locked up? We're talking about gangs. But are the people who are bringing in the guns, the people who are fueling a whole underground economy, are they expecting to go in jail and stay for that period of time before they can have the option to go before a court? And that is where I want to place my contribution today. That the police service has to understand what we are sacrificing to give them this, and that we have expectations of them and their performance. The police have to come back. We should ask for these reports. I don't want to hear how many people are arrested as though that is a triumph. I want to hear how many people are convicted. Because we have had, there was a period that we were parading before the television station how many people were arrested, and all those people eventually got out, and a lot of them got money as a result. We want to hear how many people, and if in fact the police can come back and demonstrate that this has allowed them the opportunity to actually build cases and win cases, then we may find that we don't need this kind of legislation, because the police would have got themselves to a point where they can actually detect crime, build a case, find the evidence, and have those people in jail. We want the people who are putting us at risk every day. You know, I do feel that any of us who is alive is because nobody wants us dead bad enough. Because anybody want me dead bad enough, all they have to do, I have no gun and I have no particular security and nothing. They just don't want to kill me yet. That's how I feel. Right? That's how I feel. And so the police must know that they are under watch by us. This parliament, we have gone and given them a piece of something, a sacred right, the right to liberty, the right to enjoyment of property, the right not to be deprived thereof, except we've gone an extra mile. We have given them that before. And look where we are. Any senator here who's under 27 years will remember, well, not, you won't remember. I don't think Helon might remember. But within our lifetime, the murder rate was under 100. Under 100. That we have crossed 600 is unbelievable. So I will support this, but with a great deal of pain. I want to see that this power that we are giving away, that it amounts to something. And it cannot be that we're just going to ask in perpetuity and becomes a norm, because the public is so scared, angry. And if the police can get, if all, not just the police service, I think Senator Lutchmedial did a good job by tracking down why these cases, why they're failed.
Would the senator give way for a question?
Sure.
May I ask, what is the power that is being given away? I just don't follow that. You just said that the power is being given away. I genuinely don't follow.
Well, I'm talking about the presumption of your right to bail. That I think that isn't it going to become more difficult to access bail? I know that the judge is going to have that discretion, and we are giving the judge exceptional circumstances, and we don't want to define that, right? And so that is where I'm saying we are tightening, and that's the whole point, to narrow the space. Okay, so that all the bases on which people, because I heard the Attorney General talk about, repeat offenders, right? The repeat offenders. We don't want those. We don't want our, we don't want people to be raped and killed and so on, because people are getting, repeat offenders are getting, getting bail and coming. But I don't want that to happen from a first offender either. I want to be safe. I want us to be safe. So we have to deal with crime, not simply the people who commit crime, and therefore the scope for them on the basis of that they have committed a crime. A judge will say you've committed a crime and so on. We're narrowing that space. I want to deal. We are here with this piece of legislation because crime, not repeat offense, but crime has reached a level that is untenable, scary. And so this is a piece of legislation, but there is so much more that we cannot legislate that lies in the hands of the management of the different elements of the protective services and the administration of justice that have to be activated with this little space that we are giving them here today. It has to transform itself into some level of success. We have to see some corresponding reduction. So I think my point here is, let us not take it as something that we take it lightly, or the norm, or it becomes the norm. Our efforts must be to use this opportunity to rein in crime so that we can pull back and restore our rights, our full rights under the Constitution. I thank you.
Senator Francis.
Thank you, Mr. Vice President. Thank you for the opportunity to contribute to this bill. The Bail Amendment Bill seeks to make substantial changes to the existing Bail Act. It aims to tighten the conditions under which bail can be granted, particularly for serious offenses, while enhancing judicial transparency and accountability. Now, allow me to give a short story why this might be so important. I can remember some years ago, I had a friend of mine who was put in jail for something as simple as maintenance. I'm just saying, it depends. Now, he was put there, and the way he related the story was, while being there amongst hardened criminals, he would be asked sometimes what he was there for. And his response was always the same thing: murder. Murder. But he said that out of fear. Out of fear. It started changing who he was. Right. So you see why this is so important. Of course, the intent of the amendments are good. And no one can argue that it is an appropriate time for the amendment to be made, especially given the current situation in the country. That said, for me, this bill is less about crime and criminals itself or the administration of justice, but more about the citizenry, insulating the public from any impact of administration of justice, which quite frankly they should be protected from and not have to care about. It may be shocking for us to know, but in many countries, the crime section in the newspaper is often overlooked. Not that there is no news in it, because there is. But if you don't have anything to do with the crime, it is absolutely no concern to you. Unless it's an extraordinary circumstance or something sensational, people skip past that section of the papers and simply assume that whatever the situation is, justice will be administered, and that is their culture. But not here. In that regard, this bill and its amendments is less about the people inside the system of the crime administration and more about the people that are outside going about their business. It is about the culture of crime. Because crime creates a culture in society, and it stems from how the law-abiding citizens that have nothing to do with crime shape a culture depending on how they perceive its impacts. But everything in life comes with a cost. We can't forget that when the next debate on the budget appropriation comes up this year, the Honorable Minister of Finance will start to tell us about the millions that he seeks to approve for. Only then we will understand the impact of that cost. I anticipate that the proposed amendment, while aimed to enhance public safety and judicial transparency, which is paramount, it will require significant additional resources to administer justice effectively. It must. The corresponding budget provisions will have to be made. So it is crucial for policymakers to consider these resource implications and ensure that the judicial system is adequately funded and staffed to handle the increased demands. Otherwise, less funds available for a bigger process can lead to even more loopholes, delays, or other problems. I'm not an expert on criminal administration and the costs associated with the same, but we all know that legal fees and other direct or indirect costs associated with more robust justice administration can be significant. Significant. We see the figures in the papers from time to time about legal bills that the government incurs on different matters, 50 million, 70 million, and perhaps over time, that is only the tip of the iceberg, since there is no doubt many other costs that occur with legal fees. Some may say that is the course of justice, or is it perhaps the course of the absence thereof? In terms of efficiency, fairness, and the clarity of law being most important. Because some will argue that a lack of clarity in the law is where legal fees blossom. That said, how does it compare to the cost of the innocent lives lost and the fear instilled in the public? Not just for those who are victims and witnesses to the crimes that these amendments are meant to address, but to those picking up the papers every day and talking in the maxis or in the lunchrooms, in these intimate spaces. These are the places and moments that culture is changed. When people lose faith in the justice system, it really ain't happening to them yet, but God forbid about that misfortune. Especially if it will happen to be their family or put their livelihood at risk. See, crime has changed our culture. The most dangerous weapon the criminals have is not guns or the things we see on social media. The most dangerous weapon is their power to instill fear without any sort of repercussion whatsoever. Now that is what is perceived. See, that is the perception and not the fact. But it doesn't matter, because you know what they say. Your perception is what sometimes becomes your reality. So with this bill, along with the whistleblower, there is possibly a change in our culture. So it leaves a question. Is this going to be another effective conversation, or is this going to be an effective implementation? Thank you.
Minister in the Ministry of Works and Transport.
Mr. President, I want to welcome you back into the chamber. And Mr. President, before I get into the meat of my contribution, I want to offer congratulations to our neighbors to the north, the United States of America, for celebrating 248 years of independence today, as July 4th. I want to put that on record and congratulate our neighbors to the north. As well as, I would like to offer condolences to the family of Miss Shanti Paladi, who belongs, or she's the matriarch of the Pennywise group of companies. She recently passed away. Pennywise actually is one of the formidable companies that helped shape and mold our country for what it is for today. And Mrs. Shanti Paladi, who was an avid Hindu and Sai devotee, recently passed. She actually passed just before visiting some sites where they were building houses for the unfortunate ones. So her name should go down in the Hansard of this country. Mr. President, before I get into the meat of my conversation, and I want to thank you again for this opportunity to contribute to this bail amendment, Bill 2024. And the purpose of the bill is to amend the Bail Act, Chapter 460, to make provision for the restriction of bail to persons charged with serious offenses. And some of the positive outcomes that we're looking for is to help speed up the justice system and also to curb recidivism. You know, I heard Senator Nakhid went on his rant, and he gave us an accolade of, he went to St. Mary's and he went to United States to be educated. I as well went to Presentation College of Honors, which is no less. I also was educated in the United States. I also don't drink, smoke, and I'm a member of the 5 a.m. club, so he could say what. The only thing I know, I came out with a degree in both engineering and an MBA in international business, why he's known for kicking ball, right? So he could kick ball from now until Lebanon, and I don't know what other success he could come up with, right? But again, right, he wanted to talk about what we do. 52 years of PNM. Let me just read something for you, Honorable President. In an IDB report in 2016, increase in rape, incest, and other sexual offenses in 2012 could be explained by the state of emergency declared from August 21 to December 5th, 2011, in their effort to reduce crime. During the state of emergency, it was illegal to be outdoor at nights. Past research has shown that a large proportion of sexual offenses are committed by persons known to be the victim. In this case, an unintended consequence of the state of emergency which they impose, right? This was the outcome, and there were victims. Actually, there's even more to that, Mr. President, and if you allow me to quote from the United States Department Bureau of Democracy and Human Rights Labor, in a 2012 report, the Anti-Gang Act bans membership of criminal gangs, gang-related activities as defined within the statute, and permits authorities to hold suspects detained under the law without bail up to 120 days pending filing of specific charges. Authorities detained approximately 450 suspects during the 2011 state of emergency pursuant to this act. The government eventually released nearly all of them when prosecutors determined that evidence of gang activity pursuant to the law was lacking in most cases, and they want to say our 52 years of governing this country did nothing. Well, you can imagine what the 5 years they did, and imagine putting them again for another 5 years, what will happen? But we know, you could kick your ball somewhere else. Mr. President, I have the pleasure to sit amongst the Joint Select of the National Security, headed by the Member of Parliament for Wallace South, the Honourable Keith Scotland, who recently was awarded Senior Counsel, a well-deserved Senior Counsel. I would like to congratulate him on it, and also co-chaired by our Honourable Senator, Dr. Paul Richards. And we had, at one of the Joint Select meetings, the judiciary, right? And I want to just give a basic summary for the general public to understand the matter at hand, right? When you're talking about matters, there are three matters when it comes to judicial review. There's the summary matter, there's the indictable matter, and there's the triable either way matters, right? Depending on which of you go to whichever court. There's the district court, and then the district court judge, and there's the high court judge. Now, when we're dealing with the indictable matters, right, for preliminary inquiries, there's a hearing, not a trial, where evidence is provided for cross-examination. Next process.
Mr. President, on a point of order, please, Standing Order 51E. I'm trying to hear my colleague, but it seems everybody over there have a condition of noise or something.
standing order again, 50.
Yeah.
51E.
51. Noise, just noise.
Okay. So it's a standing order in relation to silence when a member is contributing. And of course, as I always state, we'll just temper the level of crosstalk and hum and noise while a member is contributing. Continue, Minister.
Thank you, Mr. President. You can see all that ball kicking has affected his hearing, maybe his speech impediment. But coming back to my contribution, Mr. President, this, when it comes to the Indictable Act, after it moves to the evidence gathering stage, there's a trial where individuals before the High Court are able to apply for bail, especially in serious crimes and offenses, and somewhat like murder. Now, given the master the approval, right? Now, as an engineer, understanding all the legal jargons, I would like to make it a little more simple by breaking it down to understand how the master operates like a project manager in such cases, right? And project manager where he coordinates the paperwork for both sides and then present everything so that everything is in a line and in accordance so that they can continue with the proceedings. The master now given the ability to come forward and have the ability to look at granting bail, especially when it comes to the exceptional circumstances, is now a way forward in pushing us to achieve what we want by providing speedy justice. The master who was overseeing or who chaired and represented the judiciary, Ms. Christiane Morris Allen, who was the court executive admin and a master as that, she explained to us that between May 2022 and May 2023, and she listed the amount of cases that were put forward and how many grants in terms of who got bail or granted. So, for instance, and I'll just quote it by months that'll go forward, 27 were listed in May, starting from May 2022, 27 listed, 6 granted, 87 listed, 3 granted, 70 listed, 4 granted, 67 granted, 4 granted, 65 listed, 5 granted, 38 listed, 2 granted, 46 listed, 3 granted, 53 listed, 5 granted, 58 listed, 0 granted, 54 granted, 3 granted, 61 listed, 3 granted, 46 listed, 1 granted, 26 listed, 0 granted. A total of 39 individuals were able to achieve bail in that year. This bill seeks to amend that and to look to increase that number so that we can get the wheels of justice turning once more. And again, and I understand where Senator Lutchmedial was speaking, and I do sympathize with her when she comes to the fact of people who suffered at the hands of these rapists. I can tell you, I have a great aunt, a great aunt that actually suffered. She was 80-something years old, and she suffered at the hands of a rapist. Wow. Until the day she died, and she died with a broken heart. Wow. It's not something nice. The individual, when tried, they realized that mentally unstable. And it goes to show how many cases come forward. Wow. So, Mr. President, this bill is not only timely, it is also something that will help us in the arsenal of fighting the burgeoning crime situation in this country. And it's not like our government isn't putting our best foot forward. We are trying our best. Unlike what Senator Nakhid said, who knows how to kick his ball good. But, coming back to my point now, what I just want to say in my winding up, because I don't want to be long, it doesn't matter because it has been elaborated through and through. I know Senator Lutchmedial spoke about the license plate detection, and I want to tell the goodly senator that from the Ministry of Works part, we are rolling out a process. The thing is that the first step was to get license. In order digitizing the process, we combed through the entire process of terms of license plates and matching that they have matching chassis numbers with them. So those that are duplicated are actually stamped out. This is all in a process of our crime fighting initiatives. It is not a hoax. We are there and we will do it with the help, with their help or without their help. But I know where our government is focused. With that, Mr. President, I thank you.
Senator Thompson-Ahye.
Thank you, Mr. President, for granting me the opportunity to participate yet again in this week of back-to-back debates, but duty calls. And I had a beloved relative named Horatio Richardson from Vieira, although he was not the original Horatio Nelson, whom I quote, he too would have said, the Republic of Trinidad and Tobago expects every woman to do her duty. So I'm here to do my duty as best I can. This is not the Battle of Trafalgar, though. It's a battle between rights in our Constitution. The Constitution is the supreme law of Trinidad and Tobago. Any other law that is inconsistent with this Constitution is void to the extent of the inconsistency. Those are not my words, but are the words in Section 2 of the Constitution of the Republic of Trinidad and Tobago. Section 5(1) of the Constitution states, except as is otherwise provided in this chapter and in Section 54, no law may abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognized and declared. Section 5(2)(f)(3) states, without prejudice to subsection 1, but subject to this chapter and to Section 54, Parliament may not deprive a person charged with a criminal offense of the right to reasonable bail without just cause. Section 54 provides for the Parliament to alter certain sections of the Constitution, including that same Section 5, provided that when the final vote is taken, it is supported by the votes of not less than 2/3 of all members of each House. The bail amendment bill before the Senate today seeks to tamper once again with Section 5 and substitute certain additional conditions for the granting of bail. What this amendment is seeking to do is to continue to erode the constitutional right to bail, the presumption in favor of bail, and substitute instead a new regime of bail under certain specified conditions. Let's look at the how and the why of the proposed amendment. This bill is seeking to have judges and masters deny bail to persons charged with murder unless they can show exceptional circumstances to justify the granting of bail for certain indictable offenses and hybrid offenses where those persons have previous convictions for offenses punishable with imprisonment for 10 years or more, or is charged with offenses specified in Part 2 of the first schedule and so on. I can do no better than to repeat what the framers of the bill have given us as the rationale for this bill. The purpose of this bill is to amend the Bail Act, Chapter 460, the Act to make provision for the restriction of bail to persons charged with serious offenses. The bill seeks to give effect to the ruling of the Privy Council in the case of Achilles Charles and State 2022 UK PC 31 by providing that a judge or master may grant bail to a person charged with the offense of murder. The bill also seeks to impose conditions on the exercise of the court's discretion in granting bail to persons charged with the offense of murder, serious offenses listed in Part 2 of the first schedule, and firearm-related offenses. Further, the bill seeks to impose an enhanced reversal of burden on persons charged with the offense of murder and firearm-related offenses to require such persons to show exceptional circumstances to justify the granting of bail. The bill also seeks to require a review of the Act to be conducted every 5 years after its commencement. Finally, the bill seeks to provide that bail granted to an accused under Section 5 of the Act will continue to apply after this bill comes into operation. We should not be surprised that this legislation is brought to the Parliament. The Prime Minister does not speak idly. He is not as secretive as some believe. He is good at signaling his intentions, if we would only listen. In his conversation with the Prime Minister on May 23 at the Scarborough Library, as reported in Newsday on May 25, in Corey Connolly's story, headlined "Justice Favors Criminals," the Prime Minister expressed his frustration at the criminal justice system and, to quote Connolly, expressed his displeasure at the state of affairs in the judiciary when it came to bail for certain serious crimes. Now, although the head of the criminal bar expressed shock at the Prime Minister's statement, many agree with the Prime Minister. How many times have we heard that a person who committed a crime was out on bail or had more than one firearm offense? Clause 4, which amends Section 52A, at first glance seems harsh. To deny bail to someone charged with murder or another indictable offense, to deny the liberty of a subject not convicted, are not matters to be taken lightly. It is not beyond the skills of a lawyer, faced with defending someone charged with murder, to show exceptional circumstances to justify the granting of bail. In the one murder case I did, after which I vowed not to do another, my 17-year-old client was badly wounded. It was a clear case of self-defense. At the magistrate's court, the prosecutor, a true minister of justice, told the magistrate, in fact, Nanette Ford John, who became a magistrate herself, that she agreed with me. The prosecution had not negative self-defense, but it was sent for a jury trial. It was probably the shortest time in our history in which a jury returned with a not guilty verdict. Despite the summing up, which is another story for when I write my memoirs. On the second day of the trial, the police commissioner had said, "You win that case already, girl," even though it was a police officer's son who had been killed. But what I must say, that both parents were extremely honest on the witness stand in answering my questions. Yet, my client had to spend 3 years in remand, and I do believe that affected him for life. The amendment to Section 5.3, which speaks to non-grant of bail for certain serious offenses, punishable with imprisonment for 10 or more years, or where the person has a previous conviction or pending charge of that nature for such offenses, unless he can show sufficient cause why his remand in custody is not justified, is another case calling for skilled lawyers. Not in short supply in this jurisdiction, given the flood of SCs and SCs in waiting in our jurisdiction. The amendment to Section 5.4 gives testimony to the fact that firearms are the weapons of choice for murder, for robbery, and other serious offenses. The amendment to Section 5.5 is directed towards the administration of justice personnel playing their part, because it looks at evidence being taken within 180 days. The time requirement seeks to balance out the right of the accused as against the seeming harshness of the legislation. It places responsibility not only on those who are presiding, but also on the investigative arm of the state, who frequently do not play their role as efficiently as they should. And I would like to make a public call for police officers who play the fool to be removed from the service. I know a case where police interviewed a witness. The witness contradicted a statement given by a suspect. The police said they would return to take a statement from that witness. 4.5 years, have passed. The witness still waiting for the police to take the statement. The amendment to Section 5, 6, and 7 show a recognition that people can and do change their lives around, and I commend the Attorney General for its inclusion, because if you have not offended for 10 years, you could safely say that there might be some lady in your life who has helped you to turn your way around, your life around. The amendment to Section 5.8 calls for the civil standard of proof rather than the criminal standard of beyond a reasonable doubt. This is noteworthy, and in the circumstances, it shows a willingness to alleviate the seeming harshness of the law. Clause 5, which amends Section 6A, extends the jurisdiction of the Bail Act to Masters of the High Court. And that is sensible, because then you have more judicial personnel available to deal with the large number of cases that we have. Clause 6 inserts a new Section 9A after Section 9 to provide for the judge or master to give reasons for granting or refusing bail or imposing conditions, and to include those reasons in the decision. This will be of immense value because it will facilitate any decision you have to make regarding the appeal. If you know the reasons, and you know they are cogent reasons, then you will know I should appeal, although there are people who appeal for no good reason whatsoever. One lawyer told me that time, I said, you can't win this case, why are you appealing? Yeah, I mean, client giving me money, girl. Anyway, that's what happens sometimes. Values. Clause 7 provides for review of the Act every 5 years, and for that review to be laid in Parliament. And this is important, because as things change, you find that you notice certain trends, and they should assist you in deciding what direction you need to go. Clause 8 provides some tidying up of the provisions and the specified offenses to which the amended Act applies. And it pleased my heart to see they even tidy up the grammar, which you know I talk about all the time. Clause 9 is the savings clause to ensure that existing bail is not affected. It is not unusual for jurisdictions to amend their bail laws, not once or twice, but several times for various reasons, depending on the nature of their concerns. 2 studies from Australia, one by Julie Stubbs from the University of Sydney, titled Critical Reflections on Bail and Remand for Young People in New South Wales, from the ANZ Critical Criminology Conference proceedings in 2009, and from Alex Steele from the University of New South Wales, titled Bail in Australia, Legislative Introduction and Amendment since 1970, show how bail laws are modified over the years. So maybe somebody at the university can actually do a study about the amendment to the Bail Act from since the 1980s. See where we are going, how we have fared. The concern over drugs, over the safety of victims, over repeat offenders, over the firearm offenders, a number of them, about murder and other serious offenses, have moved legislatures to amend their laws. Some have done so to protect victims of domestic violence. I have not seen that trend here, and I highly recommend that this be considered. Too many women have lost their lives after repeatedly reporting that they are victims of domestic violence. The men should be in jail. I am satisfied that these amendments evidence a willingness to strike a balance between the rights of the citizen, whether potential or actual victims, and offenders, all of whom are entitled to their human rights. So I will support it. Thank you.
Attorney General.
Thank you very much, Mr. President. And I will start my brief remarks with a tribute which I paid only yesterday to once more finding myself moved and impressed and enriched by the quality of the wise women and men of the independent bench. But I was even more enriched today in listening to the remarks of the youngest member of the independent bench, and I pay tribute to Independent Senator Helon Francis.
If he's the youngest.
If he's the youngest. And I will give way to him if I misunderstood him, but he started off by speaking to the focus of the bill before this House, and I understood him to be referring to the guidelines that the bill seeks to give to the judiciary, and he used the term enhancing judicial transparency and accountability. And I commend that perception. And it goes back to a point that I often want to return to, and that is the debate. Let me be as neutral as I can be. Let me debate. To the debate that we have on the separation of powers in this place and the other place. And that very wise remark of the independent senator, that the provisions of this bill before this chamber, and therefore asking for the imprimatur of the legislator, the parliament, is a very good, current, contemporaneous example of the true meaning of this separation of powers. That is to say, this executive, of which I am proud to be part, brings to this House, this chamber, a piece of legislation by which the other part of the state, the parliament, will hopefully give its imprimatur in order to enhance judicial transparency and accountability in the exercise of their jurisdiction to grant or not to grant bail. Now that is the working of the separation of powers, where the different arms of state come together under our Constitution. And I pay tribute to Senator Helon Francis. I will return to a couple of the other things that the good senator said, but let me go back to my original intentions in terms of the remarks, a few remarks I want to make. I again, referring to one of our other independent senators, Senator Paul Richards has gone on record, and I am grateful to him for putting on record here today the fact that our statistics show a 60% to 70% recidivism rate in Trinidad and Tobago, and we are talking about that in the context of this bill. And one of the important facts that we are putting on record here today so that this Parliament can maturely exercise its deliberate legislative power is to have the data that speaks to the legitimate aim in order to manage the proportionate exercise of what Parliament is about to do. So thank you, Senator Dr. Richards, for adding that data to our bank of some of the data that we have had put before this Parliament today. And in speaking to the recidivism, of course, the Senator makes the call for Trinidad and Tobago having a more effective restorative justice system in Trinidad and Tobago. And I can give the Senator, if I'm just permitted to comment by way of reply, not strictly on the issue of bail, but to assure the Senator that the Office of the Attorney General and the Ministry of Legal Affairs is in active correspondence with the prison service as we work through a conversation with respect to restorative justice and measures that we are hoping to take in that regard. We have in the make as well a parole bill also to deal with an issue which Senator Lutchmedial raised, that is to say, the remand conditions that we need to do better with. We accept all of that. Senator Vieira has, as one would always expect on another occasion, but I won't go there today. I was tempted. I was tempted. Senator Vieira embraced the bill with certain criticisms, and I accept that. And while he makes the point that the bill does not address the failings of our education system and societal systems, we accept that this bill is not a panacea for everything that we need to fix in the society. We never said it would. And the amendment that we are seeking here today is just one part of the fabric that we are trying to rebuild for a better society, keeping our citizens safe. We've also had other remarks from other independent senators. If I may respond briefly, I asked her to give way at a certain point to Senator Sunity Maharaj, because she was using a turn of phrase that I wasn't following. That is to say, she was making the point that the power that is being given away, and I asked her to give way, and I'm grateful that she did, and she explained that she was talking about, in the context of the power that is being given away, the presumption of the right to bail. Well, I think the answer to that was put better than I could by what Senator Helon Francis said, because we are not giving away a power. We are in respect of a citizen's right to liberty, and the fact that the judiciary from 1898 has always had the discretion to grant bail, seeking to enhance the capability and to provide guidelines to make that capacity, when exercised, to grant or not to grant, more transparent. So we're not giving away any power. We are rather providing guidelines by which properly to assist the judiciary, we the legislators, to assist the judiciary in making their task more clear, more transparent, more accountable by providing reasons, and the reasons would then conduce to whether there is a good appeal or not. We are providing for the right to appeal. So, Mr. President, those are my few remarks of gratitude to the Roman wise bench of the Senate. I regret to have to go on record to say that I hope in the fullness of time and greater maturity, Senator Nakhid will rise from the abyss into which he descends so often and will pay respect to being a member of an ancient, hallowed tradition which deserves more respect than he gives it every time he stands.
I've warned earlier on, have a seat, Attorney General, the language. Just be careful. Attorney General.
Mr. President, and I was in the process of saying that I'm an optimist at heart. And
Mr. President.
Senator Nakhid, so the next outburst will be dealt with accordingly. Attorney General.
Thank you, Mr. President. And I was in the process of saying that I am an eternal optimist, and I live in hope that in maturity, Senator Nakhid will give respect to this House, which it deserves. Mr. President, let me pay tribute to Senator Laurence Hislop. Let me pay tribute to Senator Renuka Sagramsingh-Sooklal. They have put a rich contribution to the debate we've had here this evening. let me pay tribute to Senator Sookhai. It encourages one to participate in this process when we have the richness of the quality of the bench that the government brings to this place. And let me finally address one or two of the remarks which Senator Jayanti Lutchmedial made. She spent a lot of time, Mr. President, applauding the fact, and I congratulate her, she was part of the legal team that took Achille Charles to where it went. And I congratulate her on that. I'm always happy to see lawyers, young lawyers, ascend to greatness. It is an important decision. As I have said of the Suraj decision, this one will be written of in the constitutional and public law books for a long time. But do not let the politics do a disservice to a noble profession, the legal profession. So, while I accept that the government appealed the Achille Charles decision, the government lost in the Court of Appeal and appealed the decision to the Privy Council. That is not a criticism of the government. Governments have to be responsible. Exactly. And if we look at paragraph 10 of the Achille Charles decision of the Privy Council, delivered on the 28th of July, 2022, this is what paragraph 10 tells us. On the 17th of February, 2022, the Court of Appeal, Chief Justice Archie, Justice of Appeal Dean Armour, and Justice of Appeal Hislop allowed the respondent's appeal. So we lost in the Court of Appeal. Fair enough. The Court of Appeal in Achille Charles held that the bail provision was not existing law and that the earlier majority Court of Appeal decision in Krishnadath-Sinanan against the state, 1992, 44 West Indian Reports, 359, was wrong in holding that the High Court did not have jurisdiction to grant bail to a person who had been committed for trial for murder. So let us pause and reflect on that. At the 28th of July, 2022, the law in Trinidad and Tobago was in conflict. Two courts of appeal of the Supreme Court of Trinidad and Tobago, one reported 1992 44 Western Report 359 in the case of Krishnadath-Sinanan and the state, had held that the High Court did not have jurisdiction to grant bail. And until a decision of a higher appellate court, that decision was binding. On the 28th of July, 2022, when Achille Charles was determined in the Court of Appeal, and the Court of Appeal found that the High Court did have the jurisdiction to grant bail. What you had was the classic conflict of jurisprudence at the same level. It was the duty of a responsible government to take that to the higher court. It would have been irresponsible in the extreme. It would have been a dereliction of executive and constitutional duty for the state not to have appealed that. It had to go to the apex court so that we could get the benefit of the final Court of Appeal, which at this point in time is the Privy Council, settling a conflict which had existed for 20 years between two courts of the same jurisdiction, the Court of Appeal of Trinidad and Tobago. So don't use the political platform to trump one's trumpet to suggest that the government was wrong to have appealed. The government had to appeal. Let us be lawyers when we have that, the honor to belong to that profession. We have had significant statistics put before this august chamber, Mr. President, and I just want to leave one last word to commend to this chamber the fact of us being on good ground. In the Attorney General against Morgan, 1985, Law Reports of the Commonwealth, page 780, a significant decision emerged out of the Court of Appeal of this country. Some of us are old enough to remember that case. It was the rent restriction case. The respondent challenged the Rent Restriction Dwelling Houses Chambers Act 1981, which had been passed with the required majority in accordance with Section 13 of the Constitution, a supermajority. This legislation introduced a cap on the amount a landlord could charge for rent. The cap applied to properties that attracted rent charges within a specified range. The respondent, a landlord, challenged the constitutionality of the rent control legislation on the grounds that it infringed his right to property and that as it only applied to certain landlords, it amounted to unequal treatment. The Court of Appeal allowed the appeal of the state on the basis that the respondent had failed to discharge the burden of proving that the law was not reasonably justifiable. So let us go back to the reasonably justifiable legitimate aim principle established by the Court of Appeal in 1985 of this country. Critical to the court's reasoning was the fact that the state was able to produce evidence in the form of data to show how many tenants were likely to benefit from the protection afforded by the legislation. So that was a good example in another factual scenario entirely, where the legislature of this country had passed legislation with a legitimate aim to control rents in the face of a runaway landlord class in the country. And one of the landlords challenged it on the basis of being unjustified, and the Court of Appeal, and it was not appealed, held that it was in pursuit of a legitimate aim. The data was before the court to have satisfied the Parliament that it was an appropriate exercise of parliamentary jurisdiction to have capped the rents, and therefore the Rent Restriction Act was upheld as satisfying the 3/5 majority. So that if ever we needed precedent by our own Court of Appeal for what I ask this Parliament, this chamber today to do, that is the precedent. And with those words, Mr. President, I beg to move.
Honourable Senators, the question is that a bill entitled an Act to amend the Bail Act, Chapter 460, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General. Go ahead. 1 second, Attorney General.
Sorry, yes.
To amend the Bail Act, Chapter 460.
Thank you, Mr. President. In accordance with Standing Order 66-1, I beg to move that the Bail Amendment Bill 2024 be committed to a committee of the whole Senate forthwith to be considered.
Honourable Senators, the question is that the Bail Amendment Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, there are 9 clauses in this bill. I have not received any circulated amendments, and as such, we will proceed accordingly. Clerk.
Clauses 1 to 9.
Honourable Senators, the question is that clauses 1 to 9 stand part of the bill. Honourable Senators, the question is that clauses 1 to 9 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 9 now stands part of the bill.
The preamble.
Honourable Senators, the question is that the preamble to the bill be approved. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate.
Thank you, Mr. President. I wish to report that the Bail Amendment Bill 2024 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Bail Amendment Bill 2024. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 4, Number 60, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed. This bill requires a special majority. The clerk will conduct a division.
Dr. Brown? Mr. Armour, SC?
Yes.
Ms. Gopi Schoon?
Yes.
Mr. Sinana?
Yes.
Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. Mitchell?
Yes.
Ms. Cox?
Yes.
Mr. Bacchus?
Yes.
Dr. Ibrahim?
Yes.
Mrs. Sagramsingh-Sooklal?
Yes.
Mr. Sookhai?
Yes.
Mrs. Luzama Singh?
Yes.
Mr. Hislop?
Yes.
Miss London?
Yes.
Mr. Mark?
Yes.
Miss John?
Yes.
Mrs. Lutchmedial-Ramdial?
Yes.
Mr. Nakhid?
Yes.
Mr. Lyda?
Yes.
Mr. Roberts?
Yes.
Dr. Richards? Mr. Vieira, SC?
Yes.
Mr. Timal?
Yes.
Mrs. Thompson-Ahye?
Yes.
Dr. Dillon Remy?
Yes.
Professor Hutchinson?
Yes.
Dr. Patasar?
Yes.
Miss Maharaj?
Yes.
Mr. Francis?
Yes.
Mr. President, the results of the division are as follows. 30 senators voted for, 0 senators voted against, and there were no.
Honourable Senators, the results of the division is as follows. 30 senators voted for, 0 senators voted against, and there were 0 abstentions. As such, the bill would be read a third time and passed.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Attorney General.
Thank you very much, Mr. President. I beg to move that a bill entitled An Act to Amend the Constitution of the Republic of Trinidad and Tobago, the Judicial and Legal Service Act, Chapter 601, the Children Act, Chapter 4601, the Patents Act, Chapter 82, Number 76, and the Legal Profession Act, Chapter 90, Number 3, with respect to the administration of the Ministry of Legal Affairs and for related matters be now read a second time. Mr. President, the need for a comprehensive restructuring of the Department of Civil Law of the Ministry of the Attorney General and Legal Affairs was flagged and highlighted extensively since 2006 under the then Attorney General John Jeremy. The dire need to avoid further calamitous events by bringing amendments and changes to the structure of the Department of Civil Law, culminating in the drafting of the bill now before this House, which was approved yesterday in the other place, dramatically came to the fore, notwithstanding the 2006 efforts of Attorney General John Jeremy in the circumstances surrounding the now infamous High Court case, Civil Matter 2020, number 01243 of Sherwin Peters and others against the Attorney General of Trinidad and Tobago, which I shall call the claim or the case. And a brief history of this matter is necessary in order to understand why, by this bill, before this House today, the government of the Republic of Trinidad and Tobago has considered these amendments to the above-mentioned acts as being both crucial, essential, grossly overdue, and in fact urgently necessary for the effective running of the Civil Law Department of the Republic of Trinidad and Tobago. Mr. President, investigations concerning the claim, that is to say, the claim of Sherwin Peters and the case to which I have referred, have revealed that the relevant proceedings in that case were, and I say deliberately, were cynically not served at the correct office, with the result that full activity resulting in a default judgment against the state, in which the state was ordered to pay a sum in excess of $20 million, could go undetected by the state's Civil Law Department. How was it, Mr. President, that days after I called the 2023 media conference, having been alerted to the fact of this judgment, to announce that in the wake of that $20 million judgment, I would leave no stone unturned, that the missing file mysteriously appeared on the tabletop of an empty desk of a vacant office in the Civil Law Department. And that's why I use the word cynically. And this underscored the need, Mr. President, to look closely at the systems and processes used by the state in its civil law portfolio urgently. And after a much justified public outcry following that decision, I decided to appoint an independent investigative team on the 2nd of February, 2023, consisting of retired Justice Mr. Stanley John and Mrs. Pamela Schulera-Hines, retired head of the Special Branch of the Trinidad and Tobago Police Service, to do the following, among other things. 1, to inquire into the facts and circumstances relating to that case, Sherwin Peters, commencing from the 22nd of June, when service of the claim form and statement of case were effected, but mysteriously disappeared, including the decision of the High Court dated 30th January 2023, and culminated in the handover of the file of that case to the Acting Solicitor General on the 6th of February 2023, when it mysteriously reappeared on an empty desktop of a vacant office. I add, an empty desktop of a vacant office. The second, terms of reference, to inquire into and establish the facts and circumstances regarding the role or roles played by any minister, member of the Civil Law Department, or any other person employed at the Office of the Attorney General and Ministry of Legal Affairs in the management and conduct of that case. 3, to inquire into and establish whether there had been any dereliction of duty, violation of any law, conflict of interest and/or breach of trust on the part of any minister, member of the Civil Law Department, or any other person employed at the Office of the Attorney General and Ministry of Legal Affairs in the management and conduct of that case. To inquire into, 4, and examine the current procedures of the Office of the Attorney General and Ministry of Legal Affairs and the Civil Law Department relative to the management and conduct of civil litigation involving the state. 5, to make recommendations to improve the management and conduct of civil proceedings taken by and against the state at the Office of the Attorney General and Ministry of Legal Affairs and the Civil Law Department, and to have recourse to such information, technology expertise as necessary. 8, because I've skipped 2, I've skipped 6 and 7, which were to report in writing, respectively, to the Judicial and Legal Service Commission and to the DPP. 8, to make such other and incidental inquiries which concern and relate to the subject matters of inquiry as the investigative team may deem necessary, to give effect to any findings made by the investigative team and/or remedy and/or prevent any act of conduct as may be found by the investigative team, and on the need, if any, for the enactment, amendment, or repeal of any law of Trinidad and Tobago relating to civil proceedings by and against the state. And 9, to issue a report with recommendations to the Attorney General within 60 days of the establishment of this investigation on the 5th of February 2023 with reference to those terms of reference, and a full and final report with recommendations within 6 months of the 5th of February 2023. Mr. President, the preliminary report was submitted by the investigative team on the 31st of March, and the full and final report was submitted to me in June of 2023. Permit me at this stage, Mr. President, to record with the nation's deepest gratitude to retired Justice Stanley John and retired Mrs. Pamela Sholera-Hines, former head Special Branch Trinidad and Tobago Police Service, for their invaluable and expeditiously comprehensive work. For brevity only, Mr. President, I will use the words investigative team and to refer to the final report as either the final report or the John report. During the course of their investigations, Mr. President, the team met with heads of departments in civil law, and I'm emphasizing this now. This team was appointed by me in February 2023. They commenced their investigations from that date. And during the course of their investigations, the team met with heads of departments in the Civil Law Department, led at the time by Ms. Carleen Senath, Acting Solicitor General, the Permanent Secretary for the Office of the Attorney General, the Director of Information Communications and Technology at the Office of the Attorney General and Ministry of Legal Affairs, among other persons. In the submission of their full and final report, the team carefully examined and addressed the roles and functions of the Chief State Solicitor and the Solicitor General, identified certain shortcomings, and made several recommendations with respect to improving the management and conduct of civil proceedings taken by and against the state at the Office of Attorney General and Ministry of Legal Affairs. Mr. President, during the course of that investigation, the team carefully scrutinized the procedure of the Civil Law Department as it relates to the management and conduct of civil proceedings. They examined how court documents are handled once served at the Office of the Attorney General and Ministry of Legal Affairs, where these documents are logged, by whom, where these documents are placed after they've been served, and most importantly, to whom are the cases assigned for conduct of the matter. Mr. President, the current information technology infrastructure at AGLA was also assessed in terms of how much it is used by officers attached to AGLA, AGLA being Attorney General and Legal Affairs, and how best ICT could be used in the future by the Civil Law Department to improve their processes and efficiency and to ensure that similar circumstances do not recur. In making their recommendations as part of their mandate, Mr. President, the investigative team examined reports from 2006 commissioned by former Attorney General Jeremy and 2008 of a committee comprising 2 former Solicitors General who subsequently went on to become High Court judges and judges of our Court of Appeal, as well as a senior professional in organizational management, a senior professional in human resource management, the then permanent secretary to the Office of the Attorney General and Ministry of Legal Affairs, and chaired by the then, at the time, and Senator Richie Sookhai referred to her today, the then Court Executive Administrator of the Caribbean Court of Justice at the time, Master Christian Morris Allen. The investigative committee appointed by me in February 2023, Mr. President, acknowledged that the 2006 and 2008 committees held extensive and exhaustive consultations. And I'm emphasizing this because of something that I will return to, Mr. President. The investigative committee of the Justice Stanley John Committee acknowledged that the committees appointed in 2006 and 2008 had held extensive and exhaustive consultations with members of the various departments of the Ministry of Legal Affairs, allowing them to produce extensive reports entitled Reports of the Committee to Enhance the Delivery of Legal Services to the People of Trinidad and Tobago, so that the consultations to improve the civil law department have been going on since 2006. Mr. President, I emphasize that the exhaustive and extensive consultations go back that far, in part because of the sorry debacle which occurred yesterday in the other place, led by the Honorable Leader of Opposition, and to which I shall return in due course, Mr. President. In the course of the investigative team's work, Master Morris Allen was asked by Justice Stanley John to review those 2006 and 2008 reports with a view to ascertaining whether the situation had changed significantly. As part of her task, Mr. President, Master Morris Allen, whilst being part of the Justice Stanley John Pamela Schulera Hines investigative committee, met with senior officers of the Solicitor General's Department, senior officers of the Chief State Solicitor's Department, the Director and staff of the Information and Communications Technology Department. So these consultations have been going on since February of 2023. We are now in July of 2024. The Permanent Secretary for the Office of Attorney General and Legal Affairs, the Registrar General of the Registrar General's Department, all with a view to an intention of understanding the concerns of the officers of those departments about the state of the Civil Law Department, of the Office of Attorney General and Legal Affairs, and ascertaining whether there were any changes in the services they deliver, their modes of delivery, their processes, their resources, and their tools. She reported to the investigative team. After all the information was collected and their investigations were completed, the investigative team concluded and determined that the structure of the Civil Law Department of the Office of Attorney General and Ministry of Legal Affairs did not afford ample opportunity or fertile ground to enable the types of processes and procedure changes required to be or to become an efficient and well-organized civil law department. The investigative team under Mr. Justice Stanley John's leadership identified, among other things, poor systems, weak processes, a lack of accountability. I quote only one paragraph out of the remarks in their report, which is here, Mr. President. I quote, "It has become evident that there are and have been weak processes which have resulted in unfortunate outcomes. It was necessary to understand where the weak processes came from. Why were they allowed to remain? Who was studying them? Why was there a culture of continuous improvement? More often than not, processes are an outcome of systems and organizational structure, and it continues to be evident that the existing structure lends itself to less than sound systems, limited accountability, process failure, and limited engagement. Continuous review, which should be one of the hallmarks of modern organizations, is not encouraged in this organizational structure. The legal heads and their senior legal staff saw the processes as the responsibility of some amorphous them who somehow had the power, and the legal heads simply had to take it or complain, but never that they should take the lead or be involved in the process design or redesign. Data entry was seen as something done by IT, not the responsibility of each person as the computer replaces the pen. It is for this reason, says the Stanley John Pamela Schulera Hines Committee, it is for this reason that we approach these recommendations by first discussing the organization. The design of the organization must be such that the head of chambers sees themselves as accountable for not just the cases that they are handling, but the systems, the processes, the efficiency, the throughput, the standard, and in general, the full organization. End of quote. This is the report, Mr. President. And I will make some remarks about unfortunate remarks made yesterday about this report. The investigative team officially therefore recommended, 1, that there be a civil law chambers, which should be a merger of what is now the Solicitor General's Department and the Office of the Chief State Solicitor, formerly called the Civil Law Department, in keeping with the Judicial and Legal Service Act, Chapter 6, Number 1. The administration of the civil law chambers be bolstered by the introduction of chambers management within the civil law chambers, and that the chambers management be headed by a competent chambers manager. 3, the Office of the Registrar General and the Intellectual Property Office be separated from the civil law chambers and formed as offices on their own. This was seen as necessary, as the work of the Registrar General is quite different from that of the rest of the Civil Law Department. And 4, the positions of senior children's attorneys and children's attorneys be formally created and filled under the provisions of Section 88 of the Children's Act, Chapter 46, Number 1. Mr. President, permit me at this juncture to acknowledge that in the wake of the 20 million judgment, I retained Mr. Justice retired Ralston Nelson, who led a team of attorneys and who has successfully been able to set aside that judgment. Never mind, the judgment is now not unexpectedly under appeal under the leadership of Mr. Anand Ramlogan. On the 19th of October 2023, Cabinet accepted the Justice Stanley John report and authorized me as Attorney General to come back with recommendations, which I did. On the 5th of April 2024, Mr. President, I formally retained retired Court Executive Administrator Master Morris Allen as consultant to the Office of Attorney General to implement the recommendations of the Justice Stanley John report. For the record, it is important that I ask this chamber to acknowledge that prior to her retirement as Court Executive Administrator in 2023, Master Morris Allen served successively in that capacity under the late Right Honorable Mr. Justice Michael de Labastide, King's Counsel, as Chief Justice of the Supreme Court of Trinidad and Tobago, went on to serve as Court Executive Administrator under President of the Caribbean Court of Justice, President Michael de Labastide, and after his retirement, returned to the Supreme Court of Trinidad and Tobago in the capacity as Court Executive Administrator under Chief Justice Ivor Archie, ORTT. Need I say more as to the suitability and competence and experience of retired Court Executive Administrator Master Morris Allen as my consultant to implement the John Report recommendations? Mr. President, following on her appointment, on her retainer, Master Morris Allen has held a series of meetings and consultations on my behalf with the staff of the two departments, the Solicitor General and Chief State Solicitor, as well as with the Registrar General and the controller of the Intellectual Property Office on the reform process, the first step of which process, reform process, is represented by this bill. And let me just list some of the events that occurred in the process of that consultation which Master Maurice Alleyne undertook on my behalf with the Chief State Solicitor, Solicitor General, and their staff. Meetings with seniors in each department, meetings with lawyers of the Solicitor General, sometimes for over 3 hours, meetings with lawyers of the Chief State Solicitor's Department, sometimes for over 3 hours at a time. Joint meetings and working sessions, sometimes lasting over 5 hours, with both departments, where all concerns were aired and written down and collated. She received lists of questions and concerns. She exchanged several emails and phone calls from staff who were invited to contact her freely and did. She held several meetings with the Solicitor General and the Chief State Solicitor. She received their observations. She had several conversations by WhatsApp and phone, etc., with the Solicitor General and Chief State Solicitor, a running conversation, she tells me, with the staff of each of those two departments. She received excellent suggestions from those consultations and took them into consideration in the recommendations that she continued to make to me. And these included not proceeding to abolish some of the positions that we are going to examine today and not to create new positions, so that she accepted some of those recommendations. And the approach to dealing with public officers, first by the bill and then to address contract officers, actually came out of those consultations. The names were also worked through by several conversations. That is to say, the names that we'll be examining here today culminated in a conversation on which people voted. There were votes taken in those meetings. Permit me, Mr. President, to turn to the bill in some detail. The Judicial and Legal Service Act provides for the creation of a civil law department in the Ministry of Legal Affairs under Section 12. And Section 12 provides that the Ministry of Legal Affairs shall comprise the departments of civil law, of criminal law, of legislative drafting, and of accounting, which shall be headed respectively by the Solicitor General, the Director of Public Prosecutions, the Chief Parliamentary Counsel, a public officer to be designated permanent secretary in the Ministry of Legal Affairs. And 2, the Civil Law Department shall include the departments of the Chief State Solicitor and of the Registrar General. The bill seeks to reorganize and restructure the Department of Civil Law, Mr. President, by doing a number of things. In the main, fusing the departments of the Chief State Solicitor and the Solicitor General's Department into one civil department, and for provision of children's attorneys under the Children's Act, and for effective chambers management to provide for an improved opportunity for sound strategic and operational management of the Civil Law Department. Secondly, creating the Registrar General's Department as a separate department in the Ministry of Legal Affairs, with the Registrar General as Chief Legal Officer. And thirdly, making provision for persons in the Intellectual Property Office to be engaged on contract to perform their specialized functions in such a way as to provide for some element of contractual stability. Mr. President, a number of legislative changes are being proposed, but none of them change the substantive functions of the officers under consideration. None of them alter terms and conditions of any of the substantive officers. What by this bill is being done is to rename a number of the officers, to put them into one fused department, to align their responsibilities under the Solicitor General. And because we being lawyers, Mr. President, and that is since 1985, we now exist under the Legal Profession Act, which fused the former division of barristers and solicitors, which we inherited from the UK, to become attorneys at law. What you will now see in the bill is the naming of attorneys instead of Chief State Solicitor to be Chief State Attorney, but the substantive positions have not been changed. Mr. President, how much time do I have left?
7:13.
Thank you. Mr. President, so we remove the references to the Department of the Chief State Solicitor as a distinct sub-department of the Department of Civil Law, Clause 5D2. Distinguishing between the responsibility of the Department of Civil Law and specific statutory civil law functions and responsibilities as well, and removing the distinctions between the offices of the Chief State Solicitor and the Solicitor General simply by changing the names of those offices to reflect our fused profession. Section 12(1) of the Judicial and Legal Service Act, Mr. President, provides for three main legal departments. The ministry, that is to say, the Department of Civil Law, the Department of Criminal Law, and the Department of the Chief Parliament.
You actually end at 7:18.
Thank you very much, Mr. President. And the Department of the Chief Parliamentary Counsel. And with respect to the Department of Civil Law, Mr. President, Section 12(1) of the Act provides that the Solicitor General is the head of the department. That has been retained. That has not changed. The Civil Law Department, under the bill before this House, has been retained, and the head of that department, by that name, is retained as the Solicitor General. And that retention of that name actually came out of the process of consultation. There was originally an intention to name it differently, consistent with the fact that we are no longer solicitors or barristers. And out of the consultation, I was persuaded, I actually participated in one of those meetings, that the name Solicitor General is an international brand that exists across the English-speaking Commonwealth. And therefore, it would be a disservice to the Office of Solicitor General in the international plane where that Solicitor General has to function cohesively with other Solicitors General across the Caribbean, the Commonwealth, to change the name. So out of that consultation, I accepted we will leave the head of the department as the Solicitor General, but everyone under the Solicitor General will be renamed attorney as opposed to solicitor. I'm emphasizing the process of consultation because I was so aggrieved by what happened in the other place yesterday, Mr. President. Section 12 of the Act, the Judicial and Legal Service Act, does not detail the functions of the department, Mr. President, because the functions remain the same. Any function conferred by legislation to either the Solicitor General, wherever that legislation exists in Trinidad and Tobago, to either the Solicitor General or the Chief State Department will remain the responsibility of the Civil Law Department, whether or not the particular legislation is amended to refer to the department. The Department of Civil Law is the umbrella under which those two offices will function. Additionally, the proposed bill envisages and recognizes that many of the roles and functions of the Department of Civil Law are not currently and will not be expressly assigned in legislation because they have traditionally been performed by the holders of the Office of Solicitor General and Chief State Solicitor. They've existed since 1962 with independence, Mr. President. And the Attorney General, the proposal before this House by the bill, recognizes that the Attorney General being charged under Section 76 of the Constitution with responsibility for, and I quote from Section 76, the administration of legal affairs in Trinidad and Tobago and legal proceedings for and against the state may assign duties to the Department of Civil Law. It's recognized in the Constitution. The bill also expressly refers, Mr. President, to Part 1 of the first schedule to the Judicial and Legal Service Act that sets out the legal offices of the Department of Civil Law. And these offices include the current offices of the Solicitor General's Department, the Chief State Solicitor's Sub-Department, and offices required under the Children's Act, that is to say, children's attorneys and senior children's attorneys. Mr. President, as I've said, the Solicitor General remains the head of the Civil Law Department. She also performs, she or he, other statutory functions that are specific to the holder of the office of Solicitor General. Similarly, specific legislation provides for functions to be provided by the Chief State Solicitor. These roles will remain specific to that office holder, notwithstanding that that office holder will now be known as the Deputy Chief State Attorney under the Solicitor General. A change of name, Mr. President, so that the Chief State Solicitor is now known as the Chief State Attorney, not Deputy, I beg your pardon, and will continue to assign and delegate functions that are statutorily assigned to the Chief State Solicitor to other officers as Sections 52 and 53 of the Interpretation Act provide that any statutory function conferred on any public officer may be delegated to any other officer within the same ministry. It is not necessary for the officer with the statutory assigned role to be the head of department or sub-department for other officers within the department to exercise functions related to the statutorily assigned role. Mr. President, it isn't practical to specifically identify and prescribe responsibilities for every civil law matter to a particular department or officer. For the avoidance of doubt, Mr. President, a new Section 12(2)A is inserted, which clarifies the scope of the Department of Civil Law, provides that the specific civil law functions assigned by legislation which have existed before will continue to be exercised by the entity or other offices specified in the legislation. And the purpose of that proposed subsection 2 is twofold. One, it seeks to clarify that while there will be one Department of Civil Law, if any law specifically assigns a duty or function to the Solicitor General or to the Chief State Solicitor, that duty or function remains that of the officer renamed. The officer simply operates within the new fused Department of Civil Law as opposed to being in a sub-department. Two, the proposed 2A recognizes that some functions that may come within the broad scope of a civil law matter may have to be assigned to some other public functionary. In such case, that office holder or body will be responsible for the function specifically defined. State attorneys, Mr. President, I've already spoken to the fusion of the Legal Profession Act 1985 and the maintenance of the anachronisms of State Solicitor, Chief State Solicitor are just that. They're redundant anachronisms. So we are bringing Trinidad and Tobago in line with the 1985 legislation, under which all of us in this chamber who are lawyers and were called to the bar, under which legislation we have been called to practice. Senior children's attorneys and children's attorneys. Section 88(2) of the Children's Act, Mr. President, mandates that the children's attorneys' offices be an office within the Department of Civil Law. So we are recognizing that. And we are proposing by replacing Part 1 of the schedule to bring those attorneys properly in and described. And it is therefore proposed that Part 1 of the first schedule be repealed and substituted to reflect the following changes. A, the office of Chief State Solicitor be renamed as Chief State Attorney. The Deputy Solicitor General and Deputy Chief State Solicitor be renamed Deputy Chief State Attorney. All other offices within the designation State Solicitor, State Counsel, or similar designation renamed State Attorney. The inclusion of senior children's attorneys and children attorneys within the ambit of Schedule 1. And the removal of the offices of Controller, Deputy Controller of the Intellectual Property Office, and as well as the Assistant Controller will be inserted into Part 5 of the first schedule as they are not part of the Civil Law Department. They were created under the Patents Act and are now going to be a separate office within this contemplation of this bill. Chambers management, Mr. President. Yesterday I permitted myself to speak of myself when I made the pronouncement, and I don't necessarily apply to anybody else. Lawyers are not good managers. Mr. President. We are not. And therefore, what we are doing by this bill to amend the Judicial and Legal Service Act is we are making provision for the Judicial and Legal Service Act to provide for and create a position of chambers manager who will not be a lawyer necessarily, but who will be experienced in, among other things, operational structures, human resource management, performance standards, to get the lawyers who are performing a service to the public to function in a cohesive, efficient, structured way. So we are creating a non-legal position, and the precedent for that exists. The permanent secretary of the Office of Attorney General, the Civil Law Department, doesn't necessarily have to be a lawyer, but under the schedule to the Judicial and Legal Service Act, the permanent secretary is accounting officer and is part of the structure. So we're simply building that out to accomplish for the better quality of service that lawyers in the Civil Law Department will perform, to give them the management capacity under somebody who is recruited as being skilled in that area. It is to be a new, senior, non-legal, non-public service contractual position to enhance the management of the Department of Civil Law. Public sector management, yes.
You mentioned chamber management. Person's experience in operational structure and so on, and that person will be managing. So I am head of a department. I manage my staff. You present me now with someone who is going to teach me, because they have the managerial experience and skills. So what happens to me? Am I supposed to be happy with that? You know, I hear you with your arguments about consultation and everything, and perhaps you can tell us how have the staff members reacted to the change? Are they comfortable? Are they happy? Do they have questions? I am curious, because the way you speak, I'm getting an underlying feeling that you're trying to convince not only us, but everybody else. So convince me.
Thank you, Senator Thompson-Ahye. I will briefly answer your specific questions with 3 short points, but as I continue, I hope you will also accept that I address them. Firstly, Clause 5 of the bill before us proposes to amend Section 12 of the Judicial and Legal Service Act. If you go to page 5, you will see that at the bottom of page 5 it says, by inserting immediately after subsection 4 the following subsections. 4A, there shall be a chambers manager who shall, imperative word shall, in accordance with the general or specific directions of the Solicitor General. So to answer your first question, the chambers manager is answerable to and functioning under the general and specific directions of the head of the department, the Solicitor General. And secondly, to answer your question, Section 4A, to provide general administration support, including strategic and operational planning to the Department of Civil Law. And what that contemplates in public sector management today, Senator Ahye, it is far more complex and onerous, and we need persons who can take instructions from the Solicitor General, but bring a skill set and a body of experience that lawyers neither have the time to accomplish and discharge, nor are they skilled in that new task. So I say that to you in specific answer to your questions, and I will come to the question of consultation and the quality of consultation as I continue, if I may. So that the chambers manager will be a suitably qualified professional.
Attorney General, you have 5 more minutes.
Thank you, Mr. President. Who will support the head of department in harmony with the ministry's strategy for general administration, including ICT development and implementation and performance management. We also accept on the bill that is before the Parliament, that this chamber, that we are going to create a Registrar General's Department as a separate department of the Ministry of Legal Affairs, and we are going to make the Registrar General Chief Legal Officer in his or her own right. We are also going to make consequential amendments. So in addition to the proposed amendments, that is the fusion of the Department of Civil Law, the establishment of a separate Department of Registrar General, we propose that certain challenges to the effective administration and operations of the Department of Civil Law and Intellectual Property Office will be addressed, and we are proposing that the Children's Act will be amended to allow the functions of a children's attorney to be performed by more attorneys of the Department of Civil Law. We also propose that the Patents Act should be amended to provide for officers other than the controller, deputy controller, and assistant controller of the IPO to be either public officers or engaged on contract. The Legal Profession Act has also been amended to include the Registrar General among the chief legal officers. The restructuring, and I'm coming now to your question about the concerns, Senator Ahye. The restructuring of the Civil Law Department has been a work in progress for a long time. I've already referred to the 2006 report and consultations which commenced then in 2006. I was yesterday appalled by the fact that the Honorable Leader of the Opposition read into the record a letter which came into my email dip at 12:01 a.m. on the 2nd of July. A letter addressed to me by signatories who are officers of the Solicitor General's Department, which I did not intend to address because I saw that letter as a challenge to me to continue the engagement, so much so that I replied. It was a letter from the Solicitor General. I replied to the Solicitor General's letter on the 2nd of July in these terms. Dear Solicitor General, acting, thank you for your email, which I have asked Master Morris Allen to meet with you on, since, as you know, she's my lead consultant, has already met and addressed many, if not all, of these concerns, and should be more than able to provide any further clarity required. I have copied Master Morris Allen, and she will correspond directly. Please keep me in copy in your responses to her. And I communicated that I was unable to meet on the 2nd because I was in Parliament morning and afternoon until midnight of that day. Master Morris Allen had a 4-hour meeting with these attorneys, after which the letter arrived in my dip on the whatever date. The letter misstates the fact of consultation. The consultation, when you read the letter shows that the consultations have been taking place since February of 2023. Of 2024, I beg your pardon, 2024. The letter speaks to the brand of Solicitor General, which was an accession that I made in the consultations that were taking place. I invited, and this is important for the record, as part of that consultation, I invited the Chief State Solicitor, the Solicitor General, the Registrar General, and the Controller of the IPO Office to attend the LRC meeting at which the bill, which was scrubbed and went to Cabinet, was engaged in and to which they had no objection. They attended the LRC meeting. I received today a letter that I want at 12:46 p.m. Today, I received an email in these terms. I'm going to edit it slightly because I do not want the person to be identified. This is a member of the Solicitor General's Department. Dear Honorable Attorney General, forgive me for taking this direct approach in addressing you, but after yesterday's development, talking about the House of Representatives yesterday, Concerning the reading of the letter dated 1st July by the opposition leader, I feel compelled to express myself in this manner. I have served in the Solicitor General's Department for almost blank years. I put in blank. Whilst I'm of the view that the concerns expressed in the letter are legitimate, I have to distance myself from what I perceive to be a move that lacked respect and integrity. At no time was it communicated to me that the letter was intended to be sent to anyone else beside your good self. I do not believe that the leaking of the letter really reflects a good faith attempt to have legitimate concerns addressed appropriately. It is unfortunate that our concerns were leaked and canvassed in this manner. I received that today at 12:46. My time is up, Mr. President. I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Amend the Constitution of the Republic of Trinidad and Tobago, the Judicial and Legal Service Act, Chapter 601, the Children Act, Chapter 4601, the Patents Act, Chapter 8276, and the Legal Profession Act, Chapter 9003, with respect to the administration of the Ministry of Legal Affairs and for related matters, be now read a second time. Senator Mark.
Thank you, Mr. President. Mr. President, we just about 5 hours ago would have been advised through the Attorney General that this bill, that it took the office of the Attorney General a substantially long period of time to formulate, was given to this Honorable Senate in terms of our procedure, our standing orders. It was only read for the second time just about 4.5 hours ago. And based on what the Attorney General has indicated in his contribution, this is a bill whose contents are very deep, sweeping, and far-reaching. And it requires, Mr. President, deep thought, discussion, consultation, research. We have been working from Tuesday into Wednesday into this Thursday, right? And Mr. President, I want to serve notice on this government that after I speak, I cannot guarantee this government any further cooperation on matters that are before us, because I'm exhausted myself, like my colleagues are, and I do not want anyone to accuse me of being part of a new Section 34. So we need time to study these matters. And in fact, Mr. President, I would like to say from the very outset that because of the importance of the matter before us, this bill should be properly referred to either a joint select committee or a special select committee where we will bring in all the players. I do not trust the Attorney General. I do not trust the government. So, Mr. President, if we are to hear from the workers, from the public officers, be they contracted, be they contract officers, be they public officers, I would like to be part of a select committee that can interview them in camera if they don't want Mr. President to be subject to a public hearing. But for heaven's sake, you cannot bring a matter before this honorable Senate dealing with what? Reclassification. That is not my responsibility. That is the responsibility of the Salaries Review Commission.
Yes.
You are asking me, Mr. Vice President, to agree with a number of things. We are being told by the Honorable Attorney General that he has a report from a retired Stanley John, who I have the greatest respect for. But I know between himself and Rolston Nelson, provisionally, they got almost $1 million. I do not know what is the final price tag for their work. But you know what? The contempt, the contumely disrespect that this Attorney General has shown towards this Parliament and this Senate. He showed us a short while ago. This is the report. But what is this? There's secret. There's a secret. There's a secret report. So we paid over $1 million.
Money.
Right? It didn't come from the Attorney General's pocket. It came from our pocket, the taxpayers of Trinidad and Tobago. And yet still, the Attorney General has not furnished us with a copy of the Stanley John report. And he regales us with cherry-picking recommendations and findings, and we don't have a clue because we don't have access to the report.
We don't need him to read for we.
And then to make things worse, we are told that he hired a consultant. He has a consultant called Sam Christie and Morris Allen. And obviously, Mr. Vice President, if I am to take it from the Attorney General, the Honorable Master, former Executive Master in charge of administrative matters in the Supreme Court, generated a report. She has been involved in a number of consultations. But where's her report? Where's the consultant's report? But again, that's a secret document. But you are tying our hands behind our backs, blindfolding us, and telling us, trust me. Trust the Attorney General. AG, we do not trust you. No way, Mr. President, Mr. Vice President. Mr. Vice President, before I go into what I deal with substantive matters surrounding this issue, because we had to make night into day because of the total incompetence of this administration. Failure to generate, Mr. President, a legislative agenda. So we are here like headless chicken, just doing things crazy, Mr. President, because we have no agenda from the Attorney General.
Senator Mark. Yes. Have a seat for a bit, please. All members, kindly keep the respect and tone, standing orders for the rest of the evening. These standing orders for the rest of the evening.
No, well, I'm not shouting, sir. I am very passionate. You know why? You know why?
But you don't trust
I don't like injustice. I don't like unfairness. And the government is seeking to take advantage of these lawyers because they believe that they have no representation.
Correct.
Mr. President, I want to make it very clear. I want to make some preliminary points, and I want to deal with some matters in a more detailed way. Just now they're going to tell me they can't hear me.
You talk, man.
Mr. President,
A democracy.
this attempt at undermining, weakening, seeking to destroy the Civil Law Department comprising of the Solicitor General's Department, the Chief State Solicitor, and now conveniently, formally located here, the Registrar General's Department. But you know what the AG has done? Through his consultants, he has now migrated out of the Civil Law Department, the Registrar General. So the Registrar General is no longer under the Civil Law Department. And you know what the Attorney General is telling us in this Parliament? He got a report from the former retired Judge Stanley John, ably supported by the former executive administrator of the courts.
Was that a paid report?
Yes, the Attorney General has to tell us whether Christine and Morris Allen was paid for her services, and tell us how much money she was paid, and why her report is secret. No, I am the taxman, I'm the axman too. I'm not only the taxman, I'm the axman. You understand? Yeah. So, Mr. President, very rude. Here what we want to clarify very early from this Attorney General and his lame duck government.
No, lame duck.
Mr. President, what I would like to ask, first of all, through you, to the Attorney General, is this. Was there, and I'm asking questions here, I start to accuse anybody as yet?
Not yet.
I'm coming at that.
Tomorrow.
So asking questions first,
Come clean. Not
Mr. President. I want to ask the first question. Was there a breach of the separation of powers principle when this executive administrator was consulting and preparing and meeting and discussing with the workers in the two departments while she was a member of the judiciary? I would like the Attorney General to tell this country if there was a breach in the separation of powers, because there are three organs of the state. There's the legislative or the legislature, Parliament. There is the executive, headed by the Prime Minister and the Attorney General, because they form the government.
For now.
And then there is the judiciary. I am hearing from the Attorney General, and I have evidence here, that this court executive administrator only left the judiciary on the 7th of February 2024.
7th February.
Only a few months ago. But we understand she was on the compound of the Attorney General, working on behalf of the Attorney General in restructuring the offices of both the Chief State Solicitor and the Solicitor General's office. So the first question I'm asking is whether the Attorney General, when he's speaking, if you could clarify
The time period.
the time period. Was this lady holding meetings in the month of May last year? While she was a member of the executive?
That can't be.
Whether she was holding meetings with the workers?
No way, no.
With the lawyers?
Nah.
So we want the Attorney General to clear the air. Right? No, I'm saying it here, right here, for you to hear. You are to account for money. You must account for money. Yes. So, Mr. President, that is the first question we want to ask. This temperature that is building up in that office hasn't been building up now, you know. John Jeremy, the former Attorney General, tried to undermine and tried to mash up. They tried to integrate, they tried to fuse the same merger, Mr. President, that we have before us. John Jeremy and his team, led by the same lady, this same Maurice Allen, like a constant star. She like the Northern Star. She constant. She was there in 2006. She was there in 2008. She is there in 2024. And the objective has remained the same. They want to undermine, they want to compromise, and they want to destroy the Solicitor General's department. That is what they did. And the only reason, Mr. President, Mr. Vice President, they were stopped in their tracks is because the masses voted for the People's Partnership in 2010. And because they got back in the power in 2010, and they're now there in 2024, they are fast at work trying to undermine and destroy those two units or departments. Mr. President, I want to ask the Attorney General whether the Public Procurement and Disposal of Public Property Act was breached by the Attorney General's office when he employed this consultant. We asked the Attorney General to tell this country if he contributed to the violation of the Public Procurement Act. Since this lady, Maurice Allen, was an executive at the time. I'm working as a consultant for the executive at the time, Mr. President. So we want to know that because she was employed, according to information reaching me, and I call on this lady to publicly confess to the nation whether she was employed at the time in the judiciary while she was conducting consultancy for the Attorney General. Let her come out publicly and state. Mr. President, we also want to find out from the Attorney General. We have a copy of the 117th report of the SRC. And the 117th report of the SRC does a complete reclassification of the offices that the Attorney General is now seeking to alter and to change through the legislation that is before us. And as far as I know, under Section 140 of the Constitution, the only institution under our Constitution directed by the President, which is the Cabinet, to deal with terms and conditions for office holders like ourselves and those public officers, DPP, Solicitor General, Chief State Solicitor, Registrar General, is the SRC. So how can the AG come here, give us a report from Stanley John, with the greatest respect? I know him, I respect him.
Good for you.
And how can he give us a report or says that something was done by this lady, Morris Allen, and we don't have any evidence, no information, no report, but you want to change people's titles? Listen, comrade, brothers and sisters, Honorable Vice President, let me tell you something. I have some industrial relations training, right? It is unacceptable. It is indefensible. It is inexcusable to abolish people's offices the way they are doing it. It is an infringement of elementary, basic industrial relations practice and principles. You don't do that.
The PNM could do that, yes.
That is what the AG is doing.
Yeah.
And his agents. Listen, the former Attorney General, when he was there, Mr. President,
which one?
He had this lady, I don't know what influence she has over attorneys.
PNM attorney.
Oh my God, Mr. President, if the lady said jump, they say, how high, master? And this is what happened with the former, and this is what is happening with the present. I thought the Minister of Public Administration would have spoken out against this matter. And the reason being, there's something called the Public Management Consulting Division. Any kind of restructuring, any kind of new kind of classification systems that have been, any new functions, new titles, they want to restructure, they have to come to the PMCD for directions. They bypass the PMCD.
Where the PMCD?
And who is doing it, Mr. President? Mr. Vice President, you know who is doing it? Justice Stanley John. I didn't know he'd take over the role of the SRC.
Bad boy.
I didn't know Justice Stanley John is the new chairman of the Salaries Review Commission that deals with reclassification. I didn't know that, Mr. President. So where does he get that power from? And where does Morris Allen get this power to do, Mr. President, what is being done? So, Mr. President, Mr. President, let me indicate something to you. Hear what they are proposing. They are saying, in terms of amending the legislation to bring these new offices into being, there is something called the Chief State Solicitor. Mr. President, Mr. Vice President, that's a brand. That's a brand. Any Commonwealth country you go in, Mr. President, you hear about these things, these offices. You go to the United States, you hear about the Solicitor General. You go to Belize, you go to Jamaica, you go to Singapore, you go to Hong Kong, you go to New Zealand. Why is the Attorney General and his gang seeking to abolish these offices? Why are they trying to change the names? What is the purpose? And not only that, Mr. Vice President, why are you seeking to merge?
They want to control.
That is the issue. They want to control. Mr. Vice President, they want to control. But to control, they must first destroy. They must first undermine. That is what they want to do, and then consolidate. That is what they want to do.
Playbook of the PNM.
It's the playbook of the PNM. Mr. President, so here what they did. In the Constitution, under, I think, Section 111, if I'm not mistaken, the titles of some critical office holders are located here. DPP, Chief State Solicitor, Registrar General, the Chief State Solicitor, or the Solicitor General. They know if they want to change that name to Chief State Attorney, they have to come for a constitutional amendment. Because it is enshrined rather in Section 111 of the Constitution. So you know what they did? They left it alone. So where that is located in the Constitution, the Deputy Solicitor General is not there. So that is why, Mr. President, they're going from Deputy Solicitor General to Deputy Chief State Attorney. What the hell is that? Sorry, Mr. President, I withdraw that. I withdraw that. I withdraw that and I apologize to you. Yeah. What is this? I have seen no job description.
Correct.
I have seen no kind of indication as to what this new Deputy Chief is going to be doing, Mr. President. But that is what they have introduced here.
Deputy
right?
For Rowley.
And so they're doing these things, and the people who are going to feel the heat would be the people of Trinidad and Tobago. Mr. President, do you know, under the rubric of the Office of Solicitor General, which is now being integrated and amalgamated with the Chief State Solicitor, the Solicitor General is the second advisor, legal advisor to the government. Do you know that? And the first one is the Attorney General.
So they're trying to bring all together.
So in other words, Mr. President, that office is very critical. And all the offices that fall under the Solicitor General is absolutely essential. You know what? They protect and safeguard our constitutional rights and freedoms. That is a very important role and function of the Solicitor General's office and that office holder. They go to court to fight matters that are brought, Mr. President, against the government and the people of TNT. They are in court. They are not instructing attorneys, as you find in what is called the Chief State Solicitor's Office. They are advocates. They go into courts. So you know what the AGM is planning to do? You know what the trick, Anil? Senator Roberts? You know what the trick? Undermine, weaken, discourage, frustrate, run them out of town. And then the fellows who did silk recently, huge briefs. Huge briefs. So what will happen, Mr. President, Mr. Vice President, is that the Attorney General is presiding over the destruction of another important institution in our nation. That is the Solicitor General's Department.
Shame.
And we want to make it very clear, Mr. President, that we are not in favor. We call on the Attorney General to withdraw this bill, to refer this bill, if he doesn't withdraw it, to either a joint select committee or a special select committee. Let us hear not from you, the Attorney General. We don't trust you. We want to hear from the lawyers. We want to hear from the workers. We want to hear from all of those persons, Mr. President, who are affected as a result
Mr.
of
Vice
this
President,
matter.
on a point of order, please. Standing Order 46-4, the members persist in using insulting language and inappropriate language in this chamber.
Senator, as you continue your presentation, just temper the language a little bit so that you may, I'm on my legs, Mr. Roberts, just temper your language a little bit and your tone. Thank you.
Thank you, Mr. President.
But we don't
So, Mr. President, what we are saying, when we look at this matter very, very closely, we are concerned. We are very, very concerned. And the Attorney General did indicate earlier that he was appalled at what was said in another place. But, you know, the workers, of course, the AG got a letter. He put it on record. Somebody supporting what the AG, well, not supporting, but indicating that what went on, he didn't support. So.
Let's have a procedural motion to attend, sir. Leader of Government Business.
Vice President, Mr. Vice President, in accordance with Standing Order 14.5, I beg to move that the Senate do continue to sit until 1 a.m. or until the completion of the business at hand, whichever comes first.
Honorable Senators, the question is that the Senate continue to sit until 1 a.m. or until the completion of business at hand.
No.
Inclusive of matters of the adjournment. Those in favor say aye. Aye. Those against say no.
No.
Senators, we're about to conduct a vote.
Yes.
More
Yes.
FC. Ms. Gopi Schoon.
Yes.
Mr. Sinanan. Ms. West. Mr. Mitchell. Ms. Cox.
Yes.
Mr. Bacchus.
Yes.
Mrs. Sagramsingh-Sooklal.
Yes.
Mr. Sookhai. Mrs. Lazama Leasing.
Yes.
Mr. Hislop.
Yes.
Miss London.
Yes.
Mr. Mark.
No.
Miss John. Mr. Roberts.
No.
Mr. Nakhid. Mr. Lyder.
No.
Mrs. Lutchmedial-Ramdial.
No.
Mr. Vieira SC.
No.
Mr. Timal.
No.
Mrs. Thompson-Ahye.
Sorry, no.
Miss Dr. Dillon. Professor Hutchinson.
No.
Dr. Patasar.
No.
Miss Maharaj. Miss Maharaj.
No.
Miss Maharaj.
What,
Miss
sorry?
Maharaj.
What? No.
Mr. Francis.
No. Okay, members, please. There's a division taking place, and I've repeatedly stated that this is a very important part of the procedure, and we need to hear every single vote. Continue, clerk.
Mr. Sinanan. Mr. Hussain. Dr. Richards.
No.
Dr. Ibrahim.
Yes.
Dr. Remy.
No.
Members, again, please allow me to complete the procedural motion that is now taking place. Honourable Senators, this Senate will now stand suspended for 15 minutes. Honourable Senators, the results of the division before the suspension is as follows. 15 senators voted for and 14 senators voted against. However, pursuant to Standing Order 117, there has been an agreement by the benches. I shall just read Standing Order 117 for the edification of all senators. Where agreement has been reached by leave of the President between the benches with regard to the transaction of any of the business of the Senate for any sitting or period, such agreement shall be announced in the Senate by the President, and the President shall, the provisions of these standing orders notwithstanding, conduct such business in accordance with the terms of the said agreement. I will call on the Leader of Government Business now to indicate what that agreement was. Leader of Government Business.
Thank you, Mr. President. Pursuant to Standing Order 117, there was agreement between the three benches in consultation with the Leader of Opposition Business and the coordinator of the independent bench, Senator Paul Richards, whereby we will today, at this sitting, begin and complete debate on the AJIPA bill. We will begin and complete debate on the National Instrument bill, and we would adjourn the current miscellaneous provisions bill at this point.
Okay, so Honourable Senators, you have heard what the agreement has been between the benches, and pursuant to Standing Order 117, we shall proceed as such. Leader of Government Business.
Mr. President, in accordance with Standing Order 48.1, I beg to move that the debate on the miscellaneous provisions, Judicial and Legal Service Bill 2024 be adjourned.
Honourable Senators, the question is that the debate on the miscellaneous provisions, Judicial and Legal Service Bill 2024 be adjourned. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Mr. President, the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, is an act that we have spoken to often in the last 8 months or more. It is an act, as we know, which has, from proclamation, abolished preliminary inquiries and introduced a new system by which summary and indictable matters are to be accomplished in a more expeditious manner. One of the material sections of the Indictable Proceedings Act, which I will refer to for convenience as a JIPA, is Section 33 of that Act, which provides 33.1, the Indictable Offences Preliminary Inquiry Act and the Indictable Offence Committal Proceedings Act 2014 are repealed. 2. Notwithstanding subsection 1, the Indictable Offences Preliminary Inquiry Act shall continue to apply to proceedings which were instituted prior to the coming into force of this Act, where no order is made under Section 32A. The consequence of that a JIPA Act having therefore been proclaimed is that preliminary inquiries, save in the limited respects to which they are saved by that Act, come to an end. We have, however, Mr. President, the Extradition Act, and by Section 12 of the Extradition Act, that is provides, 1, a person arrested in pursuance of a warrant issued under Section 10 and in respect of whom no order under Section 11.2 has been made, shall, unless previously discharged under Section 10.3, be brought as soon as practicable before a magistrate. 12.2. For the purposes of proceedings under this section, a magistrate shall have the like jurisdiction and powers as nearly as may be, including power to adjourn the case and meanwhile to remand the person arrested under the warrant, either in custody or on bail, as when the magistrate is acting at a preliminary inquiry. So we are faced with a situation which has been brought to my attention, Mr. President, because there are actually a couple of cases in the Magistrates' Court now in which the point has been taken that because the JIPA Act has repealed the Preliminary Inquiry Act, the magistrate has no jurisdiction under the Extradition Act to function as if acting at a preliminary inquiry. It is arguable that that is not the case and that the Extradition Act stands on its own, and arguments are currently being made in the courts to that effect, but it is equally arguable that a magistrate may not purport to exercise preliminary inquiry functions because that jurisdiction has been repealed by a JIPA. We cannot take the chance of that lacuna continuing to exist, given that there are pending proceedings before the court in which fugitives who are about to be extradited could succeed in persuading the magistrate on an argument that the magistrate has no jurisdiction to have them before him or her. And for that reason, Mr. President, we have brought before this chamber a one-paragraph bill, that is to say, the bill before the House this evening, to amend the AJIPA Act. And by clause 3 of that one-paragraph bill, we wish simply to add 2 further sub-paragraphs to the section that I've already read, section 33. So clause 3 of the bill says, section 33 of the Act, that is to say, the AJIPA Act, is amended by inserting after subsection 2 the following subsections. That is to say, 3, notwithstanding subsection 1, and that is the section which repeals AJIPA, and section 35(2), the Indictable Offences Preliminary Inquiry Act shall have effect for the purposes of the Extradition, Commonwealth, and Foreign Territories Act. And 4, subsection 3 is deemed to have come into operation on the 12th of December, 2023. That is the date on which AJIPA was proclaimed. So in summary, Mr. President, we are asking this chamber on an urgent basis this evening simply to save the continued function of magistrates under the Extradition Act by passing the amendment to section 33, which I've just read, and that is to say, notwithstanding the repeal of the AJIPA Act, of the Preliminary Inquiry Act, the magistrates shall continue to have jurisdiction for the purposes of the Extradition Act under that act, and therefore we are saving the continued operation of the Preliminary Inquiry Act from December to continue to be exercised under the Extradition Act. And I don't think I need to explain it in any further detail, Mr. President, and therefore in those circumstances I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Senator Mark.
Yeah, Mr. President, as the Attorney General explained, this act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, is required to address what can only be described as an oversight or lacuna in the legislation, even though we have had 6 to 7 amendments to this particular Administration of Justice Indictable Proceedings Amendment Act. And yet still we, even though it was proclaimed on the 12th of December, I think that's the date I'm seeing before me, sometime in December of 2023, unfortunately, the provisions needed to save and to ensure, Mr. President, that preliminary inquiries under the Extradition, Commonwealth, and Extraterritorial Commonwealth and Foreign Territories Act continue so that not only there would be justice, but there would be equity and fair play in this whole exercise. So I don't think there's any need to detain this Honorable Senate. I think it is an amendment that is required, has been recognized as needed to address this loophole in the law that could have had severe consequences later on. So we support the amendment to the Indictable Proceedings Act. That is the preliminary, if I may say, Mr. President, the Administration of Justice Indictable Proceedings Act 2011, Act 20 of 2011. We support the amendment to that piece of legislation to address the areas as outlined by the Attorney General. Thank you very much.
Senator Vieira.
Thank you, Mr. President. As the Honorable Attorney General has pointed out, the Administration of Justice Indictable Proceedings Act repealed and replaces the Preliminary Inquiry Act, but proceedings under the Extradition Act referenced committals under Section 12 and at Form 6 as when the magistrate was acting under a preliminary inquiry. This legislation is essentially procedural, aimed at ensuring that processes remain consistent. So I agree with both the Honorable Attorney General and Senator Mark that there should be no procedural lacunas in our legislation. This amendment will help reduce error and will lead to more reliable outcomes, and of course it upholds the principle of justice for all. I thank you.
Thank you very much, Mr. President, and I rise to compliment my fellow senators, Senator Wade Mark on behalf of the opposition bench and Senator Vieira on behalf of the independent bench, and to thank them for the collaboration that we have been able to work at this late hour of the evening. And I say only one further thing, and that is that the advice which was given to me, which caused me to bring this legislation, has the support and the advice of the Director of Public Prosecutions. I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Mr. President, in accordance with Standing Order 661, I beg to move that the Administration of Justice Indictable Proceedings Amendment number 2 Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Administration of Justice Indictable Proceedings Amendment number 2 Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, this bill has 3 clauses in it. There have been no circulated amendments, so we shall proceed accordingly. Clerk.
Clauses 1 to 3.
Honourable Senators, the question is that clauses 1 to 3 stand part of the bill. Honourable Senators, the question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Attorney General.
Thank you, Mr. President. I wish to report that the Administration of Justice Indictable Proceedings Amendment number 2 Bill 2024 was committed and considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Administration of Justice Indictable Proceedings Amendment number 2 Bill 2024. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Minister of Tourism, Culture and the Arts.
Thank you very much, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Provide for the Designation of the Steel Pan as the National Musical Instrument of the Republic of Trinidad and Tobago and for related matters be now read a second time. Mr. President, it is indeed a privilege for me to serve as a minister with the responsibility for culture to pilot this bill on this historic occasion. Mr. President, the bill, while of great national and cultural significance, is a simple one. It seeks to designate the steel pan using the Parliament, using legislation, as the national musical instrument of Trinidad and Tobago. The preamble to the bill affirms the commitment of the government toward developing, safeguarding, and promoting culture and the arts, and sustainably strengthening the cultural sector. It then delves into the history of the steel pan and the need to give formal recognition to the fundamental value of the steel pan as it belongs to the Republic of Trinidad and Tobago and its citizenry. Mr. President, the bill contains 4 clauses as follows. Clause 1 and 2 of the bill provide for the short title and interpretation sections of the bill. Clause 3 seeks to declare the steel pan as a national musical instrument of Trinidad and Tobago. Clause 4 will require the minister to whom the responsibility for culture is assigned to prepare and lay in Parliament a biennial report on the recognition, status, promotion, development, and impact of the steel pan at national, regional, and international levels. Mr. President, now that we understand what the bill is purporting to do, I will now add some context as to why this is necessary and why this bill is the legal framework to designate the steel pan as the national musical instrument. On July 24, 2012, the world-renowned British Broadcasting Corporation, the BBC network, reported, amid the electronica of 20th century music, one new instrument stands out for its simplicity: the steel pan. Possibly the only instrument made out of industrial waste has become an icon of Trinidadian culture. 11 years later, on July 24, 2023, following a resolution put forward to it, the United Nations at the 77th session of the United Nations General Assembly in New York officially declared 11th August as World Steel Pan Day. Mr. President, these are just some of the international strides and global recognition of our revered instrument, the steel pan. Mr. President, this instrument serves as an important thread in our cultural tapestry and weaves together our diverse identities and experiences, a central element of both our tangible and intangible heritage. Culture is not merely a collection of artistic practices, but a system of shared values, imagination, and ideologies derived from those artistic expressions. This system of shared values creates social cohesion and fosters a sense of community. This system recognizes the importance of the people in shaping and preserving our nation's cultural identity. Mr. President, I recently attended the launch of a book on the history of Trinidad All-Stars Steel Orchestra titled Metal and Metal, written by Bucker Rennie, during which Mr. Eddie Hart, former Member of Parliament for Tunapuna, spoke, giving an inspiring story about his experience as a young man joining the All-Stars Steel Orchestra. His story was one of a young boy finding community and mentorship which helped him transition into adulthood and himself becoming a leader and mentor in that band. This story is a common one that is replicated across many panyards across the country. Mr. President, the preservation and promotion of a nation's culture is the collective duty of its citizens led by the government, which creates an enabling environment for culture to flourish. By understanding, appreciating, and preserving our own culture, we not only strengthen our sense of identity and continuity, but we also foster greater understanding and respect for the cultural diversity that exists within and beyond our national borders. Mr. President, despite its international proliferation, the genealogy of the steel pan traces and roots back to its cradle of Port of Spain, Trinidad, as an indigenous and principal acoustic musical instrument of Trinidad and Tobago forged on this country's soil. The official birth of the steel pan prevailed in the 1930s and 1940s, and it is heralded as the only invention of a new family of acoustic musical instruments in the 20th century. The genesis of the steel pan is deeply rooted in both struggle and celebration, oppression and innovation. Steel pan represents an unwavering commitment to freedom and cultural self-expression in the Trinidad and Tobago context that directed the innovative energy of our people towards the creation of this extraordinary musical instrument. An intrinsic part of this story is the remarkable individuals who played pivotal roles in the creation and advancement of the steel pan. It is therefore imperative that we acknowledge their contributions on this landmark occasion, where we intend to enshrine the steel pan as our national musical instrument through this legislation. Among these notable figures are Winston Spree-Simon, Ellie Manette, Anthony Williams, Neville Jules, and Bertie Marshall, distinguished for their prowess as steel pan creators and players. Winston Spree-Simon, a native of Trinidad and resident of John John, is renowned for his role in the development of the ping pong, which became the tenor pan of today. Ellie Manette introduced the innovative concept of the concave sinking into the steel pan surface, departing from the traditional convex approach, thereby contributing significantly to steel pan evolution. Anthony Williams stands out for his multifaceted contributions to the steel pan, excelling as an inventor, tuner, innovator, and esteemed performer. He is widely revered as one of the foremost figures in the history of the instrument. Mr. President, and of course the steel pan movement would not be as we know it today without the well-known bomb competition and the concept of the bomb tune created by Neville Jules. The steel pan is thus authentically Trinbagonian and deeply emblazoned within our history. Equally, we must consistently strive to not merely venerate our steel pan, but also to rebrand it as uniquely Trinidad and Tobago. The steel pan continues to be a source of wonder and national pride for our nationals and our diaspora. Today, the instrument is a mainstay of this country's annual carnival celebrations and has been adopted, manufactured, sold, and generally celebrated not only locally but also internationally, with steel pan competitions and events taking place on all continents across the globe. Contemporary pioneers such as Len Boogzy-Sharp, Duvon Stewart, Leon Smooth Edwards, Ainsworth Mohammed, and Kirsch Ramsey continue to advance the work of their respective steel orchestras. Mr. President, this bill, once assented to, will provide the long-awaited recognition for the efforts of these steel pan innovators, pioneers, and the steel band movement, reshaping our steel pan from the de facto into the de jure national instrument. While acknowledging the achievements of those nationals who develop, use, and promote the instrument, it is a very important exercise. The steel pan emerged from the grassroots, many of whom toiled without financial reward or the guarantee of recognition. This legal commendation will therefore also serve to acknowledge those who labored tirelessly, continually breathing new life into our versatile instrument, elevating its status and disseminating its artistry around the world. Mr. President, it has long been the policy of governments, past and present, to have the steel pan designated the national musical instrument of Trinidad and Tobago. In 1992, under the PNM, the then Minister of Community Development, Culture and Women's Affairs recommended to Cabinet that the steel pan be declared the national instrument and recognized as a national treasure of Trinidad and Tobago. In that same year, the late Patrick Manning, then Prime Minister, declared the steel pan as the national musical instrument during his independence address. But notwithstanding these recognition efforts, the legal declaration of the steel pan as our national musical instruments remains unrealized. Mr. President, the bill before us today was not created in a vacuum. This bill and the policy which informed it were created and crafted in close consultation with key stakeholders, including, but not limited to, the world governing body, Pan Trinbago, steel pan academics, Dr. Mia Gormandy from the University of Trinidad and Tobago, as well as other stakeholders in the steel pan industry. And at this time, I say a special thank you to the executive and the president of Pan Trinbago, Mrs. Beverly Ramsey Moore, Mr. Henry Harper from Pitti Valley, and of course, Mr. Martin Daly, SC, a pan enthusiast and the legal advisor to Pan Trinbago, for the continued advocacy and for the recognition of steel pan as the national musical instrument. Mr. President, over the years, there has been consistent clarion call by key stakeholders within the steel pan fraternity and the public at large to have the steel pan designated as the national musical instrument of Trinidad and Tobago. A few of these calls. In a letter to the editor in the Guardian newspaper on the 25th of January 2022, submitted by Henry Harper, entitled Pushing Pan Forward, he wrote, "It is time for the national community to push pan forward in order to ensure that the powers that be recognize its true value by having it proclaimed our national musical instrument." On the 10th of August 2023, a Daily Express editorial entitled Let's Proclaim the Pan as Ours, in it wrote, "The pan is indeed the source of our magical ability to move beyond despair by creating something out of seemingly nothing. To rebuild our shattered confidence, we must tap into the power of the pioneers who gifted us the pan. We can start with the bold proclamation that the pan is indeed officially ours." On the 11th of September 2023, at the ceremonial opening of the 4th session of the 12th Parliament, our own Head of State, Her Excellency, called for the steel pan to be recognized as the national musical instrument of Trinidad and Tobago, when she stated, "My hope is that the Parliament will, in that vein, pull together to enact laws that are even more reflective of our society's goals and vision, including in relation to legislation that protects and advances culture and the arts. In particular, I hope that it will be seen fit for there to be an urgent parliamentary intervention that results at long last in the steel pan being firmly and irrevocably declared our national instrument. Those in the industry will tell you that giving the steel pan formal and official national instrument status is critical to opening doors for the industry in international markets. The General Assembly of the United Nations has formally recognized the universal value and significance of the steel pan. I believe that it is high time that we formally do the same." And that is what we're here to do today, Mr. President. And of course, on 26 October 2023, our own senator, Senator Maharaj, filed a motion which provided, among other things, that whereas citizens widely revere the steel pan as the national musical instrument of Trinidad and Tobago, yet the recognition of the steel pan as the national musical instrument of Trinidad and Tobago has not been codified in law. Be it resolved that the steel pan be declared the national instrument of Trinidad and Tobago. Mr. President, now more than ever, the nation has arrived at a juncture wherein it is primed to focus our attention on the cultivation and enrichment of its cultural landscape, to safeguard the legacy acquired. This endeavor is in harmonious accord with the overarching objectives of Vision 2030 and the National Cultural Policy, embracing our traditions, honoring the artistry and craftsmanship that molded our musical landscape, therefore creating opportunities to foster economic diversification. The designation of our national instrument marks a vital moment in our nation's journey towards celebrating and preserving our identity. Mr. President, the bill will significantly enhance our international marketing strategies for the steel pan, as well as for our local culture generally, helping us to truly and unapologetically exploit the power, allure, and mystique of our musical instrument. This is critical given the instrument's versatility, its current international recognition, and immense commercial potential as a desired instrument for musical performances and education. Endorsing the steel pan as the national instrument of Trinidad and Tobago through legislation will also serve to market the steel pan fraternity, carnival, and by extension, all of Trinidad and Tobago's culture. The designation of the steel pan as our national instrument will increase the opportunities for strategic investments and intensify penetration in the highly competitive global, cultural, and creative market. In addition, this designation has the potential to act as a catalyst for the increased production, promotion, distribution, and commercialization of our national instrument, which will redound to the benefit of our citizens. The declaration as our national instrument will once and for all remove any doubt that Trinidad and Tobago is indeed the home of the steel pan. Mr. President, once assented to, this bill has the potential to raise the profile of Trinidad and Tobago. Studies have shown that the possession of indigenous instruments promotes tourism development, economic growth, and the distinctive global recognizability of nations. One such study in 2020, entitled "The Role of Traditional Music in Tourism Destination Development," concluded that traditional music is an endless source that can be tapped to develop event and experience tourism, and, in particular, heritage tourism. Several prominent instances of employing traditional music in tourism are evident in various regions. Notable examples include Ireland, renowned for establishing a robust tourism image rooted in traditional Irish music; Austria, celebrated for its alpine traditional music; and Canada, particularly Cape Breton Island, where Celtic traditional music holds significance. While traditional music forms an integral part of the local resident's identity, it offers tourists novel experiences and opportunities to immerse themselves in the traditional values of the destination they are exploring. Mr. President, throughout the globe, national musical instruments have reinforced the connection between indigenous instruments and music-based tourism, and supports a country's unique selling proposition of possessing a unique and distinctive culture. And Mr. President, allow me to revisit Clause 4 of the bill, which is a critical feature, and that is the inclusion of a mandatory reporting mechanism by the minister to whom the responsibility for culture is assigned, The legislative requirement for the preparation and submission of reports to this Parliament is a tried and tested avenue for accountability and oversight. Once this bill is passed, the responsible minister is statutorily mandated to produce a biennial report to this Parliament, which will contain key updates on steel pan development, including its recognition, status, promotion, development, and impact across the national, regional, and international levels. This statutory reporting mechanism will provide accountability, transparency, and enable parliamentary scrutiny in all steel pan-related affairs on a worldwide scale to our citizenry, while enabling legislative oversight on the progress and developments secured for our national instrument. Last but certainly not least, Mr. President, this bill, once placed on our national books, will secure preservation of the socio-cultural and historic development and significance of the steel pan. The declaration of the steel pan as the country's national musical instrument will firmly acknowledge the pivotal role that the steel pan has within our musical history, ensuring that Trinidad and Tobago is indelibly recognized as the indisputable home of the steel pan and acknowledging steel pan's contribution to the world of music. Mr. President, we have listened and responded to the repeated entreaties of our steel pan producers, tuners, our jurists and legal luminaries, our historians, other stakeholders, but most importantly, our citizens in heeding the call towards the legislative declaration of the steel pan as a national musical instrument of our Trinidad Island Republic. This bill will statutorily codify the universally accepted fact that the steel pan is a product of our own people's innovation and a significant element of cultural heritage. Mr. President, I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Provide for the Designation of the Steel Pan as a National Musical Instrument of the Republic of Trinidad and Tobago and for related matters be now read a second time. Senator Nakhid.
Mr. President, once again, in the name of God, the most gracious, the most merciful. Mr. President, I must say this is the first time that I've been disappointed with the Minister of Tourism, Culture and the Arts. Well, the second time in 2 days, actually. Because I listened on the other house on television, and after a brilliant presentation by the MP for Moruga Tableland, after she really went in heart and soul, because when you're talking about pan, it's not to come here with 5 pages and just read for 40 minutes. It's to talk about pan from your heart, from your soul. Yes. Because I'm not writing a note, Mr. President, because I was born into pan.
Tell him.
He come and, the minister came and spoke about pan. And he mentioned Laventil once.
He did what?
Once he mentioned it?
Just once, only once.
Well, how you can mention Laventil and not mention Laventil Desperados?
He did.
Laventil? No? And more so than that, he didn't mention the premier innovator in pan, the hammer, Rudolph Charles. So I must admit to missing some of the presentation as I was praying. But when I listen to this sterile, non-creative submission on what is supposed to be something that stirs not only the soul, but uplifts entire communities, then I have to wonder, well, I don't wonder anymore. onto why the PNM is not only decades late and millions of dollars short in addressing PAN as a national instrument. They are decades late, and millions of dollars short. Because we have an instrument that came out of the, as he said, the oppression, the suffering of people in the hill. And I was glad enough to be a 9-year-old, 10-year-old boy, witness to my uncle with the hammer making those pans. Double tenor, rocket pan, all his innovations. Not one mention of that. Not one mention of that here. Just as sterile, like somebody wrote that for the minister. So he gave us a historical background, superficial by its nature, but not really coming into how the PAN uplifted that community that they failed to uplift, that they represented, but that PAN held that community together. Not only in Laventille, but along the East-West corridor. As a matter of fact, if Laventille is to serve in a socio-economic way as a litmus test for this government, then surely PAN is a litmus test to how they have treated culture and the arts, which they have abused and mistreated over the course of their entire tenure in government. I mean, here we are. Who they fooling? When they come here and talking about PAN as a national, for us citizens, we know PAN is a national instrument. Not only do we know PAN is a national instrument, PAN is every Trinbagonian. Every Trinbagonian. Whether some of them like PAN or not, when they go abroad, Mr. President, one thing they could say, PAN come from Trinbago. One thing they're proud to say, PAN come from Trinbago. So if cricket and football, which the English exported to all corners of the world, and they like to claim that, they win one World Cup, but they like to claim they export football, FA. We can't claim that with pride here. The Japanese have gone way ahead of us in terms of how they manufacture pans and so. We playing catch up. We playing catch up with this government to how we manufacture pans. And who in charge of that? Let me tell you who in charge of that. Not in charge of that are the pan men who suffered in creating what we now call pan. Not the pan men in charge of that. It's businessmen who came in. I don't want to talk about any specific community, but we all know, we all can see, but it's certainly not the people from Laventille. Certainly not the people from East Port of Spain. Certainly not the people up and down the East-West corridor who suffered under this government. Let me tell you how, and I relate it to in contemporary times. I only go for Carnival, Mr. President, I only go to the Panorama. My honorable colleague over there helps me with those tickets, and I thank him for that. But I'll have you know something. When you go to Laventille Desperados, Panyard, the greatest pan side in the world has ever seen, I'll give Renegades a second place together with All Stars. But we can all admit, when they talk about marketing pan to the world, they're way behind. Laventille Desperados in the 60s with my Uncle Rudolph and Uncle Jerry Walton and Uncle Kenneth Charles were playing in Carnegie Hall in the 60s. They don't even know that.
Yes. Preach, brother, preach.
They don't even know that. Yes. They were making tours to Asia in the 60s and sending us back pictures. Let them Google it. Look, you gotta Google it. They gotta Google it. They're sending back pictures of them performing in all these majestic halls together with philharmonic orchestras and all of that. They don't even know that. They don't even know that. Dressing up nice, meeting kings and queens, royalties. White suits. What's that, son? When for that, look, oh, Senator Vieira, call her name. When for that, they know. Every citizen know. We don't have to wait for them to come and tell us what pan means to us. Hear what? The Nakhid family is not no fun of panning. We is panning.
Yeah.
We not no fun of panning. I don't like panning. Mr. President, nothing move me like this. I don't like panning.
You should have been Nakhid pan.
I pan, we pan. The only thing my father, a Lebanese man, could have stomach about carnival, I would say it was pan. I could only get permission to go and push the Spurs pan. That is the only thing I had permission to do in carnival. And they come here and give us some trivial, historical, superficial overview, a pan, and who invented, yeah, with respect to Manette and P. Simon. I know all the names. Respect to all of them. But what are we doing for pan now? What are we doing for the pan men now? Who, when they play pan, and they go in Desperado's pan yard, the finest pan side in the world, when they go in the pan, and they finish a set, you see people taking up the pan and running to play in a small or medium-sized band. Why? This government paying them $500 for the year, for the season. You can believe that? $500 for pan men and pan women for the season. So they had to pick up the pan. So after you listen to the first set, let me say they start 8:30, they finish by about 11:30, the first set, right? They take a break. When you come back 12:30, 1 o'clock, half the pan side gone. You know why? Them fellas had to look fit. The moment I had to look fit in another pan yard, Mr. President, to make some money. So they're running from pan side to make money. When our pan instrument, by now, with proper representation from this government, who has been in power for over 50-something years, our pan men should be professionals. Yeah. Our pan men should be professionals. Not no meager offering, $500, and just lip service to pan. What kind of stupidness is that? And then they want to talk about fighting crime and creating and having the diversification. You have the diversification slapping all in your head. Right there it is. That is it. Pay attention to that. Minister of Trade and Industry. That is diversification right there. Pan. How we can market that to the world. How we can market it here. How we can make the lives of pan men and pan women substantive enough that they don't have to be just eking out a living. And I'll give them some ideas. Under a UNC government, every community that has a pan site, that pan site after the carnival is done, they will have to go into those schools and those communities and teach them pan in schools. Not like this government who cut pan in schools. They cut funding for pan in schools. How you want to come here and tell us now that you represent in pan? It's really shameful, Mr. President. It's really shameful. I think the only benefit we had from that is from a historical perspective. There was nothing, not only substance, there was nothing profound about it, completely shallow. And I was surprised, I was disappointed in the minister. I thought he would come and maybe just really give us a historical perspective and then talk from the heart. But he cannot. He cannot. And don't come here and try to insult me after. He's not Michelle Benjamin, eh?
I know dairy farm over here. I know dairy farm over here. Right.
But I feel sorry for the minister. I'll tell you why. He's a minister in our government that really and truly has never showed any care for the national instrument. As a matter of fact, they have never showed any care for our creatives in this society. And that is a fact. This is a government that doesn't understand the benefit of creatives. If they did, what they will realize that creatives can mitigate against crime. Creatives can still generate employment. They don't understand it. This is a government, one-trick ponies, I call them. Energy, oil and gas. energy, oil and gas, and then lip service to diversification. They don't understand how tourism can mesh with pan. They don't understand that. I'll give you an example. Lavantil Desperados, the greatest pan site in the world, was forced to move from their pan theater up the hill because this government cannot control crime and provide security. So our players, Lavantil Desperados, the finest pan site in the world, our players are afraid to go up the hill. Even those in the community are afraid to go from down in the quarry to up in Picton. To over in St. Barb's, they're afraid to come across by Despelly Crescent. They don't want to come because they can't provide security. So all of it is meshed. And I think Senator Maharaj mentioned it in the previous debate. That crime is the overriding factor that stunts growth in every sector of the society, and they don't understand that. So they just get annoyed when we always talk about it. When I think the member for Diego Martin is crime. Exactly that. It is crime that stunts growth in tourism, culture and the arts, in sport, in national development. But they don't recognize that, and they don't have the intellectual capacity to realize that we could now use pan. Not just in a superficial way, talking about pan. Like if they know, they come along and reinvent the wheel that is pan. Mr. President, if I tell you how I have seen pan calm down a whole community. I've seen it my whole life. Give you an example. It was 1975, no, 76. Because we won Panorama that year. Lavantil Desperados, finest pan site in the world. We won Panorama that year. There was trouble on the hill. So then you hear that song from David Rudder, Where the Hammer Gone. I know where the hammer went. And I know the hammer is the one who pulled that community together in 1976 and take them down the hill and beat everybody's tail in that Panama because they are trouble. I'll tell you what else pan could do, Mr. President. I watch my uncle. I also watch the founder of their party, Dr. Eric Williams, because he used to come up to Uncle Rudolph's mom and Auntie Georgie. He used to come to see Uncle Rudolph.
Real life stories.
So I give you not hearsay, not what somebody write for me, because I see a little boy by Grandma Melda, because houses right next to each other. Grandma Melda, my grandmother, and the mother of Uncle Rudolph are sisters. So I right here watching when the great, according to them, Dr. Eric Williams, come up the hill to see Uncle Rudolph. Because any trouble the PNM had with any unions or anybody, he coming up the hill. Because who could stop the union? Who could quell that disturbance? Lavantil Desperados, the finest pan site in the world. So he come up to Uncle Rudolph, and I there. And if you see that famous picture with Dr. Eric Williams walking up the steps, and Uncle Rudolph and Auntie Georgie waiting for him to come. I saw that. I was there. I witnessed that picture taken. I was there. So they can't come and tell me about pan. No matter what they try to throw after or wind up after, they can't tell me about pan. All they can do is have somebody Google it and have somebody write about it. I could tell them what pan means to Trinidad and Tobago. I could tell them what pan means to the community. So when they treat pan men with the disregard that they have treated them, or they treat with them $500 for the season, when under the UNC, back in 2014, was giving pan men $1,000. Back in 2012, 2014. Yes. would imagine, Mr. President, that progress would have been made in terms of remuneration. And since the minister wants to play coming hard, I'll go him harder. So when pan men get $500, certain people making $70,000 a month. In pan, $70,000 a month, certain people are making. And you have to ask yourself, what kind of conflict of interest is that? That the minister, I ain't gonna go hard on him, if he's but suffice it to say, $70,000 a month, by what they're paying, that's about 140 pan men. Somebody benefiting in 1 month what 140 pan men getting in a whole season. And they want to come and tell us about pan. And they represent pan. Political hypocrisy. And although we might find some jocularity with it, it's sad. It's sad. Because if that person, that citizen, who when approached about, well, how come there's seemingly a conflict of interest as regards the pan, that you are renting, you are the landlord, benefiting $70,000. You know what's the answer? From a lawyer. Not SE yet, but from a lawyer. He said, I asked the president of Panchinbigo, and she said it was okay. Look at the kind of craziness we faced with when it comes to pan. I read that in the papers. That he asked the president, Beverly Ramsey Moore, about
point of order 46. One relevance.
So,
all right, so, member, you are talking about pan, and you're talking about the fact that the Minister of Tourism, can't talk about pan more than you, and you've been saying that quite a number of minutes. So, again, if you have any new points to bring in, bring them in.
Yeah, well, I'll finish this point and go on to others. Because that shows you the disregard that the PNM has for pan. It shows you that they come here and talk about, like, if we don't know the history of pan also, that we read a book. I am going more in depth to show you the suffering and plight of the pan men that they have disregarded over the course of the pan history. That's what I'm showing you.
This motion is not enough.
In other words, this bill or motion, whatever they brought here, is clearly not enough. They like to come with these things just to satisfy a certain portion of the population. Yes, we brought that. As a matter of fact, I feel they brought this, you know what? I feel they brought this because of the motion brought by Senator Sunity Maharaj. I really believe that. They had no intention of recognizing pan. They don't care about pan. They don't care about it. I think that motion brought by her, by Senator Sunity Maharaj, spurred this government to bring this what they brought here today. And again, it's insufficient. And that is what I am trying to show you. I'm trying to show you that even the pan instrument that doesn't have a home, and I'll get to that just now, that doesn't have a home, that was granted land, they will come and say, well, it wasn't the name of Panchinbigo, and it was there, but it was given. Articles will show that Carney granted that land under the UNC to Panchinbigo. About 13 acres. 15? 8 originally, moved to 13. Then why didn't they take it forward? If they so like pan. They're in government more than us. They don't like to boast that. We here, we had to deal with it. They're in government more than us. Why didn't they take it forward?
9 years.
And then take that land, expand on it. Let me tell you what that could have done and what we intend to do. That land, not a little piece of land by post office now that they're trying to give and making people feel that that's sufficient for the home of pan. You have 13 acres. You know what you could do with that? You have an administrative building. You have a pan museum. fitted, you have a hotel, tourism, manufacturing, you could do all kind of things. You could have a place where pan men could go and truly feel they have something. They didn't do none of that. For them, everything is expeditious. Just like they try to run through everything here in the parliament. And kudos to the independent bench on telling them I resounded no, Senator Vieira. Well done. They like to do that with PAN. So now, if they want to come and talk about PAN, clearly PAN means nothing to them because it could just come and all of a sudden find an Indian businessman and grant him that PAN land and tell us that they had consultations. Well, I beg to differ. And I'll tell you what was the submission of one Fuad Abubakar and Gulson when they were asked about it. Well, first of all, in the JSC represented by Senator Roberts, he asked the question to Beverly Ramsey Moore, President Panjimego. And she actually was quite mendacious. It reminded me of the Attorney General we have right now. She was quite mendacious. He asked her about that PAN. She said they had consultations. Upon further investigation, there was no such consultations at all. Half the PAN members did not know about those consultations.
Mr. President, 46-1, please.
Okay,
Very important.
Again, Senator Nakhid, it's sounding like you're going in circles in making the point that you want to make. If there's something relatively new that you could bring forward, I invite you to do so.
Mr. President, I don't know what could be more new and more relevant than us discussing how the PNM has not only paid lip service to PAN, they have actually taken away the land granted to PAN. I don't understand what is more relevant than that.
Making it a national instrument, we're removing the land.
And then in cahoots, seemingly, with the president of Panjimego, who obviously was not forthright, parliamentary language.
Wasn't forthright.
Wasn't forthright.
Yeah, that's fine.
She wasn't forthright. She said they had consultations. Upon further investigation, some of the Panjimego members said they were never consulted, and they do not agree with what she said.
She was misleading.
That they agreed to give back this land to the government. No, they never agreed. That's a one-woman decision, one-person decision. That's like when the president told to the honorable minister, when he asked about, he said, do I have a conflict of interest in renting out my property to Panjimego? And she told him, no, you good. And he was good with that. He was good with that.
Mr. President,
that was in the papers. No, that was in the papers.
46-1.
Okay, so
can't take it.
Again, no, Senator Nakhid. So this bill is about making PAN the national instrument. And I get the fact that it's all about PAN, so you're talking about land promised to Panjimego and all of that. That is a little bit outside of what is before us because it's PAN national instrument. That's where the boundaries remain. Okay? So bring it back in.
President, respectfully guided, but I'm trying to show how we just can't say something is a national instrument without creating the framework and infrastructure for it to be the national instrument.
Yes. You have to create infrastructure. What? Just a piece of paper?
The English didn't say we are the home of football and throw one or two balls on the street and tell all they go and make England the home of football. They created a structure, rules, legislation. They built facilities, infrastructure. They sent players here. They sent players to Brazil who exported the game. They sent players to Central America, to Asia. That is where you call PAN. What did we do? We let other people take that burden and run with it. Then we let other people take the PAN and run with it. And now they're taking our land. They're taking the PAN men land. And all they think we come in here and stand for that? We're not standing for that. We're not standing for that. PAN men suffer enough.
We will get them back. Desperado, the greatest guy.
So, Mr. President, This is not just about we'll come and talk about pan. You know the PNM already like to bring legislation and then try and narrow it so nobody could talk about it and understand it all. No, this is not one time. No, we're not standing for that this time. I'll tell you why. The pan is too important. The pan is too important. Played mostly in underprivileged communities that we need to uplift. And we can't pay lip service like people that pay lip service. They just come and ship champagne 3 months of the year and play the listening to pan and then tell you how them love pan more than you. I'm not joking when I talk about I grew up in this thing. I grew up in this thing. Just make any point of that now. Just refer into that, Mr. President.
So I know. We've heard it several times.
Okay.
Move on.
So therefore, Mr. President, in creating that infrastructure and framework to make PAN truly our national instrument, it requires certain things. They didn't come and tell us what is the initial investment, for example. They didn't say nothing about that. How are we going to know what investment they're going to make PAN? Just normal PNM lip service. They didn't tell us, well, here what? They tell us what? They're taking that land, but they're giving us the post office, the old post office. Look at that small piece of land they want to get PAN. What PAN men could do on that land?
National instrument.
So they're taking 13 acres where they could build a complete home of PAN, where people coming from the airport could just duck in, where the same Minister of Tourism might finally find something to do in his job, other than wait for cruisers to come and offer employment. He might find something to do. They want to give a billionaire the land. I ain't going to talk about nothing. To build a cricket academy, where we have a cricket academy that's underused, underutilized, never been used for purpose. Overspent. But they don't understand that.
But overspent, $1.2 billion.
I wouldn't even talk about the corruption with that. I'm just telling you we have a cricket academy that has never been used.
Brian Lara, in fact.
I get into every point, Mr. President. I get into every point. So they want to build a cricket academy on that land, and the question we have to ask why. If they so want to pay homage, be patrons of PAN as the national instrument, what have they shown to us, the citizens of Trinidad today? The communities that PAN, if truly was the national instrument, could uplift those communities that right now are mired in crime and underdevelopment. What have they shown us? They never came one time here, for example, as I spoke briefly about. And I want to elaborate on that. The PANs in school. Do you know that in certain PANs of the world, in certain countries of the world, PAN is not a required course. You have to take PAN. Japan is one of them. In Trinidad and Tobago, is optional. Still optional. In some of these schools that still have PAN, and most of them, because one of those schools in Tinapuna came to me to ask for funding to help them. They don't have this, they don't have that. We were talking about that.
When we in government, we will take it.
Exactly, that's the point.
When we in government, we will take it.
This government, as you know, Mr. President, has left everybody with empty pockets.
Yes.
So I couldn't give the PAN people anything.
I know.
But I assure you, Mr. President, once the UNC is in government,
think bad.
PAN men will be seeing a much better future. Yes. A brighter horizon. And I'm very serious about that. And I want to go back a little bit. I want to go back a little bit. My uncle, who was not mentioned here.
Which one?
I take it as an insult. The hammer. I take it as an insult, personal. He has not been mentioned here. This is the second time. The first time was a proclamation by the PNM Mayor, Martinez, when he spoke about the great innovator, and a proclamation, not once mentioned Rudolph Charles. Well, I don't know why. I'm not a conspiracy theorist to say, but I wonder if because I was Nakhid uncle, that they ain't mentioning Rudolph Charles.
Very possible, they're that vindictive.
I say, but these people could be so... I don't want to believe that. I'm not a conspiracy theorist. But it's just a little bit too much right now. That the Minister of Tourism... Huh?
Scotland?
The Minister of Tourism, Culture and the Arts could speak 40 minutes and about not only the inventors of pan, the innovators, but they didn't mention him. And I'll tell you what, I believe, as well as my family, that the promises made to the pan men by the then government of the day, the PNM government, by Dr. Eric Williams, by George Chambers, and to some extent by Patrick Manning, I believe that left my uncle heartbroken. I really believe that. Because I know what he did for the PNM when called upon by Dr. Eric Williams. I know. I wouldn't say it here. But they're too young to know. But I know what he did. That is not no folklore I'm talking about. I know what Desperados was called upon to do by the PNM government. And they carried it out. And I know what they expected the then government to do for the Lavantil community. Never came to pass. Never came to pass. And we have to ask ourselves why. I mean, we all know the famous story of Dr. Eric Williams coming down in Lavantil by the basketball court and he always saying about the Bajans at Lavantil. But when he came down to Lavantil, all he didn't see Bajans, all he saw was poor Johns. What have they done since then to alleviate that? Lavantil still poor as ever, if not poor. The once thriving community spirit that we had, from Picton to St. Barb's and beyond, down into the quarry, not there anymore. No, they want to come here and regale us with a history of pan, and they recognize as pan, and they will want to say, well, they bring this pan as a national instrument.
Small thing taking picture about pan. The mankind spell pan.
I don't want to say that again. Decades late.
Senator, you have 5 more minutes.
Decades late, millions of dollars short. So, Mr. President, I didn't need anybody to write me anything about pan. And I don't say that to cast aspersions on the minister. I know he really knows not more pan. It's not his domain. And I understand that. If you have people in Trinidad, when Carnival come around, they know all the pan. The biggest pan lovers. But as soon as Ashwenze reach, as soon as they want to hear pan. Nowhere. They ain't going nowhere to find out how the pan men do it, what they could do for the pan men. If they need help with anything, a hamper. I'm glad to say I've given out hampers up and down Lavantil. I've been castigated for that by people who say, well, why are you giving here, why are you not giving there? I give it to Lavantil because Lavantil is my community. My community, Lavantil. And Lavantil Desperados comes from that community. And if you cannot honor Lavantil Desperados, and I'll leave it with this. I will leave it with this.
Oh, that's so funny.
I'll leave it with this, Mr. President. I'll ignore the mumblings and rumblings from the peanut crowd.
The peanut crowd.
I'll leave it with this. This government, in proclaiming their love for pan and Lavantil Desperados, said that they would give Lavantil Desperados their own pan place. Because you know, others moving from place to place. After we couldn't go back on the hill from the crime and insecurity that they created. Okay. So you move from Chagrin Road, they build a so-called pan theater in George Street. Do you know, Mr. President, when I investigated that, the lease for that property, 9 Lavantil Desperados' name?
So they're talking about us with the land.
I want to call who name it is. It's not in Lavantil Desperados' name. In other words, at any point in time, they could throw Lavantil Desperados out. And yet still, they come proclaimed they spent $13 million on the, what is it? $14 million on Desperado's Pan Theater. So I say, what? Finally, what? The greatest pan site in the world get a Pan Theater. This had to be right. When I look and investigate the thing, it don't even belong to Lavantil Desperados. So it's Mama Guy, after Mama Guy, after Mama Guy. I want the minister to address why that is. And if they cannot, as our government, create the conditions and the security for Lavantil Desperados to go back on the hill, because if it's one thing that could quiet down that community, it's Lavantil Desperados. That is a fact. If it's one thing that leadership provides, is a certain culture. And I think we heard that before. And once the hill doesn't have that leadership, once the east-west corridor doesn't have that leadership that comes with pan side, what pan really means to those communities, we'll have a floundering government, out of touch, disconnected, at sea, to deal with crime, to deal with our socio-economic problems. They're at sea. So they could come with all the trivial proclamations that they did here about PAN. I am saying the only people that can correct PAN is the UNC and the Kamala Patasar. And we will not use the Panyard only for having political meetings. We will make sure that it is used to uplift the communities up and along the east-west corridor and return our beloved country to a state of normality and sanity. I thank you, Mr. President.
Senator Maharaj. Senator, who it is? Senator Patasar.
Thank you, Mr. President, for giving me the opportunity to add my voice to this debate. So I'm not coming to this with a kind of experience that some of the older people would have here. But what I come with is an alternative relationship with PAN. From my work in music, from a family that has typically dealt with PAN in a different forum. So when I think of PAN, what tends to happen is that I trail off into my imagination to think of how and what would have been going on in the minds of the people who developed that instrument. Because to me, it's almost mind-blowing to think that you see this oil drum and you thought that you could make this into something musical. This to me is almost this stuff of fiction. So there's no disputing to my mind that steel pan is a central sound in this landscape. It's the sound of home when you go away and you hear a pan walking, from my experience walking in London, in Westminster, and I heard the sound of the pan and I walked towards it. It felt like home. What the pan represents to me is a power of the diasporic imagination, because this space it's an in-between space when we think about the creation history of the space. It's a diaspora, and the diaspora by its very nature has a very fertile position. It's basically a blank canvas that you could do anything with. And that to me is what pan represents to me as a musician, to me as a creative, to me as a citizen. is a place that allows for recasting, for reframing, and that is what the steel pan symbolizes. It's a strong symbolic representation of the creative possibilities that exist here. And we are seeing that being developed in the technological innovations that are taking place. The G-Pan comes to mind. So to designate the steel pan a national instrument theoretically makes sense. To enshrine it in law makes sense. Because if this is a nation-building exercise, then we do need shared symbols that unite us. But there is a stumble. And I know that this may represent, in a sense, an unpopular position, but in my role as an independent senator, I think it needs to be said. When you make something a national instrument, you pit it against the concept of nation. So that begs the question then, what constitutes a nation? How do you define the nation? And is this concept of nation shared by a majority? That's a question that I would ask. And I'll give you my personal experience as a musician because I think it's relevant here. Some years, and it's still ongoing, whenever I was asked to perform, I was always asked to perform when it's in a national capacity with a pan. So my way of dealing with it was step away. So I stepped away for many years because I had gotten to the point where I was fed up of being asked to do that. The issue for me wasn't that it was the pan, but the issue for me is the way that we frame what constitutes national. To me as a musician, because I'm a musician playing a sitar, it has to do more with the music than with the instrument. So to me, my Trinidadianness had to do with the music that I was creating with this, not necessarily the instrumentation. And I decided that I was not going to be, in a sense, bullied into that, and I stepped away for almost a decade. Now I've come back to it, but I've come back to it with a different eye, because I think the country is now at that stage where we are now moving into that understanding of national more and more. Okay? So the question, so I quoted the experience in London, I quoted the local experience. And to me, what this highlights is that when I'm outside, it's easy enough to claim home, but when I'm home, where is home? When you think about the nation this way. So coming out of this bill, I have a few questions that represent some of the other voices in the nation. The question is, who do we alienate when we create such designations in a multicultural society like this? And how does it aid in nation building that should be inclusive? And the cultural policy states this. The cultural policy says that the concept, and I'm quoting from it, takes on an even greater significance in post-colonial societies, such as Trinidad and Tobago, that are still dealing with the multiple traumas of enslavement, indentureship, and dependency in the economic world order. It is evidenced by the lack of assurance some citizens exhibit in celebrating their ways of life and by privileging all the other cultures ahead of their own. So the designation of the steel pan as national instrument is not as simple as it looks. It carries the weight of history, it carries the weight of politics, and I was having this conversation with Senator Dr. Brown when he asked, we were speaking about my voice, which I lost 18 years ago. And he was saying, music is such a nice space, but it isn't what you see on stage. There's a lot of politics involved in the background. So as a musician, I'm speaking from that perspective. And here I make reference to Senator Maharaj's motion that called for a joint select committee to be established to determine the best mechanism for giving meaningful effect to this declaration. I felt that that might have been the way to go, because what it would have invited was multiple voices to share in this exercise. So however we look at it, the country's history is complex. The task of nation building is by no means an easy one. And it requires that we deeply recognize that this space is multi-layered, very much complex. So the bill is a great one, right? But it leaves me with the questions, and these are the questions that I will leave you with. What is the bill supposed to achieve? What is the purpose behind making it law? Is it necessary for us to be able to do innovations on it? Have the pans been patented? What is the urgency of it at this time? And moving on to the symbolic, how does the law speak to addressing the challenges for nation building? So that's it. Thank you.
Senator Hislop.
Thank you, Mr. President, for allowing me the privilege to just jump in very briefly on this bill, this debate. This evening, or within the last 2 days, has been a historic occasion for our country, for Trinidad and Tobago. Has been a historic occasion from the standpoint that we are celebrating what is ours. And we're not here this evening to debate who is more a lover of pan and who isn't. We're here to celebrate pan. And whether we were born into pan or whether we became pan lovers in our adulthood, whatever it is, pan is ours. It is an instrument that even if you want to stand up, when it starts to play, you can't stand up. It creates a rhythm. Well, it was created out of us. It was created out of our rhythm. And because it was created out of our rhythm, we can't help but move when pan begins to play. Whether you were born into a Despas patent or into our boys or them boys or whichever patent you were born into, or whether you became a fan of a pan side or of pan, there's just something about it that moves you. There is a spirit that comes out of it that moves you. And that's why we're here to celebrate pan. I just want to touch briefly, because we are in a debate. Even though we're in a celebratory mood, we're in a debate. $20 million average spent on a pan tent for one of the premier pan sites in the country, Desperados. Just over 20 million, I believe, is the estimate. Whatever millions were spent by the government of Trinidad and Tobago for a historical and renowned pan site, for them to have something, for them to even take them the organization to another level. And we should be celebrating that. Those are the kinds of things we should be celebrating. But also, Mr. President, we had a situation, or Senator Nakhid just heaped praises on his political leader and speaks about when the UNC comes back into power, that the UNC will take care of PAN. But I want to read something from an article written by then David Nakhid. He wasn't senator then, I don't think. Friday, 29th November 2013.
What year?
2013. He was a guest columnist. Oh, yes, guest columnist. And he said, recent history makes it clear that the People's Partnership cannot lead people out of a paper bag, let alone a country out of the morass in which it is. Not my words. But now the same gentleman has put on a cloak of righteousness and has spoken very highly of the opposition leader. And it makes me stand in my size 12 shoes and wonder. Mr. President, from the back alleys and the dusty yards of Lavantil, Senator Nakhid, to the big yard and to the international stages, PAN is now being elevated from a legal standpoint. And when I say from a legal standpoint, Mr. President, PAN did not require a piece of legislation to elevate it. It was elevated by the people of Trinidad and Tobago. What this government is seeking to do, Mr. President, is recognize and give legal status to an instrument we've all come to love. Not just an instrument, Mr. President, but a way of life. It is a way of life. And, you know, I remember the days because I grew up good Seventh-day Adventist young man. Grew up a good Seventh-day Adventist young man. And I remember the days when PAN was not even allowed in church. Because PAN was considered the bad boy instrument. Out of the alleys and out of the... Yes, it's only Bajan used to play PAN. That is how PAN was seen. And you know, to tell you where PAN has come to, Mr. President, I remember a gentleman at a church that I used to attend said, if it is one instrument that should be allowed into heaven, it's the steel pan. And that is because there is nothing sweeter than hearing people like, and I'm taking this from a Tobago standpoint because right now Tobago ruling the roost with pan. We taking claim of that where medium band is concerned. We're taking claim. And we also taking claim, Mr. President, where some of the best arrangers in the country are right now. We're taking claim of that. So I want to, there's nothing sweeter than hearing a Duvon Stewart play a pan and Kirsch Ramsey. And I must say that my own relative, O.J. Richards, who is one of the renowned young arrangers coming into the fore. And these gentlemen have made a name for themselves. You talk about the level of musicianship that comes out of Cats and Jammers, of Black Rock, Mr. President. And this is about a national instrument. So this is not just Lavantil's instrument. This is not just San Fernando's instrument or Diego Martin's instrument. This is Tobago's instrument as well. This is Trinidad and Tobago's instrument. This is ours. And so when you speak to people like the late Patrick Arnold and Mr. Roger Sardina, and I want to speak to one of the best tuners that I know, the late Iron Anthony, better known as Deuce, who was the manager of Steel Explosion out of Canby. And these are men who, well, originally, yes, Senator Dillon Remy will correct me that he's directly out of Buko because, yes, he was, I think, co-captain of Buccaneers, and then he created his own Panside Steel Explosion. And these are men who, if they were alive today, Mr. President, would be applauding where we are. Yes, things are not perfect, Mr. President, and we all learn as we go along. But Mr. President, when we can stand as a government and declare and give prominence to an instrument that we have all grown to love, whether we were born in it or whether we were grafted into it, and I want to use a little biblical reference. Whether you were born a Jew or grafted in as a Jew, Jesus Christ considered you his brother. And so whether you were born in Japan or grafted in Japan, we are all pan lovers because we are Trinidad and Tobago, Mr. President. And so I want to congratulate not only the Prime Minister for his love of pan, because he's a pan lover as well, and for giving the strength and the backing and the foundation to the Minister of Tourism, Culture and the Arts so that he could put this in its rightful place so that we can have a debate to elevate our national instrument to its legally rightful place, Mr. President. I think we ought not to be patting ourselves on the back because this is what we are supposed to do. This is what we're supposed to do. But we stand on the backs of all those, the creators of the instrument, those who had the vision, those who had the rhythm within their soul, and the legacy that has continued from the fights between pansides to where pansides can now exchange players. Because that's what the instrument has done over the years. Moving it from gangsterism, Mr. President, to places of note, to churches, to halls, to playing in concerts with philharmonic orchestras, from calypso, from ping pong to classical music. The pan has, I believe, one of the widest ranges where a musical instrument is concerned in terms of what the genre of music that it can play. From calypso, soca, reggae, gospel, classical. I think one of the best versions of thank you, Senator Dillon Remy. Classical music from Beethoven and yes, Hallelujah chorus. I have heard played on a steel pan. Mozart played on a steel pan. Played on the national instrument of Trinidad and Tobago. And it is no sweeter song to hear. I think it was at the last Olympics when our national anthem was played for Dream Richards, played on steel pan. And Mr. President, there's nothing more I could say, but I'm ready to vote in favor of doing what we are supposed to do to elevate our instrument. Mr. President, I thank you.
Senator Francis.
Thank you, Mr. President, for allowing me to participate in this bill. I know by now everyone is a bit exhausted. Yeah, me myself. Honorable members of the Senate, the National Musical Instrument Bill 2024 is a move that gives formal recognition to the steel pan in both this House and the lower house. A gesture that is for sure long overdue. It represents a significant step in recognizing and promoting a crucial aspect of our national heritage. By officially declaring the steel pan as our national musical instrument and instituting regular oversight on its status and promotion, we not only honor our cultural roots, but also pave the way for its continued relevance and growth, both nationally and internationally. As part of this bill, the Ministry of Tourism, Culture and the Arts is being committed to monitoring and reporting on the steel pan's impact and development. We can only hope that through that process and the data captured, it will also cause to create a strategic plan that will ultimately yield tangible commercial benefits to those that dedicate and many times sacrifice their lives and livelihoods to promote this now de jure national instrument. You know, I listened to the Honorable Minister of Tourism and Culture and the Arts, Randall Mitchell, with whom I have had a good relationship with. In his remarks, he referred to moving the recognition of the steel pan as the national instrument from de facto to de jure. And in doing so, allowing to its ascension in status from practical recognition or its real status in society to this honorable legal recognition that we are debating in the Senate today. While overdue in many ways, it feels like finally having a wedding ceremony to marrying your common law wife of over 50 years. De jure. In that vein, I would like to know what would be the tangible benefits of this de jure status, and to whom do these benefits accumulate? There are roughly 200 steel orchestras that compete during the carnival season, yet less than 10% of them are sponsored. Will this bill create steps to fixing these things? In the de facto world that we had before this, Ash Wednesday come and the panyard empty. Nobody asks where the pan man disappears to. As far as the general public knows, all of them vanish into thin air till next carnival. Like Santa Claus and the elves after Boxing Day. Nobody checks in on them. Nobody wondering how they're making out. When and where will they be performing next? How they send their children to school. And the same for Calypsonians. Today, we are in July. Where are the arrangers that we pile praises on in February? Where is the bass woman who stands on top of the pan frame playing at lightning speed? Where is she today? In this very moment. What are the tangible benefits to those who have given us something to love in the steel pan? Like a faithful common law spouse. Of course, as a Calypsonian myself, don't get me wrong, I acknowledge, like this provides a certain level of recognition and visibility that ignites promise and opportunity, that glows like a bright light in otherwise dark cultural circumstances. But often, that light proves to last as long as the flame of a matchstick. In that vein, behind the door that this recognition opens, I would like to see steps towards creating tangible benefits to the practitioners and promoters of our national instrument. I would like to see the data captured in this monitoring and reporting to be undertaken by the ministry and turned into a strategic plan to develop the industry in a commercial and sustainable way. And not just with government handouts and incentivizing corporate involvement. These are musical artists who should be envisioning their livelihood in the context of pan and in the music industry. They should not be thought of as disposable gladiators who people pay to see battle in a coliseum once a year. We need a plan to move us away from the view of this industry. So my question would be, how would this bill take us in that direction and provide tangible benefits to those that continue to lift our national instrument up, and to the world, making it fitting of this recognition? In closing, I would like to say that as we consider this bill, let us reflect on the profound cultural and historical importance of the steel pan. Let us also ensure that our acknowledgement is genuine, meaningful and tangible in its intention. To do that, let us allocate the necessary resources and strategic planning to support its promotion and development effectively. In doing so, we can celebrate and preserve a unique symbol of our nation's innovation, spiritual, and cultural identity. With that, I say thank you. I hope you understand.
Senator Mark.
Mr. President, I'm very happy to join this debate on this bill to provide for the designation of the steel pan as the national musical instrument of the Republic of Trinidad and Tobago. Mr. President, it is better late than never, because before self-government in the 50s, pan was the national instrument, musical instrument. When we gained independence in '62, pan was the national musical instrument. When we gained republicanism status in '76, pan was our national musical instrument. We were told by the Honorable Minister of Culture that even though previous prime ministers, including Patrick Manning, I think he mentioned the former Prime Minister, may soul rest in peace, he declared pan, the steel pan, as the national musical instrument. But Mr. President, even though all of these things were done over all of these decades, we were never able to put this declaration into legislation. So it has taken us decades upon decades. And in 2024, we are now taking that leap, that step that we ought to have taken so many decades ago. I really want to record my congratulations, my appreciation to the Honorable Senator David Nakhid for his brilliant exposition, a testimony of the grassroots, right? On this bench, living testimony of the living testimony of the national musical instrument. So I want to congratulate my colleague. Mr. President, I also want to take this opportunity to associate myself with the Culture Minister. Henry Harper, for over 2 decades, Mr. President, has been like a pioneer in this country, seeking to get the steel pan declared as our national musical instrument. He has written to prime ministers, to presidents, Mr. President, to all sorts of prominent individuals in the nation who can take and make decisions. And I think, based on the recognition this evening, coming from firstly the Minister of Culture, I want to associate with the great appreciation of our nation to Mr. Brother Henry Harper, who has played his part. He's alive and well as we speak. He was here just last Friday. He was recognized in the public gallery in the other place. He's not here this evening because he probably didn't know that we were going to deal with the pan this evening, this particular matter. So, Mr. President, I thought I should put on record and join the Honorable Minister in recognizing this national icon who has made his contribution and who is happy to have seen his work being materialized in the form of this legislation that is before us today, because he has been advocating, Mr. President, for over 2 decades for us to put into legislation, put into law, the recognition and the declaration of our steel pan as the national musical instrument of our nation. And I think he deserves our honor and recognition. Mr. President, I also would like to ask the Honorable Minister to look at this initiative, not in isolation, but to look at it from the perspective of how we can give what I call genuine, meaningful recognition to this national musical instrument. And you know how that could be done, Honorable President? Through you to the Honorable Minister? By ensuring that national content on our radio broadcasting networks, particularly as it relates to the steel pan. The steel pan music, Mr. President, is given the kind of recognition in many countries. In Trinidad and Tobago, for example, we don't have a policy. We started it under the PP government. We reached a long way. We had consultations and discussions, symposia, and we were about to bring legislation to Parliament to deal with this issue of local content. My colleague, Senator Vieira, will tell you, Mr. President, that if you go to Nigeria, 80%, boy, local content, you know. 80%. In Canada, it's 35%. In a place called Zimbabwe, whatever they say about Mugabe, he's a national hero. You understand? Mugabe, you know, Mr. President, 75% local content in Zimbabwe, but in France, 40%. So why can't we, as a recognition, because remember, the steel pan is one element, one aspect of that whole milieu that we are talking about, but it's the most critical aspect. And I dare say, Mr. President, that it is something that the government should really pay close attention to and bring legislation. The groundwork has been done already. The symposia were held. Discussions were had. We just only have to take the material off the shelf, dust it, and legislate for it. You have over 36 stations, radio stations in this country. And it's only, you could count on two fingers, one hand, if so many, the level of local content that you could talk about meaningfully. I know 95.5, I ain't advertising for them, but I know that on that station, they just bring a fella called Brother Diaz, who was the former president of Trinbago, and they have a program on a Sunday evening or a Saturday evening, and they will just deal with pan a whole hour, and he does a history on that. But we don't get that on other stations because there's no policy in TNT compelling these stations to allocate a certain percentage of their broadcasting time towards local content. But in France and other countries, they have now legalized that, Mr. President. They have mandated that. So I'm just saying to the Honorable Minister that that is an area, if we want to give flesh, put flesh to the meat, or flesh to the bone rather, right, of what we are talking about today, I'm saying that is an area that we need to pay attention to, Mr. President. And Mr. President, I just want to indicate, and I just want to tell the government, if you fail to do it, we will. We were very close to completing it. And then you came and you're 9 years on your last dying days. And now, the last period, let's see if the government will take up this particular challenge and really genuinely show their interest in this instrument called the national musical instrument, the steel pan. Mr. President, I am not going to take long. I just wanted to join my colleague. But before I close, again, Mr. President, through you to the Honorable Minister, the creative industries, the creative economy in the world today, Senator Vieira will tell you, as at the end of 2010, 2015, I think those are the latest data statistics I have. Mr. President, the value of the creative industry is over $2.2 trillion. And it's the point that you were making, Honorable David Nakhid. Mr. President, if we use our culture and if we use pan as an example, that's what we are dealing with today, you know how much income, how much revenue, how much employment, how much opportunities we can generate, particularly for our young people. Our young people in Trinidad and Tobago can be engaged in a productive, meaningful manner in this industry if we really focus on it in a proper way, Mr. President. So I couldn't allow this moment to pass without standing and identifying. Like David, I didn't have his experience, but I could tell you I came from the community. My mom came from Desperately Crescent, the Laventille. So I too have my roots and so on in Laventille. I spent many years, of my life growing up by my grandmother and my grandfather, who was a shoemaker right at the bottom of Piccadilly Street. He lived to be 100 years. I hope I can follow in his footsteps, right? So, Mr. President, all I'm saying is that I wanted to really associate myself with this important piece of legislation, an initiative taken. I think that we can put our heads together to strengthen what we have before us and to make all our countrymen proud of this very important instrument that the ordinary grassroots people, through the fires of struggle, resistance to oppression by the colonizers and the slave masters, they were able to create in that almost sea of oppression and exploitation this very important instrument. The only musical, I just boast that wherever I go, wherever I travel, I can tell you, Mr. President, I boast wherever I travel. I will tell my colleagues, whoever I meet, whatever conference, I say I come from Trinidad and Tobago, one of the most beautiful countries in the world. But you know what? What is even more important, we are the only country in the world that was able in the 20th century to produce the only musical instrument known to mankind, the steel pan. That was the only musical instrument known to mankind that was created in the 20th century. And where did it come from? It came from the small, tiny republic of Trinidad and Tobago. We did it. The ordinary people did it. The working man and woman did it. And we must be justly proud of our commitment and our contribution and our dedication to this nation as it relates to this very important national musical instrument. So, Mr. President, I want to thank you for giving me the opportunity to join with my colleagues in supporting this very important measure before us. Thank you very much.
Senator Maharaj.
Thank you, Mr. President. I would like to thank the government for bringing this bill and formally declaring, that will formally declare the steel pan as a national instrument. That we will, I have a motion to that effect that's on the, well, I guess it will have to come again, but I will still proceed, and I hope by what I say today to convince you that there is more to be done beyond the declaration. We need this. We needed to declare. We all accept pan as our national instrument. We say it. A lot of people have been surprised to hear that Parliament is going to, they thought it was a national instrument all along. But like those relationships that are real and enduring but need a little paper to validate its existence, we needed that for pan, so that we can go into the world and proclaim. In the way that some people say, the answer to every question is love. I would like to say the answer to every problem that we have is pan. And I will argue that case as quickly as I can. And I want you to just cast your mind back to the 1930s. I wasn't here, but we know the history. We know that was a period of intense labor angst from the dock workers' strike in 1919 that was never resolved. In the 1930s, workers were unhappy and marching, and the place was roiling. And at the same time, the world outside there was gearing up for war, a world war, Second World War. And in Trinidad, amidst all of that, all over the hills, Morva, Laventille, Belmont, and then it spread to Woodbrook, and it was in Point Fort, and it was all over. Teenagers, not big men, teenagers, had picked up this metal, and they're starting to pound. And as they did, a kind of competition took hold. Who got something else? And that was such a wildfire. To this day, nobody can say who invented pan, because it was not invented by one person. It was invented by communities. And nobody knew which race or what. It's who iron better when you're in pan. And this is the other significant point about steel pan and the steel band. It is the one place in this country that has so much contact system and corruption where a meritocracy reigns. You only get to the top in pan because you're iron better than you're better than somebody else. It has a genuine meritocracy. It has genuine moral and competent leadership. You do not get to be the captain or the manager unless you enjoy the respect of your members of your band. And if they don't agree, you're not going to be that person. And when they agree, they just come in. You don't even have to be there. These are the instructions. This is what we're playing. This is what you all do. The captain will deputize somebody, and because you know why? You respect that person, and you're prepared to take the instruction from that person. It is also the place that is safe. You can send, as we like to say in Trinidad, your girl children. And from all the elders who graduated to the point of just sitting down and watching, as Scrunter would say, that they're working here tonight when people want to come try something on the girls. If somebody gets shot, it's by accident, it's a stray bullet, has happened to this girl in Arima. It is a safe space. It is a loving place. It is a place where truth is always on the table. It is a meritocracy, and most of all is a place of education. Let us remember, as we grapple with the inability to transform our education system from whatever the British left here with their exams, as I always say, who sets the exams determines, the rules. That is a place where the dropouts and those who didn't even go to school went and they worked the science to a fine art of heightened excellence. And if we understand what happened there, we will find out how to transform this education system. Instead, we talk about Finland, and I will come back to show why this precedes this Finnish education system. But I want you to see, in that explosion of invention and innovation that gripped Trinidad, that was our Silicon Valley moment. We talk about California and Silicon Valley. The difference between what we did in the 30s and 40s and 50s and so on, and what happened in California was when a whole community of dropouts, those guys like Bill Gates, and they drop out from university, they go in their parents' garage and they do their software and so on. When our youths did that, they didn't get investors running to them and say, I want to put some money in that. I want, I'm going to give you some, I want to share whatever. No, that's what happened in another country. What happened to them is they got ostracized, they got beaten, they got locked up and criminalized. That's what we did to our natural indigenous scientists, young people, a whole generation that went on for years, and they still have not. For all the lauding that we do and we enjoy the pan at carnival time, if we genuinely understood their value, we would not have the problems we had today, because there would be an investment in them more than a panorama competition. Because what they have there, this is the possibility for transforming our education system into one of experiential learning, into one learning that is joyful, and we would understand the need for an economy that locates that talent and that potential beyond the business of just playing pan. And I want to talk very quickly, because this is just going to be like my motion talks about how do we give meaning to the concept of a national instrument. Otherwise, we'll just go about saying pan is our national instrument, but how do you give it meaning? It has to be anchored in an economy. The descendants of these people, these young people who invested and took the licks and the jail and everything and the ostracism, they have to be the people who will benefit. And they not benefit by getting their grandfather's back pay. They benefit by us recognizing the value, and to the extent that this is something we can say, okay, well, let's work with what we have. And I want to put this in the context of the East Port of Spain Development Company and all the East Port of Spain initiatives. Because East Port of Spain is such a rich part of the country. I cannot understand how we don't see it and turn it into that. So my brother here wants Despas. I ain't getting in no fight over Despas, because I know I'm going to win that. Look at that real estate. Despas towards by Independence Square, you walk down the road, you get to All Stars, you have Blue Diamonds on the way, you have the craft market, you go along a little further, you buy Renegades. Where in the world can you get the 3 of the best steel bands within walking distance, and you don't see that is a heritage district, but you could go to New Orleans and see a heritage district, and you could spend your money, but you cannot see that is there. Not only is that there, there's where the Cambole riot, right there, where Carnival was born, that is right there. There's the first recording company, right there. There's Railway Douglas, the first Calypso tent, right there on Duncan Street. In that small space, we have all the requirements for a walking area that could be linked. You just have to, where All Stars is, you just build a bridge across to Piccadilly. And then you start to bring in East Port, Laventille, and you take those young people there, and you train them, and you give them the history, and they will be the ones guiding the tourists. Let them walk off the cruise ship and walk down Independence Square, and they enter a city. Not a carnival city as the kind that was planned for Movie Town, where our people will just have to put on their costume and go and get a minimum wage to play a mass, but something that generations can go. That area should be a walking area. How will the crime take hold? When you light that place up in the night and you tell people bring out every day, you bring your food, and you open up the craft market, make all the miniatures, this is what you should be funding. Not make work, real thing where people could put, and that will drive the crime and push the crime, because a lot of those people, a lot of them will get jobs. And not only that, you create an economic model that is a cooperative, because traditional mass characters, steel bands, all of these people must be owners, not workers. They must own it. They don't need a government to own it. They need a government to invest, and they must own it. And all the trainings that organizations like NTA and NEDCO and all these things, that kind of training will mean something to them. And when people are educated for things that they want, they understand it and they learn it. When they have to learn it by rote to say, well, I'm going to pass an exam, they don't really understand. They don't really want it. They will come for the paper. So we have a way forward to move PAN and move not just PAN, but all the entire creative sector. I completely understand Senator Patasar's hesitation because she has to work through. Now, she's not the only person. What PAN gives us is a chance to escape the idea that PAN is only about one part of the community. The reason that we feel when we hear the sound of PAN, we hear the sound of home, is because our heart knows it, but our political brain doesn't want us to accept it. So we are not giving ourselves the permission to love it. But you know what? We are also not giving ourselves the permission to love everything that we have created here. Tassa may not have been born here, but the Tassa rhythms, you hear the calypso rhythm and the Tassa, we created that. In the same way, we bring certain things from India, we bring certain things from Africa, but we have totally reinvented them, and they're Trinidadian, or they're Caribbean, or whatever it is. And we have to acknowledge the competition between us that is fostered as arithmetic for votes it is blocking us from embracing everything that is justifiably ours. I've heard people talk about PAN as PAN is an African instrument. PAN is a Trinidadian instrument. It is Trinidadian. What is more Trinidadian than PAN? So it is not, C.L.R. James said, what do they know of cricket who only cricket know? What do they know? What do they know of PAN who only PAN knows? Because it is a metaphor. PAN is a metaphor for all the things that are bright and beautiful about us. And so, I know it's a late time in the night, but I want us to see how much of our cultural, and not cultural wealth, this is our real wealth. This is modern culture, this is all the things. We did not invent the technology for oil and gas, but we have it. And I know that we have people who went in there and learned things. They're just bright and they're curious and they taught the expatriates things about this sector here. But there are things that nobody taught. We just had to, we heard our heart and we followed it and we invented things. And once we are talking about that, the core element here in PAN is that PAN is an economy that is a permanent and growth economy. PAN is not only about plain PAN. If we were to see the transformation, if we were to tackle education transformation, the creative sector is the natural partner for the pedagogical sector. I have proposed elsewhere that we transform all the written material in the books into audiovisual materials that will allow creative people, writers, musicians, photographers, videographers, and so on, bring them together with the pedagogical professionals to create curriculum that is alive and vibrant, and we will learn that. We want to see our history. We want animation. We want to see, we don't want to read it in a book. Who wants to read history in a book? Create transform history into visual materials that children, we're not bored children. And they must stand the rigor so that they can be accurate and it's not propaganda and so on. That's full-time work. You can never finish that work because that kind of work, geography, history, all of these things, you take that out of the book and you create audiovisual material, and all of this creative sector will stop being the gig sector where you're looking for hustle but it starts with the courage to tackle the challenge of change. And so I will just wrap up here and say that by saying that if we open up the space, if we have accepted PAN, but what it is bringing into the center of our space something that has been marginalized, but it is not the only thing that has been marginalized. I think what Senator Patasar was referring to is that sense of She is Trinidadian, my music is Trinidadian. Why do I feel that I'm an appendage? Because all of this belongs in the center. All that we are, and people should not have to argue the case for that. But making pan and just saying to the world that this is something, maybe it lifts our pride in ourselves, so we can have the confidence to really see what we are and what we have and what we have created, and think we can do it for everything else that we know we have. We have so much. We have what I consider the grandmother or the mother of Caribbean civilization in Banwari woman. And I cannot understand why we don't recognize what we have. That is how she is the mother of civilization. Yes, I am biologically Indian, but I'm culturally Caribbean. I'm from here. And indigenous, that I'm claiming that. That's my mother. And I want us to see those are the things that the tourists will come for too, but we are not creating an economy for tourists. We are Trinidadians create things for themselves, and you can come in and enjoy it. You could pay us too in the process. We have so much. We have so much. And it is a proud day because I feel, the people who wanted PAN declared, and you have done it, and this parliament is doing it. They can walk into the world. They don't have to feel like some outside. I don't think they feel so. I think they're so proud. They just didn't know everybody's as proud as they feel about the PAN. And I'm really happy that this has come to pass. But I want us to open up and just be at ease with the idea of bringing everybody into the conversation. That was the whole idea of the motion I had filed, which is I wanted this as a symbol, really, of something we could all rally behind and around, and then start doing that for everything else, and not be afraid, not wonder about who has a place in the society and who doesn't have a place. And the smaller your numbers are, the more you doubt. Everybody should be given a place. We should know everybody. I'm not into all this. I understand how the society is structured economically, but I do feel that there's so many people feel they want to belong, and actually PAN gives them something that makes them feel, but always want. Carnival it opens. This is why it's such an anomaly to be talking about all-inclusive when the intention is to exclude, right? The rope is that. But Carnival just opens its space and say, come in. Right? It just does that, and everybody finds a little space there. So I want to thank you for giving me the opportunity to say a few words, and to thank the government for taking this initiative, to thank the Parliament for supporting it.
Senator Vieira.
Thank you, Mr. President. It's late, we're tired, but I could not let this bill on the order paper pass without saying something. I will try not to be long. Designating the steel pan as our national instrument. Why? What's the added value? Well, first, it helps promote and preserve our cultural heritage and identity as a nation. The steel pan, forged by grassroots musicians, using nothing but natural talent on discarded oil drums, has given generations of Trinbagonians great joy, confidence, and a sense of self-identity. It has become a symbol of national pride, reflecting our history, traditions, and artistic achievements. Today, people all over the world enjoy the steel pan. The instrument, as we have heard, is used in Japan, China, the Baltic countries, Europe, the UK, and throughout the Caribbean. Our steel pan festivals, in particular Panorama, and when we used to have the Pan Music Festival and the Pan Jazz Festival, They attract visitors from all over the world, and they enhance our country's cultural profile. Steel pan players have evolved from the bajon that used to have the two sticks sticking out of their back pocket to young players throughout all our schools. Highlighting the steel pan as our national instrument encourages music in education. Schools and cultural institutions can now include the steel pan with pride in their curricula, increasing awareness and appreciation among younger generations. Recognizing pan as our national musical instrument will stimulate and deepen interest in learning and mastering this remarkable instrument. And this can foster the development of new compositions, techniques, new types of pan and performances, enriching the nation's artistic landscape. Making pan our national instrument can boost production and sale of pan as well as related merchandise. And this can create jobs and promote the craftsmanship associated with the instrument. I know that within the intellectual property offices even talk of trying to get a geographical indication for the steel pan. The Japanese have an interesting concept. It's called living treasures. And what they do is that they identify craftsmen and artisans, whether you're a sword maker, you're into ikebana and flower arranging, whatever it is. But they single out the people who are the maestros in their particular fields. And then they honor them with the designation living treasure. And besides giving gravitas to that person and recognizing their achievements, they pay them a pension, and they pay them to teach and hand down the craft to younger generations through apprenticeship programs and that sort of thing. That is something that we should be doing. We should have been doing a long time ago. I mean, we've had such great musicians, whether it's Jit Samaru, Bugsy Sharp, Robbie Greenwich. You know, these guys all need to be honored, not just with a medal, but where you can actually showcase them with pride, and they could be an attraction for people to come and visit and see, and they can enhance the profile of communities. Because, you know, some of our most dismal communities have produced these magnificent diamonds, these jewels. We really need to highlight it. So, the steel pan can serve as a unifying symbol. The steel pan in this country transcends race, class, religion, and politics. Brings together diverse communities within this beautiful country of ours. It promotes a sense of shared identity and common cultural heritage. In this country, we support pan sides, as Senator Nakhid has so aptly demonstrated, with the same passion that footballers and basketball fans support their teams. I agree with Senator Nakhid about Despas being the best pan side. But there are others who feel equally sure about Invaders, All Stars, Renegades, Phase 2, and Exodus. The point is, in this country, pan has the ability to evoke a wide range of emotions, from unbridled joy at panorama time, or chipping with a pan side during carnival, to calmness and even ecstasy when you go to one of these pan music festivals. This emotional resonance uplifts the spirit. It provides comfort to many during difficult times, and it boosts our mood. I believe Dr. Jonas James did some sort of study in which he talked about the benefits of Pan as a healing mechanism within communities that are downtrodden and beaten. You know, how it pulls together young men and women who might have been aimless or who may not feel good about themselves. It has enormous therapeutic potential, and I think it's something we should be investigating. Pan fosters a sense of community and belonging. Pan sides and Pan concerts create shared experiences and they strengthen social bonds. Overall, whether it's a symbol of identity, a common symbol around which Trinbagonians can rally, whether we use the Pan in our diplomatic missions, at international organizations, and other forums to represent our nation officially, whether we use the Pan in promoting tourism and enhancing this country's brand image, the steel pan has had a multifaceted impact on our population, making it a powerful tool for inspiration and motivation in various aspects of life. National emblems are a declaration of a country's sovereignty and independence. They are a reminder of who we are as a people, our autonomy, and our determination. Designating the steel pan as our national instrument is a deserving accolade. It is long overdue, and I feel honored and privileged to be a part of this legislation. I thank you.
Minister of Tourism, Culture and the Arts.
Thank you very much. Thank you very much, Mr. President. Mr. President, allow me, as I begin my wind-up, to thank all honorable members who have joined in this debate, who have contributed in this debate on this very momentous and historic occasion. Mr. President, first I would like to thank my colleague on this bench, Senator Hislop, and for speaking in support of the bill. We all support the bill, but in bringing the debate back to the level of dignity that this debate and this piece of legislation deserves. On the Senate bench, I'd like to thank Senator Francis for his valuable contribution. I'd like to thank Senator Patasar. And if I could just answer, both of your concerns together. And Senator Maharaj helped me in answering the claim. What is the problem that this bill comes to solve? And in Clause 3, very simply, it is that persons in the steel pan movement, proud lovers of steel pan in Trinidad and Tobago and in the diaspora, felt that the steel pan should be proclaimed through a legislative process to declare it the national instrument of Trinidad and Tobago. That's the problem. Members of the community, and it was a very loud call, even by, and just by, in passing, I'd mentioned, by Her Excellency. The steel pan should be declared as a national instrument of Trinidad and Tobago. But the fourth clause is very instructive. So what we have done here in this fourth clause, by giving the minister with responsibility for culture to prepare and lay in Parliament every 2 years a report on the recognition, status, promotion, development, and impact of steel pan at national, regional, international levels. What we have done here is we have placed a positive obligation on the Minister of Culture, the ministry with responsibility for culture, to scan the entire environment, whether it is work by Pan Trinbago, the work of all the individual steel bands, the work of the manufacturers, the pan tuners, the work of the IP office, everybody, and put it in a report and lay it in the Parliament so that the people's representatives who are members of Parliament, on behalf of the people who they represent, can now examine everything within that report. So we have created a level of accountability across the board, and we have also placed a responsibility on everybody who is involved in the steel pan movement to report on the advancement of the steel pan. That is what is very instructive here. So, whether it is the executive of Pan Trinbago, they'll be held accountable by a report. Whether it is the Ministry of with responsibility for culture, they will be held responsible. The Minister of Culture, the party in office at the time, everybody will be held accountable. And it can be examined by a joint select committee of the Parliament or the media or anybody else to hold persons accountable. Senator Maharaj, I thank Senator Maharaj for her contribution and for her perspectives that she has shared. Of course, we look forward to you bringing back the motion for some more extensive discussions on the matter. This is a matter that we should continue to discuss. What do we do with this magical and beloved instrument we call the steel pan? So we look forward to that. As I go to the opposition benches, Mr. President, I'll tell you that I am not surprised by the contribution from Senator Waidmark. Notwithstanding all the jousts that we have and the back and forth and the banter and so on, Senator Waidmark is an experienced parliamentarian. And with that experience comes an appreciation for the moment, some level of dignity, and he felt impelled, and we accept and we appreciate that, to place on record his appreciation and his support for this bill brought by this government, notwithstanding our, at times, very adversarial encounters. And we appreciate that. So I join with him with his contribution, but I depart where he spoke about the, what was it? The local content policy. Yes, there was a draft policy developed by the UNC, and I had sight of it. And they had done, it seemed, a considerable amount of work, but they pursued it no longer. While me personally, we on this side, we would love to see more local content on our airwaves, whether it is television or the radio. The fact of the matter is, and I believe that the United National Congress departed very quickly from that position when they saw how significantly, how seriously it affected persons' constitutional private right to the enjoyment of property. Now, if Senator Mark right now is willing to give that undertaking, that he will give us the requisite 3/5 majority, where we can bring legislation to dictate or put into legislation, rather, a local content policy, well, we'll listen to you and we will work together and we will do that. But you all don't have a good record at all of supporting any government initiative that requires a special majority. None. But if you are willing to speak on behalf of your party, to give support to that type of legislation, well, we will listen to you. And we will definitely support it, because we too feel that it should be put into legislation. Mr. President, then we come to Senator Nakhid. Mr. President, Senator Nakhid says he loves pan. Mr. President, you know, in the other place, when I did this, I became a little rambunctious. A little less, I can't imagine that. A little below the standard that I usually uphold. And you know I uphold very high standards. I became a little rambunctious, and I don't want to become so today. But Senator Nakhid says he loves pan. You know, if it is Senator Nakhid loves pan, I rue the day, for example, if somebody invites Senator Nakhid to a wedding and gives him a microphone and asks him to say a few words. Union bust from the start, you know. If you love pan. Senator Nakhid went about his entire contribution. And you know, his entire contribution was everything about himself. About me. I know pan. I love pan. You don't love pan more than I love pan. You don't care about pan. I love pan. I love desperados. Whoever else you love, well, we don't care about you. And you know, it was so trite and so childish. I mean, we sat here and we listened to him. You know, it's like, you know, Mr. President, it's like when you're in primary school. And you know, two children, I mean, you and your colleague, my daddy car better than yours. No, my daddy car better than yours. I know more about America than you. I know more about pan than you. Mr. President, this is not about knowing more than anybody else about pan. This is not about being inside the desperados, the bowels. This is not about that. Okay, you love desperados more than I love desperados. I respect desperados. I love every steel band in Trinidad and Tobago. Every single one. As a matter of fact, the people of Pan Trinbago would always laugh, because every time I go into a pan yard, I declare, I am a Decimas man, or I am a Renegades man. I always declare it, and I collect my t-shirts. I collect my t-shirts. I love all. The pan I support, a very little, somewhat unknown pan side, steel band in Pleasantville, Calamo Kings, I support them. So while they asked Senator Nakhid for support and he declined them support, Calamo Kings, in their t-shirts, they wear my logo on their backs. A company I own. I would also say to Senator Nakhid, Senator Nakhid, don't feel sorry for me. Never feel sorry for your intellectual superiors. Never. You start bad there. Never. Senator Nakhid also spoke about when the UNC comes back in power. When the UNC comes back in power, we will give you $1,000. We will give you more money when the UNC comes back together in power. And you know, it is always, it's a signal that the UNC always gives. Bring us back in power, we go give you more money. Bring us back in power, we go give you more, Panman more money. But Panman don't make $500, you know. Government offers and gives $500. A Panman makes more than that. Panman makes more than that. And if you don't know that, you don't know pan. But we accept, and we will always strive for pan men to make more and more money. We want that on this side. We want that. But this is not about, you see, that's what they do, you know. Sit up like Massa and say, we'll give you more money, vote for us. We'll give you more money, vote for us. And when they're in power, hey, we're giving you this money. If you don't vote for us, we ain't gonna get nothing. That's what they do. But that's not what we do. It is about empowering the steel pan movement. It is about empowering steel band sides, walking hand in hand with them to ensure that they are in control of themselves and are able to dictate their future. It's to make them independent, not dependent on the state. And that is why today we had to be very firm, and with many of our non-governmental organizations, such as Pan Trinbago, and Pan Trinbago is one of the leaders, they have their audited financial accounts. You know what it is to have audited financial accounts? To show that you are accounting to all of the sponsors, to the government, to everybody who contributes. And what you did today, Senator Nakhid, of course, you didn't take note from, of course, the very experienced Senator Mark. What you did in your presentation is that you denigrated the entire PAN movement. You denigrated it. And that is what we always strive not to do. Create no bacchanal in PAN, because there's not been bacchanal in PAN for the last 5 or 6 years. And you know what that has done? All of the sponsors have come lining up, wanting to become a part, fighting to get involved in PAN again. That is what that has done. That is what that has done. You know, he speaks about, you know, members have spoken about the badjonism. And what they don't mention, it is Dr. Eric Williams, father of the nation. It was PNM policy to go into the PAN yards, to speak with the PAN movement to get rid of this whole badjon culture. It is the PNM that did that. It is the PNM that encouraged and brought sponsors into the PAN movement. It is the PNM that got these steel bands to organize themselves, move away from the badjonism, accept the value that you can create in the communities. Accept that is the PNM. And of course, as he declares his love for the Desperados Panyard, and as my colleague Senator Hislop indicated, it is the PNM that built the one up on top of the hill, and it is the PNM that spent $20 million to build the one down in the center of Port of Spain. Not the UNC, it's the PNM, and it is the best panyard in all of the world. Best. And it was 13 million, the first price. And then we extended it because Desperados wanted an extension, because they indicated that it would give them a little more sustainability. They could do more with the car park and so on. And we did that. We did that for Desperados, Mr. Desperados. That's right. Ungratefulness worse than witchcraft. Mr. President, you know, we talking about the UNC will bring pan manufacturing. Hey, that is a place for the private sector. What the government does, if you don't know about government policies, government incentivizes, they are facilitators, they create an enabling environment. And it is the same Minister of Trade and Industry who you like to insult, and her incentives created a whole pan manufacturer in the form of Midco, making Trinidad and Tobago proud all over. I mean, the whole, the pan case comes in a Trinidad and Tobago flag. That is government, PNM government incentives that did that. And IP. Senator Vieira, we have been doing some work in IP. But by the very nature of the work that you do in IP, it has to be secret and it has to be confidential. Because you see, in this country, there are some unpatriotic infidels. And they often wear yellow. And I don't have to call the acronym. So you can't discuss it. Because the very nature, you have to keep it secret. So let's talk about this land business now. You know, he spoke about Fuad Abu Bakr. Fuad Abu Bakr. You know, Mr. President, Fuad Abu Bakr is not even a member of a steel band. He's not even a member of the steel band, so he's not a member of Trinbago. He is not a member. The steel band he claims to be associated with Bush Tall High so. He is not a member of the steel band. You have to be a member. Trinbago is governed by a constitution. You have to be a member. And if you read the constitution and you understand the constitution, decisions are made in a particular way. But Fuad Abu Bakr told him something about the government taking away Trinbago land. Okay, let's go into that. So, Eric Williams of the PNM gave the National Steel Band Association, which is the predecessor to Trinbago, 2 acres of prime property in Sagramsingh in 1974. 2 acres of prime property, waterfront. Sagramsingh. In comes the UNC. Hustle the people out of their prime property down in Sagramsingh. In fact, I believe they're still paying the water rate, Trinbago that is, for the property down in Sagramsingh, but they hustle them out, take it back to the CDA. So I have an article in my hand written by Terry Joseph, published in the Express, 18th of November 2001. The title is PM, Government Will Build PAN Headquarters. At the handing over ceremony over a parcel of land to Trinbago, Prime Minister Basdeo Pandey stated that his government would fund the cost of constructing the organization's headquarters on the site. In his feature address, Pandey stated, "You come up with the plan for your headquarters and I will find the money to build it. The 8-acre parcel of land is located along the Churchill-Roosevelt Highway." You pass by the Churchill-Roosevelt Highway and see what was left there? That is UNC. Are you talking about mamagain people? Mamagain the pan man? That is UNC. Let us fast forward, please, because we don't have much time, to 2011. The Express by Cherise Moe. The title is Trinbago to get $7 million to finish its headquarters. This is in 2011. Around the same time, was it around? No, it was 2013 when he was calling the UNC the morass.
Correct.
2 years before. In the Express, Prime Minister Kamla Persad-Bissessar says government has allocated $7 million for the completion of Trinbago's headquarters in Trin City. Construction at the facility, Prime Minister made the announcement on Tuesday during her visit to Petrotrin Phase 2 Pangrove Panyard, Woodbrook. She also visited 4 other panyards, Whitco, Desperados, All Stars, Cal Invaders, and Exodus, where she met with spectators and took pictures and so on. This was in 2011. Senator Nakhid, did the then government, was the member for Saparia's promise ever fulfilled? Did they get $7 million to finish its headquarters? I will sit, and give you way. You'll tell me. Okay, I changed my mind. And you're sitting next to Senator Jerlene John. Jerlene John, Senator John knows all about this. Because Udicott was involved. Udicott was involved. Udicott was involved in the mama guy. Also in 2011, this was in Jayanti Communication, an article in Jayanti Communication. Also confirming that government has allocated $7 million. Well, we know government never allocated, never gave it to Pantrinbago, nothing was built. But here's what is very instructive. Pantrinbago was part of the administration, this is Prasad Bisesa saying, member for Saparia, was part of the administration that allocated the lands to Pantrinbago. These are the lands in Twin City. In our last administration, I was the Minister of Legal Affairs, and I had control of the lands registry, and I was given that blessing to give to Pantrinbago the lands for the PAN headquarters. That was more than 10 years ago. Let us fast forward to 2023, because you heard it from the Honorable Prime Minister, then Prime Minister, member for Saparia's lips, that she was the one who executed this desire to give Pantrinbago this land in Twin City. Fast forward to 2023, and I could give you a little backstory. Pantrinbago, looking to understand their status on the land, because they don't have any documents. There was a gentleman named Peter Kanhai, who was the Assistant General Secretary of Pantrinbago. They booted him out, yes, they booted him out of office, and he kept all the documents to himself, refusing to reveal or to deliver up any of the documents to Pantrinbago. So what does Pantrinbago do? They go to a law firm and say, Mr. Law Firm, can you do some searches for us? We need to understand what is our status on this land. So they go to Keystone Law, and on the 15th of March 2023, they are given an opinion. Now, Mr. President, I just told you, the member for Saparia was part of the administration, Minister of Legal Affairs, and had control of the lands registry, and was given the blessing to give Pantrinbago the land for the PAN headquarters. Here's what the opinion says. Report Untitled. A perusal of the mother's certificate of title in the name of Orange Grove National Company Limited in volume 1995, folio 253, it's RPO land, if you don't know, shows that a certificate of title for the subject parcel of land in favor of Pantrinbago, Inc., TC, was never issued by the Registrar General of Trinidad and Tobago. As such, transaction is not endorsed thereon. Go further. In fact, to date, there are 95 endorsements on the mother certificate of title showing leases from the Orange Grove National Company Limited to various parcels of the larger parcel of land at Tacarigua to several lessees. But none of these endorsements show that Pantrinbago Inc. TC is a lessee. And we know that. We know that a lot of other people have title to land in that area. They have leases. It goes on to conclude, the current position as regards the subject parcel of land, this is the land down in Twin City, is that Pantrinbago Inc. TC does not have any legal ownership of the subject parcel of land, and as such is not in a position to conduct any legal transactions or have legitimate dealings concerning same without the relative certificate of title. Rambunctious says as Rambunctious does. I didn't want to read this here, you know, but I have to correct the record. And I have to show the steel pan movement, pan people outside of there, what the UNC is and what they stand for. That is what we do. Exactly. That is what we do. And of course, we, in discussions with Pan Trinbago and having those discussions, we've decided to put a cricket academy on that. And we've discussed it with Pan Trinbago. And in those discussions, we say, Pan Trinbago, you have a piece of land here for 23, 24 odd years. You have not done anything with it. There is a monstrosity on the site. The steel, not good. People cutting out the steel and selling the steel. They're selling the steel as scrap iron. You can't manage the land. But here's what. We don't think that you should be down in Trinity down there. PAN was created in East Port of Spain, in the capital city, and therefore the world governing body, the headquarters for steel pan of the world, should be in the capital city. And where did we allocate them in exchange? On Wrightson Road, by the old post office building. If you are to do a valuation on that land, and you are to write out the value of the valuation of that land, Senator Nakhid will stumble 3 times before he could call out those digits. That is what they have done. And we will continue to develop the steel pan movement and walk side by side and promote the steel pan in Trinidad and Tobago. You're talking about pan in schools. Let me read another article, because you now come. And it seems as though your ability to look backwards is an inability. So let's go. An article in the Express, will we restore pan in schools? And it is written by a Mervyn Critchlow. I know Mervyn Critchlow. I think he was attached to the Ministry of Education at some point in time. And he goes on to say, the nucleus of a pan in the classroom unit at the Ministry of Education was developed, and specially qualified tutors hired to teach pupils the rudiments of the pan. A course in the making of pan was incorporated into the ministry's curriculum through the Caribbean vocational qualifications. The process of establishing steel orchestras in school was nevertheless pedantic, very slow. But here's what he says, Mr. President. The pan in the classroom project received a fatal blow in 2011 when it was discontinued, and the process of putting steel orchestras in the schools continued to limp along. 2011. Sound and fury, but at least know exactly what you are talking about when you come and put things on the Hansard. And while they will boast about giving PAN all this big amount of money, Mr. President, I think I glimpsed you, but maybe I didn't. Panorama semifinals 2024 was perhaps the biggest panorama in all of its history. The firemen were coming and threatening to shut down the entire thing because there were simply too many people in this smaller space. We now have to consider, do we move back the North Stand and create more spaces, create a bigger stage, put larger screens to accommodate all the people who want to come to see and to experience panorama? You talk about pan in schools and we take away pan in schools. You know what threatens Panorama semifinals as the biggest event in Carnival, the secondary schools Panorama final and the junior Panorama final. Mr. President, it is so large that you see when the primary schools finish, we have to tell all the parents, all the teachers of all the primary schools, you have to leave, or else the firemen will shut it down. It is too large, and all of these young citizens of Trinidad and Tobago come out and they cheer and they scream louder than you could ever scream, or anybody could ever scream for Desperados. That is the enthusiasm that our young people have for Steel Pan. And that, with those young people in mind, that is why we are doing this here today. So, Mr. President, I really, again, wish to thank all the senators for contributing, both houses. I thank you, notwithstanding quality, but I thank you, Senator Nakhid. I know that you are a lover of Pan. I know that you love...
From the bottom of my heart, to end with some joy on this momentous occasion.
I assure Senator Dr. Richards that I am not permanently rambunctious. I have some joy in my heart, and I was just about to embark upon that by thanking members of this House, thanking members of that House for contributing to this bill and joining with the government to make this a reality. And I was mentioning that Senator Nakhid, I know he is a lover, and I know
Minister,
he is
you
a
have
lover
5 more minutes.
of Desperados. Thank you, Mr. President. But this really is a momentous occasion. And it's a little personal touch from me. I am privileged to be the Minister with responsibility for culture at this time. And it is really not Senator Richards. It is not about me knowing all about Pan and going back into under the breadfruit tree where there was pong in the pan and the man with the hammer. It's not about me. It's not about that for me, you know. It is about understanding what our forebears have done in creating this, in understanding my short role in the history of Steel Pan as the Minister with responsibility for culture, and doing all that I can, doing all that the government could on this side, and inviting you all to join with all of Trinidad and Tobago, of doing what we can in this moment of time to advance the Steel Pan in Trinidad and Tobago, regionally and internationally. And with those few words, I thank you.
Honorable Senators, the question is that a bill entitled an act to provide for the designation of the steel pan as a national musical instrument of the Republic of Trinidad and Tobago and for related matters be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled an act to provide for the designation of the steel pan as the national musical instrument of the Republic of Trinidad and Tobago and for related matters.
Minister of Tourism, Culture and the Arts.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the National Musical Instrument Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the National Musical Instrument Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, there are 4 clauses in this bill. I have received no circulated amendments, so we will proceed accordingly. Clerk.
Clauses 1 to 4.
Honourable Senators, the question is that clauses 1 to 4 stand part of the bill. Honourable Senators, the question is that clauses 1 to 4 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stand part of the bill.
The preamble.
Honourable Senators, the question is that the preamble to the bill be approved. Those in favour say aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate.
Thank you, Mr. President. I wish to report that the National Musical Instrument Bill 2024 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on the National Musical Instrument Bill 2024. Those in favour say aye. Those against say no. I think the ayes have it. Minister of Tourism, Culture and the Arts.
Mr. President, I beg to move that a bill entitled An Act to Provide for the Designation of the Steel Pan as the National Musical Instrument of the Republic of Trinidad and Tobago and for related matters be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Designation of the Steel Pan as a National Musical Instrument of the Republic of Trinidad and Tobago and for related matters be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Provide for the Designation of the Steel Pan as the National Musical Instrument of the Republic of Trinidad and Tobago and for related matters.
Leader of Government Business.
Mr. President, I beg to move that this House do now adjourn to Friday, July 5th, 2024 at 1:30 p.m. when the government proposes to continue debate on the Miscellaneous Provisions Judicial and Legal Service Bill 2024.
Honourable Senators, the question is that this Senate do now adjourn to Friday, July the 5th, 2024 at 1:30 p.m. Those in favour say aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Friday, the 5th of July, 2024 at 1:30 p.m.